On that side. Yes. Hearing not right now. Yes. Please. Hand over.
Application first appeal.
Pardon?
Application.
Yes.
Well, I know your lordship is not taking the hearing matter, and for the respondent, well, only let it be under to be mentioned, my lord. Mr. Dheeraj Trivedi is appearing in this matter 3 times fixed before my lord Justice Mantha, my lord.
Hearing?
Hearing.
No.
3 times, my lord, fixed, my lord.
What is that?
I'm mentioning in FAT 384, it is a fresh filing. It is arising from a
Application? Yes.
Model check final opposition in this petition. Right, and it was filed, model right, rectification of time. And you will not show that.
When is the application due to appear?
19.
No, when it appears, we will condone that.
Tomorrow. Right. Both reply in opposition.
Anyway, appellate side, not necessary to extend formally. So you hand it over, yes.
The legal of justice said may have mentioned the matter. This is a content application.
Sitting singly?
Yes, ma'am.
But what we do is take up these matters on single days. I mean, when I sit single, please have it mentioned.
Your lordship, I understand, but this is sitting singly on the 20th. I was praying.
Only on Fridays.
If this matter will come up on-
That's a very good handover. Out of single day. Okay. Yeah. Yes. Next. Yes, you.
The leave of Honorable Justice and my lord, this is also a contempt matter before your lordship.
Hand over.
I'm only
Appellate side.
appellate side, lordship. There's only one problem here, lordship. This is I want leave to file because one of the contemners is a bank. So I've been told that there is some direction internally in the department where if the contemner is not by name, the officers are also named, but we are praying for certain reliefs against the bank. I've checked the law, lordship. It is permitted to have a bank as a party. In fact, there are several kind of reliefs.
You are a petitioner.
I'm the petitioner.
Filing is not being taken.
Lordship. That is why I'm seeking leave.
Bank, why you should make some official a party.
My lord, officials are also parties, but we've also made
Bank
the
cannot be a contemner.
My lord, because my lord, I checked the after knowing this. Lord,
Very well, file it. We are granting leave. Satisfy at Assad better.
Grateful.
My lord, application, 10 applications. Condemnation of leave.
To be mentioned, yes. You are wanting an inclusion of an application or hearing? You want a direction for the lower court records to come? What do you want? I mean, it will appear under what heading? Orders for directions to for the lower court records to be brought in on. Right to be mentioned at the top. Hearing we are not taking up now. Hearing matters, please ascertain what you are mentioning for. Please ascertain properly and come back. Yes. What do you want to know? What do you want now? What should you do now? Why are you mentioning?
Parties to move an application to
Let it appear as to be mentioned, give a notice to the other state. Right to be mentioned. Yes. Applications, yes.
Application.
Yes.
First. Grateful.
Ma'am, please take instruction what you are wanting.
This honorable court had already directed the lower district judge of Uttar Dinajpur
Yes.
submit a report that the lower court records are still missing.
What are we supposed to do now?
We want that the matter be heard.
Hearing we are not taking up now. Appeal hearing. Yes.
one appeal matter.
Appeal hearing? No. Yes. In person?
In person, sir.
Good.
আর্গুমেন্ট আছে এক্স পার্টি আর্গুমেন্ট স্যার প্রিপেয়ার করতে বলেছিলেন স্যার
পেপার বুক হিয়ারিং এর জন্য হিয়ারিং আমরা এখন নিচ্ছি না, ছুটির পরে মেনশন করুন। আর্গুমেন্ট স্টেজে আমরা এখন নিচ্ছি না, কারণ অনেক হেভি লিস্ট রয়েছে, আপনি ছুটির পরে মেনশন করুন। ইয়েস হোয়াট
New motion.
We don't have determination to take new motions. What is this? Please ask your the learned friend behind you. Ask the senior learned friend behind you. What is it? Of? Not sure. No, not right now.
Lordship, may I take
Thank
a
you.
leave to mention one matter? Lordship, I filed one appeal, which will appear on 18th December.
Yes.
Lordship, this is my stay application. The department will take at least 48 hours time, Lordship.
Yes, file it. It should appear along with that appeal.
Yes, Lordship.
Write the returnable date of that appeal and mention application.
Great.
এই অ্যাপ্লিকেশনটা ট্যাগ করে দেবেন ওই অ্যাপিলের সঙ্গে যবে 18 তারিখে আসবে।
Restoration application malad, it was dismissed by the.
Yes, yes, yes. আগেরটা বুঝতে পারলেন কি?
I think number 1.
Thus, there arises no question of condoning the delay as paid for hearing. Hence, can 1 of 2023 is dismissed on contest. Consequently, FAT such and can 2 are also dismissed, also stand dismissed. Due to the malafide attempt on the part of the appellant to mislead the court and for the harassment caused by the appellant to the respondent, the appellant shall pay costs of rupees 1 lakh to the respondent within December 31st, 2024. Urgent server copies if applied for be issued.
Great.
Yes. পরেরটা কল করুন।
Item number 2.
Accordingly, can 1 of 2024 is disposed of by granting stay of all further proceedings in title execution case number 7 of 1991 pending in the City Civil Court till disposal of the appeal, subject to deposit of rupees 50,000 per month as occupation charges by the appellant in the executing court from the date of passing of the impugned judgment and deemed decree in miscellaneous case number 950 of 2016, that is from September 10, 2024. The first such payment for the month of September 2024 along with the current occupation charges for the month of December 2024 shall be deposited by January 10, 2025, and thereafter the appellant shall go on depositing in the executing court the current occupation charges at the rate of 50,000 per month by the 10th day of each succeeding month. Such deposit, as and when made, shall be invested by the Registrar of the City Civil Court at Calcutta in a short-term interest-bearing account, stroke deposit within a nationalized bank, and shall be subject to the outcome of the present appeal and/or to any order passed at the time of the disposal of the appeal with regard to such deposit. In view of the short conspectus of the appeal, the trial court records need not be called for. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records, incorporating all relevant documents, and file the same on the date of hearing of the appeal. Advance copies of the paper book shall be served on the learned advocate on record for the respondent at least a week prior to the date of hearing of the appeal. Can 2 of 2024, an application under Order 1427 of the Code shall be heard along with the appeal. If in opposition thereto shall be filed by January 3rd, 2025. Affidavit in reply, if any, shall be filed by January 10th, 2025. The appeal along with Can 2 of 2024 shall be listed for hearing on January 16, 2025.
Only one thing.
Yes,
Milord,
sir.
I get to serve the paper book. Milord, 1 week before. Milord, the
1 week before the date of
Now,
hearing.
Milord, the reply would come, Milord, on 10th. Milord, the matter is fixed on 16th. Milord, this reply and all, Milord, maybe Milord are part of the paper book.
Whatever are the relevant papers, make it a part.
So, Milord, I do not get 1 week then. 16th, Milord, returnable. 10th is the date for Milord filing of reply by them.
Yes, 10th.
So, Milord, 1 week before.
Oh, we can incorporate, we can take those applications separately. Include the other documents?
Yes.
Great, thank you.
Item number 6.
এটা নিয়ে নিন Mr. Sohini Chakraborty appeal. For the
Apart from that, Malad, this is the order for 1 of year 2024. It arises from the share law code. So, Malad,
then we don't have determination.
Yes.
We are releasing for lack of determination. Since we do not have determination to take up this matter, let the matter go out of the list due to lack of determination with liberty to the parties to mention for inclusion before the appropriate.
4 of them.
4 also 4 also same.
Yes, ma'am.
Very well. 4 same order. Separate order, same order. Thank you. Thank you. Sir.
Item number 5.
Item number 5, my lord, I am for the appellant led by Mr.
Yeah.
Parthaputim Rai.
Yes.
My lord,
Why is it appearing as to be mentioned, Mr.?
my lord, what is happening? Your lordship was held that
That no,
but my lord, there is an injunction application also. So the exit, my lord, and the
no, we do have the jurisdiction.
yes, my lord, yes, my lord, that was why, my lord.
Show us the Bengal Agra Assam Civil Court, sir.
Well,
Relevant portion.
Well, I am led by Mr. Parthaputim Rai. He paid for my short password, my lord.
To be mentioned, why aren't you prepared, Mr. Bhattacharya?
Your, my lord, the other side was I was informed with regard to the other side. My lord,
What other side?
Mr. My lord,
What about the other side? You are to satisfy us that we have the jurisdiction.
because my lord, your lordship, your lordship was held that there is a
On the prayer of the appellant, let the matter stand adjourned for the day. Come back tomorrow. But Mr. Bhattacharya, if you are not prepared tomorrow, we'll retain our order and make it out of the list. You are for the other side in this matter.
Oh, yeah.
Next.
Item number 6 and 7.
This matter has come up at my instance. I this one 81. My lord, only a humble prayer you have to regarding order. My lord, can indicate that the learned trial judge is not there, my lord, at present. My lord, only the charge code may be added.
Your Lordship, I am
That is the-
opposing.
Opposing.
Your Lordship, two points
Directed a time limit.
Your
Lordship
Lordship, yes.
directed within 30 days
Your
to
Lordship.
dispose of an order application under Order 39 Rule 4 and the main injunction application.
Your Lordship, I have twofold points.
My
By
lord,
which order? Dated?
10th December 2024.
Yes.
What
Lordship, I have twofold
We
submission.
will hear you. Yes. Yes, you want to say something?
I mentioned this on the my lord because the second my lord my lord's second court my lord senior division Asansol my lord he is not available since September.
He's saying the same thing.
No, same
So
thing.
yes, let us
I'm
hear.
for the respondent number 37 and he's for 21.
21.
Your
Right.
Lordship, the learned judge had taken leave for some minor operation. His operation has taken place. Now he will resume office on any day. Your Lordship, in this order, Your Lordship had given direction for affidavits, which will take 15 days time from 10th, Your Lordship. That comes to 24th.
You
and
have
Your
personal information that the judge will resume
Your
soon.
Lordship, we've inquired from the court below, and Your Lordship, the interim order in my favor is only till 15 January. So, Your Lordship, this matter can be mentioned on reopening of the court. If the learned judge is not sitting, Your Lordship, I will also support their prayer. But this is premature because the pleadings, Your Lordship, will see at page 3, page 4, Your Lordship had directed.
Let us wish good health to the judge.
Yes,
We'll
yes.
keep it on the
We
reopening.
have information.
We'll keep it on the reopening day.
I'm grateful, Your Lordship.
If it can be carried out in the meeting, if it comes back, please.
2024.
Yes, Your Lordship.
I find that still my name is appearing for the appellant.
Your-
And
In
that
the
is
order,
why I
Your
served
Lordship,
my
our name has not gone. The erstwhile advocate's name is there. I will,
Please order put in your name.
yes, I'm grateful, Your Lordship.
Thank you. Learned counsel for the respondent numbers 21 and 37 submit that the learned trial judge who was requested to dispose of the appeals within a limited period is at present indisposed and not in office. Whosoever as such, it is prayed that the judge in charge be asked to complete the to comply with the order of this court. Whosoever learned counsel for the appellant submits that the regular judge is due to resume his services soon. Whosoever accordingly let the matter stand over till the reopening date when it will. Acha, very well. Let the matter stand adjourned till January 7, 2025 for passing further orders if necessary.
Grateful, Your
My
Lordship.
lord, lordship's order was of 10th of this month. So 30 days, my lord, is on.
No, you can
10th of the
file
next
the
month.
affidavit, sir.
We are filing, but the matter will not
Your
be
Lordship,
heard in the
50
meantime.
7
That's the
days, 7
difficulty.
days. That comes to 24th. Your Lordship, vacation will.
The last date of filing the opposition and reply ends at
15
24th. 24th.
Yes.
So then it start. He has to take it up on the reopening date then, not before
But
that.
7th, my lord, takes up my lord, closer to 10th of January.
Achha, very well. Then we'll keep it on 2nd January, first
My
day.
lord.
ওটা জানুয়ারি 2nd করে দাও। জানুয়ারি 2nd যদি ছুটির আগে না রিজিউম করো ওই অর্ডারটা wait. If the judge does not resume with before vacation, this side of the vacation will pass that over. Right. Eight.
Item 8, my lord, I am attending for the appellant, my lord. Pursuant to lordship directions, but this is a written undertaking, my lord, which I
Yes.
will.
Have you given a copy to the other side?
I have not, my lord, but they are not. yet.
Lordship, I am appearing
Yes,
for
please.
the
Have you got a copy of the undertaking they are filing?
Lordship, no, Lordship, no copy has been served to my advocate of record,
Office,
Lordship.
there is no any office for the staff. That's why
No
my lord,
office?
I'm ready, my lord.
No office of the learned advocate.
And that is the-
My lord, my instructing solicitor
My
is
clerk
Victor
was sent.
Moses and
My
Company.
clerk was sent to
Their
this, my lord,
office is-
one was present with notice.
The
Since no
firm
copy
has
of the
been-
undertaking, since no copy of the undertaking sought to be filed before us has been served on the respondent, comma,
Adjourn for the
the
day.
learned advocate for the appellant is directed to serve the same during the course of the day. Full stop, the matter shall be listed tomorrow under the same heading.
I am deeply obliged, my lord.
Please have a talk with your learned counterpart and ask where to serve it. Yes,
I am deeply obliged, my lord.
thank you. Yes.
My lord, in this matter, Mr. Shravani Chakraborty is appearing on behalf of the appellant. My lord.
Since one of us, no, since the relatives of one of us within bracket Bhattacharya Ji is appearing for one of the parties, let the matter stand released from our list on personal ground with liberty to the parties to seek an assignment before a different bench.
I'm grateful. Your Lord.
আপনি না থাকলে তো এক হবে। Lordship, কি আছে report?
Three defects are there, but they have been cured.
All have been cured.
Yes.
One is deficit code for Appropriate 10, cured. Application for condonation of delay section 5 has been filed.
For 39 days.
That has not been allowed yet. That application is pending. Section
Pending. And section 5 pending.
Point number 3, what is that? Has been removed already. Yes, that's the report. We find from the report of the assistant registrar within bracket SR section that the defects have been cured in the meantime by the appellant, full stop. Accordingly, let CAN 2 of 2024, comma, the application under section 5 of the Limitation Act connected with the appeal, comma, be listed on December 23, 2024.
And stay application also can one.
আচ্ছা ওই যেটা বললাম along with the connected applications ওই যা যা অ্যাপ্লিকেশন আছে 23 তারিখ দিয়ে দেবেন
In the meantime, you serve.
না না ডিরেকশন না দিলে হবে ডিরেকশন না দিলে আগে তো লিস্টে আজকে নেই তো সার্ভিসে ডিরেকশন দিতে পারে রজিমান
My lord, this is my application, but I think that my lord has no determination to hear out this application because my lord, application for substitution, my lord, that has been done within time. Therefore, I rather go to the registrar lodge.
that's a technical we can
My lord, I have no problem.
whatever power the register has we have
No, I have no problem. But this is in connection with the second appeal, my lord. Second appeal application.
substitution it has not been admitted under order 41
No, my lord, it has not been admitted.
we will allow it and take up the order 41 hearing
But I have no problem, my lord.
you are ready with the order 41
Order 41, I am not ready, my lord, because you also can give fix some other-
injunction we will take up only after order 41 if you admit
Well-
substitution within time we are allowing
Yes, my lord, I have no problem, my lord.
No copy has been served.
please have a copy
Let them survey.
My lord, they have, my lord, they
Your
have, my lord, according to
lordship
their later.
apply here and now. Your lordships allow the application for substitution here and now.
and put the matter under order 41
Yes.
we'll do that
My lord, the next week, your lordship, my lord.
very well
Because it's an old matter, my lord, your lordship.
CAN 8433 of 2012 is an application for substitution of the heirs and legal representatives of respondent number 1
No,
after setting aside admit
one has already been substituted.
so that is the
Before
application
respondent has been already substituted. It's substituted respondent.
Can
Out of
three,
three
my lord, your lordship,
substituted
can consider
respondent,
can-
this is not CAN 8433 this is some other
can three, my lord.
CAN 1 this is CAN 3
Yes, my lord.
yes, my lord.
so CAN 1 is that
But can I one is stay, my lord? Can two is application for substitution, my lord, of the
Sole
respondent. number
respondent.
one, sole
Full
respondent.
respondent.
My lord, after
there's so many cans
three can.
Three cans, my lord.
which do we have to allow
Now third one.
CAN 3 that is CAN 3
Yes.
CAN 3 বার করে দিন
At present,
Can one is.
Third one is before your lordship.
Can three
Can two has been allowed by this court.
Can three? Allowed.
Can two has been allowed.
Can two allowed.
Sorry, can two has been
We have to now allow can three.
Can three?
Can three.
Give a copy right now. You give your copy. You give your copy.
It has been endorsed, madam. Some marking is there.
Any points of law has been. Give it to Mr. Ghoshal if you don't get him. Fair. There is no second judge's copy. No second judge's copy.
I think that was meant for learned
Single
registrar, so
registrar, yeah.
there's no second judge's copy.
Ah, he goes. Thank you. Can can 3 of 2022 is an application for substitution of the heirs and legal representatives of Khokon Chandra, one of the substituted respondents. Push up next para. Since the application is otherwise in form and in time, can 3 of 2022 is allowed, thereby directing substitution of the names of the heirs and legal representatives of respondent number 1 within bracket small b late Khokon Chandra, as specified in paragraph number 5 of the application. Pushed up next para. The learned advocate on record for the appellant shall carry out the necessary amendments to the memorandum of the appeal accordingly during the course of the day. He's not the advocate?
Yes, madam.
During the course of the day. Pushed up next para. Let the appeal be listed for hearing on December 23, 2024. Appeal be listed for hearing under Order 41 Rule 11 of the Code of Civil Procedure on December 23, 2024.
Instead of 23 any day. I have some difficulty.
19th we are keeping it. Thursday. Come to. On December 19, 2024, along with the other connected pending applications. Yes, next. 19, 20 difficult. 20 single. Come back on 19. Yes.
I'm appealing for the appellant.
Many
applications have.
Many applications, James. A list of that.
That then it will be easier for the lordship.
This is one copy only.
This is
This also we have to read.
just 1 minute. No, the lordship.
So order 41, it has not been admitted or not? Not been admitted. So Mr. Shah, which application section 5 you have to take up now? Substitution we have to take up now.
Except 3, all other applications can be taken up.
Taken up. So which one is to be
3
taken
will
up?
not be taken up.
What are the amendment application?
One of the opposite party has expired. In the application, his name is there.
Give us a second.
দেখেন ক্যান 4 এর মতো আরো আছে সাবস্টিটিউশনও আছে Yes, Mr. Shah, this amendment of cost title is on the death of somebody. Death of somebody, heirs are already on record.
That was substituted.
Already substituted, the name has not been deleted. And that is can 5.
Can 5 is.
Can 9 is that application for amendment of cost title. And can 10 also amendment?
Amendment.
Similar amendment.
Similar.
Can 9 and 10 are similar? Already substituted but not amended in the
9, 10, 12, 11. All are similar.
In all cases, substitution has been allowed, but
substitution of opposite party number has been allowed.
Allowed by this code?
Yes, and by mistake, we
did not.
The application, the old man's name is there.
Very
that is why amendment. Opposite party number 1 or 4.
So then, can 9, can 10?
You'll also think first can 4.
11 and 12.
Can 4 first, you'll also can take.
Yes.
Can 4, this application for respondent number 1.
This is within time application?
This is within
substitution
time.
Within time.
Within time.
Very
and
well.
By mistake in all other applications, this name is there.
Acha. What is section 5 is relating to the main appeal?
Restoration application. During the COVID period, it was dismissed.
Acha, very good.
6 is the COVID period, it was dismissed. Section 5 is the application for condonation.
Can 4 is not 106.
Can 4, this is application for substitution of respondent number 1 within time.
No, 1065 with the renumberings have been mentioned wrongly in your list. You say can 4 of 2013 is substitution application. Old number is can 10658 of 2013. But it appears from the application itself that
Can 4, possibly old number means 1245.
Not 10658.
No, injunction application.
হ্যাঁ এটা দুবার হয়ে গেছে এটা দুবার দিয়ে ফেলেছে ইনজাংশনে ওটা ঠিকই আছে 1245 so can 4 we have to allow first can 4 then the amendment applications because those have already been done after that the restoration application then we take up the section 5
Restoration
after that
application before that 5. Unless you
restoration first
restoration, if you also condone the delay for in filing restoration, then you will also can allow.
or 5 is for restoration.
Yes.
So restoration was ex parte. I mean, none of you were there. The other side was also
During
not.
COVID period, it was dismissed.
You have served also. But even if you have not served, Order 9 Rule 4 principles applies.
But it is also.
Well, let us do, start doing it. Acha. Can 4 of 2013,
18.
you have written 13?
This is type, this is 18. That should be 18.
Can 4 of 20 just here along with us if we make a mistake or there is a mistake? Can 4 of 2018 is an application for substitution of the original respondent number 1, late Bodri Narayan Odhikari. First up, since the application is in form and otherwise in time, comma, can 4 of 2018 is allowed, comma, thereby directing the heirs and legal representatives of the original respondent number 1, comma, since deceased, comma, to be substituted in place and stead of the said deceased. First up, next para. Can 9 of 2024, comma, can 10 of 2024, can 11 of 2024 and can 12 of 2023 are all applications for amendment of the cause title of the memorandum of appeal and the connected applications in view of the relevant substitutions having already taken place, but the names of the deceased having not been scored through in the cause title. Full stop. Accordingly, comma, in view of the innocuous nature of the prayer, comma, we allow all the above applications, comma, thereby granting leave to the learned advocate on record for the appellant to carry out the necessary amendments to the cause title of the memorandum of appeal and the connected applications, comma, if necessary, comma, in consonance with the prayer made in the applications during the course of the day. Next, we take up that section 5 along with the restoration, 5 and 6. Restoration, what is the delay?
The delay for 2 years because during COVID period it was done.
Entire period is COVID period.
Yes. When?
From when to when?
It was died on dismissed in 2020. And my lord, when we filed the application.
When? 2020 when? Let us find that application first.
December 10, 2020.
You have annexed the order of dismissal? No.
December 10, 2020 মানে
December 10, 2020 তে হয়েছে।
হয়েছে মানে হচ্ছে ফুল ফেজড কোভিড এর মধ্যে। After that also COVID period.
This can 8 when the client came us to know, inform the date of this can 8, then we discovered all these things.
Can 5 of 2023 is an application for condonation of delay in filing the restoration application bearing can 6 of 2023. Full stop. A substantial portion of the delay was occasioned during the pandemic period, since the appeal was dismissed for default on December 10, 2020, whereas the application has been filed on December 22, 2023. After the end of the pandemic period, there was a communication gap between the learned advocate for the appellant and the conducting persons of the appellant, in view of the said conducting persons being laymen and unaware of the law of substitution. Upon considering the circumstances made out in the application for condonation of delay, we are satisfied that sufficient explanation for the delay has been given. Accordingly, can 5 of 2023 is allowed, thereby condoning the delay in filing can 6 of 2023. Upon perusal of can 6 of 2023, we find that the explanation given for the absence of the appellant on the relevant date is sufficient. Accordingly, can 6 of 2023 is allowed, thereby restoring SA 186 of 2013 to its original file and number. Now, what remains?
Can 7 is recording death of appellant number 1.
Heirs are on record.
Yes.
And can 8?
Can 8 I am submitting letter.
Can 8 we have passed an order?
No. Can 8 your lordship not?
Acha, very. Can 7 of 2023 is an application for recording the death of Ila Devnath, Ila Devnath is a party here.
Yes.
Respondent number?
Substituted. A.
Substituted number 1, 1A.
A, B, C, D, A. Small a.
Oh, A. Acha. Application filed for কি বললাম? Is an application filed for recording the death of Ila Devnath. The substituted appellant number small a within bracket, the wife of the Shebite of the appellant deity, DEI. Next para. Since the heirs and legal representatives of the said Ila Devnath are on record, can 7 of 2023 is allowed, thereby directing the name of Ila Devnath to be expunged from the cause title of the memorandum of appeal. The necessary consequential amendment to that effect shall also be carried out by the learned advocate for the appellant during the course of the day. Substitute recording date. Name to strike out. Substitute বললাম এটা সাবস্টিটিউট বললাম হ্যাঁ সাবস্টিটিউটেড হ্যাপেন ঠিক বলছেন সাবস্টিটিউটেড কথাটা ঠিক আচ্ছা then what remains?
So there are 4 appellants. Now after substitution this B has expired and that was not made within time because there has not come
the composite application for substitution on setting a set after setting
because according to us this is no abatement because the DT is the plaintiff. The 4 are representing the DT. On the date of anyone, it is not abated.
So his heirs are not on record.
No, not on record. But
it will be the principle of order 22 rule 10 will apply then. No other provision.
No other provision.
The persons who have stepped into the shoes have to come in.
Or appellant is DT.
Yes, order 22 rule 9 does not apply.
Not 9 does not apply. It does not abate.
Very well. Can 8 of 2023 is an application for substitution on the death of appellant within bracket small b Dilip Odhikari on November 11, 2022. Push up next para. We find from the conspectus of the appeal that the appellant is a deity and the deceased appellant small b is one of its Shebites. এটা বলছে কিন্তু এটা প্রিন্সিপালটা অ্যাপ্লাই করবে না তার কারণ হচ্ছে
করছে
রিপ্রেজেন্ট করছে স্টেট
simply নামটা struck out
নামটা স্টাক আউট নাম এরাও ঢুকবে কিন্তু অর্ডার 2210 এর প্রিন্সিপালে ঢুকবে
principle
এখানে যেহেতু ওরা
devolution of interest.
রিভলিউশন কোনখানটা ছাড়লাম
This is definitely.
sentence শেষ করুন next fact we find from the conspectus of the appeal na conspectus দিন হ্যাঁ it appears that the principle of order 22 rule 4 and 9 are not strictly applicable to the present case comma since the estate of the deity is represented by itself comma through its other surviving heirs who are already on record full stop next para hence comma applying the principle of order 22 rule 10 of the code of civil procedure comma can 8 of 2023 is allowed comma thereby directing the heirs and legal representatives of the Shebites of one of the Shebites of the deceased Shebite Dilip Odhikari to be brought on record in place and stead of the said deceased. Full stop. The said heirs, comma, shall be impleaded in terms of impleaded as stated in paragraph 1 of the application. Full stop. The necessary consequential current amendments to that extent shall also be carried out by the learned advocate on record for the appellant during the course of the day. So your learned junior will spend the entire day doing these things. But he has to be careful that
Lord, he's
no, do this and let deal.
here and now.
Here and now. No. You have to complete this and go.
Here and now.
Here and now.
আমি একটা কপিতে করে দিচ্ছি
What else remains?
Now, after order for 21,
Order for 10. So should you take up the order for 21 tomorrow or you are
ready.
then you can take up. You can take up right now.
Yes.
But please carry out the corrections.
That I will check it.
Yes, Mr. Shah, you personally check.
I will take care. ওখানে এইটা দাও যে রিমান্ড অর্ডার এইটার দুটো কপি দাও রিমান্ড অর্ডার দুটো কপি দাও
আপনাদের সেকেন্ড জেন্স কপি আছে তো বাহ
Your Lordship, can you bear me for 2 minutes or 1 minute? I'm telling. 3 names I'm telling.
Yes.
এই দুটো করে কপি দেবে রাজুবালা was the original owner.
Mr. Shah, first tell us whether this is affirmance or
Affirmance.
Rajubala
was the owner. Rajubala executed a deed
yes
in 1937 in favor of one of her daughter, Radharani.
Deed of sale. Yes.
Now, thereafter, Rajubala filed a suit against Radharani, saying that this is a sham transaction, benefit not acted upon, that was decreed in 1951.
So sale deed goes.
Then Radharani's husband is Rotikanto. Rotikanto filed a suit in 1972, claiming that he is the owner, he purchased it in the benami of his wife Radharani.
But if the sale deed went, then how can Rotikanto?
That was filed. And that also decreed expiry.
Obviously. When?
There is a checkered history. Their suit is dismissed. Against that dismissal order, they filed an appeal. Appeal court remanded it. After remand, suit decreed.
When was that last degree?
Now,
when was the last degree?
This is the last degree of
date will do.
The date is
Mr. Shah, since you are submitting, we are confident that the facts will be all right. But you have to be sure by yourself and give us the dates properly.
This is 10th August 1987, a final degree of the trial court. And remand order is 12th May 1980.
All right. Then last degree.
I filed a suit against for declaration of title and
you are who? Who are you?
I am the heirs of Sebai. He executed Orpon Nama. Rajubala executed Orpon Nama.
Rajubala was the original owner. So how do the Shevites come in?
Rajubala executed an Orponnama in 66.
Not sell it.
No, sale deed in favor of Radharani in 1937.
এবার 60
Rajubala executed a sell deed in favor of his daughter Radharani.
এই সেলডিটের গল্পটা পুরো উড়ে গেল যখন লাস্ট রতিকান্তরটা গেল।
Ratikanta.
ইন্ডিপেন্ডেন্টলি 1966 এসবের গল্পের মাঝে
And by virtue of that Orponnama, it was settled to the DT where the Shevites, we filed a suit for declaration of title and injunction. And that suit,
What is your name? Oh, you are the Radha Govind. You are, yes, right.
That suit is dismissed by both the courts on the ground of res judicata.
Suit for declaration.
Declaration of title and injunction. And that was dismissed by both the courts on the ground of res judicata.
That is the present appeal.
Yes.
Why res judicata? What is
Because
the
in 72 suit decreed ex parte. 72 suit.
But
In 1972.
but if the last suit was decreed ex parte, then the title reverts back to Rajubala. The sale
decreed
deeds
ex
go.
parte, this is Rotikanto. Title goes to Rotikanto.
Why Rotikanto? You said Rajubala was the initial owner. Executed sale deed in favor of Radharani. Radharani's deed was decreed. It was decreed against Radharani. So set aside. Deed set aside. Subsequently, Rotikanto claimed that Radharani's purchase was in his benami. I mean, her benami.
That suit,
Rotikanto should also goes.
no, that suit initially dismissed, then appeal, remand,
Remand.
then
Then
decree,
ex parte degree.
ex parte decree.
Oh, ultimately decreed in
Decreed
favor
ex
of
parte.
Rotikanto. In 87. So the moment it is decreed in favor of Rotikanto, it goes back to Radharani's transfer in 1937. So therefore, you don't have any right. Radharani did not have any right.
Who executed the Orponnama?
Rajubala,
Rajubala.
what is your
Now, question
Right.
is res judicata or not? This is the simple question. Trial courts, our suit.
you are
has
claiming through Radharani, Rajubala?
been- I'm sorry. Court saying the degree was ex parte,
So
that degree is binding. Now I will show your lordship the remand order and the decree. Now your lordship can see
can
the
we
decree.
reopen the decree now? It has become
Can you
absolute.
see the decree? I have seen the decree.
Degree means ex parte degree.
Ex parte decree.
After remand.
After remand.
Yes, Rotikanto's decree.
Here your lordship when you come to page 3 of the decree. Issues are 8 issues.
Hmm.
Your lordship has found 8 issues.
8 issues.
First, decision with reason. Issue number 1, 2, 3, 6, and 7. These issues have already been decided in appeal. If it is decided in appeal, I have no case.
But you are challenging, reopening, asking us to reopen
Well,
this decree.
This is not decided in appeal. I'm telling, I'm coming. If it is decided in appeal, then that is
Even if it was
decided.
not decided in appeal,
Then-
this decree, then this decree is illegal,
There-
unlawful, erroneous in law.
If
We
there is
cannot
no
reopen.
decision, then question of res judicata does not come.
We cannot reopen. It
No.
has been found that it has become res judicata. That decree has become absolute. This decree has
On the
become
ground, if it is decided, if the title is decided, then it is res judicata. If the title is not decided, can it be res judicata?
Can we question that now? This
No.
decree has attained finality.
This decree,
Even if it was not res judicata, Mr. Shah, it has been held to be res judicata by a competent civil court. That decree has attained finality.
if the title of Rotikanto is declared here by these issues, then it is res judicata. If the title of Rotikanto does not decide in this suit,
We have gone one step further, Mr. Shah. Even if it was, we accept your submission, it was not res judicata, it was erroneously held by this court to be res judicata. We go that far. You are right. Not res judicata, but held erroneously res judicata. This is a competent court's degree. Attained finality, Mr. Shah, you know the answer.
it was finally decided by the court.
We cannot reopen that meaning, even if it was not finally decided, but held erroneously by a subsequent court to have been res judicata, finally decided. If that subsequent judgment has not been challenged, we cannot have a relook into this judgment. So this says that it was res judicata. This is attained finality.
No, this
We
says-
cannot reopen this. We are not hearing an appeal against this.
That's true.
Mr. Shah, no.
Logically, court has not in this judgment said that Rotikanto has title.
It says that these issues have been decided in favor of
That
the.
was not decided.
We are going back to the square one. No, no
It is
interference.
not decided.
Yes.
What is res judicata? The matter is finally decided by a court.
I think we have opened our mind sufficiently. We cannot go on repeating.
I am.
No, you have to stop here.
If it is not decided by any court, question of res judicata does not arise.
Right.
If also looks res judicata,
It is
which is finally decided by court. If it is not finally decided by any court,
we'll record that question and turn it down. The brief question which has fallen for consideration in this second appeal is required to be elaborated by the brief history of the case. Full stop. Next para. One Rajubala was the admitted original owner of the property and executed a sale deed in favor of her daughter Radharani in the year 1937. Stop. Next para. Rajubala subsequently filed a suit challenging the said sale deed on several grounds, comma, which suit was decreed in the year 1951, comma, thereby holding that the sale deed was not binding on Rajubala. Full stop. Next para. Subsequently, one Rotikanto, comma, the husband of Radharani, comma, instituted another suit in the year 1972, claiming that the purchase in favor of Radharani was in the benami of Radharani, whereas Rotikanto was the actual owner. Full stop. Next para. The said suit of Rotikanto was dismissed initially, and thereafter an appeal was preferred. Full stop. The appellate court remanded the matter by a judgment and order dated May 12, 1980. Full stop. Next para. Upon remand, comma, Rotikanto's suit was decreed on August 10, 1987. Full stop. Next para. In the meantime, in 1966, comma, Rajubala had executed an Orponnama, comma, vesting the property in favor of the appellant DT. Full stop. Next para. Learned counsel appearing for the appellant submits that both the courts in the present case, comma, the trial court as well as the first appellate court, comma, proceeded on the premise that the present suit at the behest of the appellant was barred by res judicata, comma, since it had already been decided in the suit of Rotikanto, that is title suit number 361 of 1972, comma, that Rotikanto was the owner of the property. Full stop. If Rotikanto was the owner of the property by dint of the purchase of 1937, comma, it is obvious that in 1966, comma, Rajubala, comma, the vendor, comma, did not have any title with her in order to transfer the same by way of the Orponnama in favor of the DT. Full stop. Next para. Learned counsel for the appellant lays thrust on the argument that in the judgment and decree of Rotikanto's suit, that is title suit number 361 of 1972, comma, the trial court proceeded on the basis that the issue as to title of Rotikanto had finally been decided by the appellate court while remanding the matter. Full stop. While proceeding on such premise, comma, it was held by the trial court that the said that Rotikanto was the owner of the property and declared the suit on contest. Full stop. Next para. It is contended that the trial court erred in holding that the issue of title had already been decided by the appellate court while remanding the matter, whereas in reality, comma, the appeal court had not done so and had sent the matter back on open remand, comma, leaving it open for the trial court to decide all issues. Full stop. In views of such palpable illegality in the judgment and ex parte decree passed in Rotikanto's suit, comma, it is argued that the matter was never, the title in the property was never decided, and as such, comma, the questions sought to be reopened in the present suit by the DT is not barred by res judicata. Full stop. Next para. We find that the question as to whether the judgment and ex parte decree passed in title suit number 361 of 1972 in favor of Rothikanto was erroneous in law, inasmuch as the question held to have been decided by the appellate court were not so done, we cannot reopen such issues, since the said ex parte decree itself passed in title suit number 361 of 1972, having admittedly not been challenged, has attained finality long back. Thus, it is not for this court or for that matter the trial court in a subsequent suit, to reopen the issues which has been conclusively decided by a competent civil court long back. Hence, it is not for this court or for that matter the trial court in the present suit, to reopen the judgment and decree passed in title suit number 361 of 1972 on merits. In such view of the matter, we do not find any illegality, let alone any substantial question of law being involved, in the concurrent findings of the trial court as well as the appellate court in the present matter. Hence, in view of no substantial question of law being involved, SA 186 of 2013 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can 3 of 2013 within bracket old 10658 of 2013 bracket closed is consequentially dismissed as well. No orders to cost. মানে আপনি আমি আজ মান্থার অজয় গুপ্ত
Before.
Yes.
I'm for the appellate.
You're for?
The appellate board.
Yes.
But blood application, I think that it is not here.
Okay.
And I have not filed. They have.
Your application? Can't hear you.
But I have of the mentioning of court number 31 matter, my lord. Shall I come at 150, my lord? Before
No, that application is not there in any.
No, this is 13. He is mentioning other.
Oh, acha. No, we'll take up mentioning immediately after this matter because you did not have time before this. We also didn't know.
And for the
The application is not here. Where did you file the application? Which court? Application was filed for which court?
And you have not served also.
Kindly see the affidavit of service with the previous.
No, the application has to be brought at a affidavit of service. Ferat diye din. Application has to be brought first. You have to give the whereabouts of the application to my officer. Otherwise, it cannot be brought. We find that the application is not on the records. The learned advocate appearing for the petitioner in the said application is requested to furnish the particulars of filing of the application. Let the application be tagged along with the main file and be listed on December 23, 2024. Please give the particulars. Eta aniye neben, bujlen? Eta aniye neben. এখন কিছু In favor of the. You can wait for a day and place that before Justice Mandal. Do that. When the file comes and we ultimately take up them, instead of that, don't create complications for yourself. Mention it before Justice Mandal.
I'm sorry, my lord, item number 12, I am appearing on behalf of the Bhatpara municipality.
We are also sorry. We have done whatever we did. Next. Yes. Diffused. Move the matter. Why?
Priyanka Rama, he has not come today. She has not come.
Who?
Due to illness knowledge.
Who?
Priyanka Das, appellant.
You are not in the matter. On the prayer of the appellant, the matter is adjourned for the day. Adjourned for the day. Thank you. Please give your name.
Milan Kumar Maitri.
Write it on a piece of paper. Looks good.
Item number 15.
Yes. Yes.
It's my application, my lord, for expansion. And while I filed this application, my lord, which is 3537 of 2019, my lord, I did not mention that they are sui juris and, my lord, they are, my lord, major. So, my lord, by way of filing supplementary affidavit, my lord, I have stated. So, my lord, I just beseech your lordship, my lord, the name.
What is the can? 15. This is 15.
My lord, I don't know, 15. Yes.
Yes. Can 2.
Yes, can 2 of 2019, which is my old number is can 3537 of 29.
Respondent number you have left blank. Which respondent has died? In your application, respondent number is blank. On the date of respondent number blank.
That would be
Swarna Prabha Nandi was.
Yes, ma'am.
She was respondent 1A.
Yes, madam.
Her years are already on record.
Yes, madam. B2.
Supplementary affidavit you have filed.
Yes, madam.
You are filing.
Yes. Because I could not file the supplementary affidavit on the.
He's for the other side. You are for the other side.
Yes.
Have you given a copy to her?
Yes.
Supplementary affidavit?
Yes.
I'm for the respondent led by Mr. Sudeep Ghosh Chaudhary. Paper book has been ready. Let the matter be fixed.
That will come immediately after we decide the application. You retain that prayer. Supplementary affidavit filed to be kept on record. Stop. We find from the application bearing can 2 of 2019 bracket old can 3537 of 2019 that the same has been made for expunction of the name of respondent number 1 small a within bracket late Swarna Prabha Nandi on her demise, comma, since her heirs and legal representatives are already on record. Full stop. Next para. We are satisfied from the averments made in the supplementary affidavit that the application is in form and the heirs are heirs of the late respondent number 1 small a are all major and sui juris, and that the deceased died intestate. Full stop. Accordingly, can 2 of 2020 of 2019 within bracket old can 3537 of 2019 bracket close is allowed, comma, thereby directing that the name of late Swarnaprabha Nandi, comma, the respondent number 1 small a be struck out and expunged from the records. Full stop. Necessary consequential amendment to the memorandum of appeal and pending applications, if any, shall be carried out by the learned advocate on record for the appellant during the course of the day, Mr. Rai. During the course of the day. Stop. Yes, the appeal has been admitted under Order 41 Rule 11. What is the stage? She is saying that the paper books have not been prepared.
No, it is prepared. It is filed before the honorable court.
Yes, what were you saying?
Paper book has been ready. Let the matter be fixed under heading hearing.
This is also my prayer.
What is the appeal against?
My lord, this is against, my lord, an order of remand in an eviction suit.
Remand will take time.
I'm the landlord, my lord.
I am the tenant.
We will come back after the vacation. We'll put it after the vacation for hearing. Let the appeal. Now, since the appeal is otherwise ready for hearing, comma, as submitted by learned counsel for both sides, comma, let the appeal be listed for hearing in the monthly list of January 2025.
I shall lodge. Great.
16, I beg to appear on behalf of the appellant.
In this matter,
Can
Lordship,
number 2 was not traceable. We
কোনো ক্যান তো
communicated.
নেই এতে অ্যাপ্লিকেশন হেডিং
We communicated the order passed by your lordship to the
এটা
learned
হলো?
register administration, and we have been verbally informed, my lord, that it has been traced out.
লিস্টে ক্যান নেই তো লিস্টে কোনো ক্যান ছাপেননি কি করে শুনানি করবো কি করে লিস্টে ম্যাটার না থাকলে হয় অর্ডার পাস করে to the application.
I'm giving it one because
No, he has to find from his own file. Yes, find from your file. Repair application.
application for renovation, Lordship.
Yes.
Yes, there is.
You have gone through it in the chamber.
Yes, Lordship.
What is your objection to it?
Objection, Lordship.
Very good. We will hear your objection. Yes, Mr. Mukherjee, what is the appeal against?
appeal against preliminary degree in a partition suit.
Achha, what sort of repair? Let us see the schedule you have given.
Yes, you. Will not kindly pick up the pen to come to paragraph 4.
Whitewash coloring. Out.
Inside plastering, outside portion of the veranda room also will be.
না ground floor roof টা দেখতে হবে
That photograph.
আচ্ছা Mr. Mukherjee, we have some questions regarding A and F because A says ground floor roof is to be reconstructed since the same has already fallen down.
It can fall down.
It's a concrete thing.
Yes.
Don't you require permission from the corporation or municipality?
Lord, it is municipality.
Municipality. You require permission for that.
Yes.
Got the permission?
Unless you get the permission, how can you permit it? And what about outside doors are to be replaced?
Outside doors are those.
No permission is required.
No, for that no permission is required. But as my lord has rightly pointed out, as regards roof, I should take a.
Because it is a reconstruction.
How soon can you get that permission? It depends on that. We can allow it subject to your getting permission in accordance with law. I will grant you a time.
8 weeks time.
8 weeks time, very well. And what is your objection now?
Lordship, actually,
Milord, the dispute is. Milord, the dispute is over. If I am not wrong, 80 square feet or something like that. Actually, I have to be candid before your lordship. We are in possession of that more than 80 square feet of the allotted portion.
That will be taken care in the.
We have.
But we'll make it clear. Even if you grant it, we'll make it clear the usual things.
Yes.
That own cost, no equities will be created, so that you don't get an undue advantage in the final degree.
I'm grateful.
Lordship, renovation application point number 3.
Yes.
They are mentioned that suit property was for the living purpose, Lordship, but that is not for living purpose. They are currently.
They say they cannot live because it's dilapidated.
Yes, Lordship, and actually, Lordship, they are started a small business of poultry farm, and that is in our portion.
We'll record your objection, but that will be the subject matter of the main suit, the final degree proceedings. And we are not granting any other order. Only this repair, this will be subject to, this will be without creating any equities in their favor, which means that they cannot claim any right on the basis of this repair.
Lordship, then that will be repaired.
Them at their own cost and without
parties.
Why both parties? They will repair it at their own cost, but they won't claim any equity.
No, Lordship. Actually, our portion we will repair at our cost. And
your portion has not been demarcated before there is a demarcation. There is a partition. Entire thing is joined. Let them do the repair work, and if you have any objection, you come up. Because we'll direct that the status quo the nature and character of the property won't be changed. That will clarify. Nature variable will put in nature and character or possession, current possession will not be changed. That will put in. Secondly, we'll put in that this will be without claiming any right. They cannot claim any equity or right, special right. Thirdly, at their cost. So that takes care of your objections. What is subject to permission being obtained from the municipality if required. 8.
So for A is that's
The present appeal arises out of a preliminary decree of partition. Learned counsel for the petitioner submits that since the property is in a dilapidated condition, the same is not habitable and requires certain repairs as specified in paragraph 4 of the application. Next para. Learned counsel appearing for the year for which respondent? Plaintiff.
1 and 2.
Very well. Learned counsel appearing for the plaintiff's respondents 1 and 2 submits that as opposed to the contention of the appellants, the premises sought to be repaired are not used for living purpose, but a portion of the premises is being used for poultry business by the appellants. Next para, it is further submitted that the plaintiff's respondents are willing to repair their portion of the property. Next para. It is submitted further by the respondents that the appellants are encroaching upon the portion of the respondents. Next para, insofar as the question of alleged encroachment is concerned, the same would be the subject matter of the partition suit and the present appeal when heard finally. It would be premature to enter into any findings or inquiry in that regard at this juncture, since the property is a joint property and the possession of every co-sharer is deemed to be for self and on behalf of the other co-sharers as well. Moreover, we are not deciding the particular portions which are in possession of the parties by adjudication of this application. Upon a perusal of the averments in the application, we find sufficient necessity for the repairs to be undertaken as indicated therein. However, such repair has to be subject to certain riders which we propose to incorporate as follows. Next, as follows. Incorporate herein below. Can 2 of Achana, arekta line add kodin. Since the repair sought in paragraph 4 within bracket small a, that is reconstruction of the ground floor roof may tantamount to a reconstruction which requires permission from the local municipality, the said reconstruction shall be permitted subject to permission in that sanction in that regard, if necessary in law, to be taken from the municipality. Next para. Accordingly, Can 2 of 2024 is disposed of by permitting the appellants to carry out the necessary repair works as indicated in point numbers small b within bracket, B, C, D, E and F for them. Small sub bracket. Within a period of 8 weeks from date, next para. Insofar as point number small a in paragraph 4 is concerned, the same would be the appellants are permitted to undertake the same subject to sanction being obtained from the concerned municipality, if so required in law. The entire repair work / reconstruction work as indicated in paragraph number 4 shall be carried out within 4 weeks from date. Next para, it is made categorically clear that in the garb of such repair / reconstruction, the appellant shall not change the nature and character and or the physical possession in respect of the suit property as on date. Next para, secondly, the appellants, solely by virtue of such repair, shall not be entitled to claim any special rights or equity in the property in any manner at any stage of the proceeding. Next para, thirdly, the repair / reconstruction shall be done by the appellants at their own cost, without claiming any benefit for having expended such amount in the final hearing of this suit. Full stop. Next para. It will be open to the appellants to seek extension for time to get the sanction plan, comma, if required, comma, only with regard to point number small a in paragraph number 4, comma, if necessary, full stop. The plaintiff stroke respondents will also be at liberty to file a necessary application, comma, if required, comma, in the event the appellants carry out such repair or reconstruction work by deviating from the riders imposed by us above. Full stop. No address to cost. No address to cost. So you can file an application if they deviate. And Mr. Mukherjee, you also can file an application for extension of the sanction. প্রথম লাইনে করে দিন, can 2 of such and such is treated to be on the days list on consent of parties. We are treating it to be on the days list with your consent because it is not appearing in the list, but the application is next.
My lord has mentioned point numbers B to F. Then my lord, it will be point numbers B to F of paragraph 4.
Yes, we have stated somewhere. Paragraph 4 was the general term.
Yes, general paragraph 4 has. I'm grateful. I'm grateful.
Yes, Mr. Yes. Detailed hearing is required. Detailed hearing is required at this stage.
It's a small matter.
Order for 27.
Yes.
Smaller than small.
I am.
Mr. Rai of
4
Sub.
dates only. 4 dates only is required. In order to decide this.
No, should you look at that at this juncture or along with the appeal? Order for 27 is in the nature of you try to incorporate what?
This is expert since in spite of service, no one is appearing.
You have to be extra careful.
The only thing is, I am married with the respondent number 1 in 2016, 28th March 2016. The male child was born on 18th May 2017. Then talak was granted on 27th March 2021. I have filed an application for custody of the child. In the meantime, on 28th August 2021, the respondent number 1 married second time after the talak is granted. I filed an application for custody of the child on the allegation that since she has married, she has no right to custody of the child according to the Muslim law. Now, the learned judge rejected my application on this ground that you could not, although you have named the persons whom the respondent was married, but no document was produced.
Oh, you are wanting to produce that document.
I wanted to produce.
So it has to be, it can be disposed of lock, stock, barrel.
Yes.
Mr. Rai, have you served copy previously?
Yes.
They are not appearing. We
have served.
We will direct you to serve a copy of the memorandum also on the other side, as well as this application again afresh, indicating that the appeal and the application shall be taken up on the short point whether this application should be allowed and the matter should be remanded. We'll clarify that in our order, and we'll also permit you to serve on the learned advocate for the respondent in the court below in our order so that he accepts. So this can be decided in a minute. Yes, he wants. Oh, expertise degree. So no trial court lawyer. তাহলে ওর নতুন হাজবেন্ড কি ট্রাই করতে হবে সব দিয়ে হ্যাঁ আর অর্ডারে ইন্ডিকেট করে দিই যে আমরা কি পয়েন্টে শুনবো যাতে ওরা বুঝে যায় তারপর যদি না আছে করে দেবো তারপরে আবার under order 41 rule 27 of the code of civil procedure the trial court refused the prayer of the appellant for custody of a minor male child primarily on the ground that no document of the subsequent marriage of the respondent was produced. The appellant contends that after document ছিল না বলে দেয়নি document subsequent হয়ে যাবে the appellant contends that after talak was granted to the respondent number 1 wife, comma, she remarried comma, which according to the trial court, comma, could not be proved in the absence of any document with regard to such remarriage of the respondent number 1. Full stop, next para, as such, comma, if the document now sought to be produced, that is the marriage certificate of the second marriage of the respondent number 1 wife after the previous talaq is brought on record, comma, the main matter can be decided on the same. Full stop, next para, hence, comma, the scope of the appeal and the present application are overlapping and are very brief in nature. Full stop, accordingly, we decide to hear the appeal along with the application without calling for the trial court records and dispensing with all formalities apart from further service on the respondents. Full stop, next para, accordingly, the appellant shall serve, respondent number 2 is the second husband. Accordingly, the appellant is directed to serve copies of the memorandum of FMAT 103 of 2023 along with Can 1 of 2023 on both the respondents, indicating that the appeal along with the application shall be listed on January 7, 2025. Full stop. All other formalities apart from such service is dispensed with for the present. Full stop. The trial court records need not be called for.
I'm good.
ওটা নতুন ডকুমেন্ট কিছু ছিল না।
An unintentional mischief has been committed. So the direction for an affidavit, the affidavit could be found only today, my lordship.
This was for withdrawal of the portion of the money deposited by state. Out of 45 lakhs, we wanted to withdraw 13 lakhs 69,000 on account of the work done, principal work done, and not the security deposit. They wanted to use an affidavit. I relied on 2 judgments of your lordship's court note where upon undertaking, my lord, permission has been given to withdraw a portion.
Would you like to use a reply?
I haven't received a copy. Now I'm getting a copy.
We'll give you a week's time or 3 days time. Do that, come back Monday.
Thursday, my lord.
Thursday, very yes, absolutely. We have
I'm also otherwise ready, my lord.
affidavit in opposition filed today be kept on record. Full stop, since a copy thereof has been served only today on the learned advocate for the appellants, comma, the time for filing reply is extended till December 19, 2025, 2024, when the matter shall next be listed under the same heading.
Lordship.
Next.
I'm for it.
Yes, Mr. Nathar. Have you served on the other side? Was there any direction for service?
Previously, it was direction for service. I served.
The appeal was formally admitted.
Yes, yes.
When?
In the 2023.
Yes, admitted. Right. You are right. What is the appeal against?
Appeal against order 39 rule for modification of injunction order has been refused.
Has been refused.
Yes.
So,
the only cause is there sanction pledge at that time when the hearing was conducted.
Mr. Shata, have you served a copy of this application on the?
Yes, application.
Where is the service?
Service are given.
Already given. It was for the previous court, serve afresh. We'll direct you to serve a copy of the memo as well as the application, so that if they appear, we'll try to dispose of the entire thing. The appellant, we find from the records that the appeal has been admitted. The appellants shall serve a copy of Can 1 of 2023 afresh, along with a copy of the memorandum of FMA 719 of 2023 on the respondents, indicating that the appeal and application shall be listed together for hearing on January 8, 2025. The trial court records are dispensed with for the present. Trial courts have arrived already.
I think this trial court record already arrived.
আচ্ছা তাহলে পরেরটা দেওয়া দরকার নেই। Informal paper books be prepared and filed on the returnable date by the appellants. Prepare informal paper books.
Your Lordship, for the appellate, Your Lordship, we have there were multiple orders we had served.
Use the microphone.
Your Lordship, there were multiple orders we had served on 3 occasions. The issue, Your Lordship, on last occasion directed me to file the affidavit of service. The issue is, Your Lordship, it was
Have
my
been served properly.
that is the issue, Your Lordship. Even the thing is that it is written delivery confirmed, but at the bottom it is written that no such, at page 4, no such person exists in the address, and this is the address below, the learned court below. I tried contacting their advocate of the other side also, the court below could not. I have gotten an address of the mother of the wife, as in the opposite party.
Won't help you.
This is the, but the point is very short, Your Lordship.
No, we understand. Point is, this is against a matrimonial decree.
Yes, suit.
No, this is judgment in name. I will direct you to effect substituted service by newspaper advertisement. Do that.
That means.
Despite service, none appears for the petitioner. Push up next para. The what is the application for?
The application for divorce, Your Lordship, matrimonial suit for divorce.
What is the application for? Present
application? I had just, it's a CAN application. I had just enclosed every document just to show. It was because it's on a very short point, Your Lordship.
There is for appropriate order.
Yes, appropriate orders, Your Lordship, just for including all the.
Very well. We find from the records that despite service at the address, the present application is for appropriate orders to bring on record relevant documents. First up, learned counsel for the appellant submits divorce was refused.
Yes, Your Lordship.
Learned counsel for the appellant submits that the appeal is against the refusal of a divorce suit filed by the appellant husband. First up, next para. Although service was sought to be effected at the last known address of the respondent, she appeared in the court below.
Yes, Your Lordship. She appeared, she filed her chief
comma,
also.
At which the respondent was served the summons of the suit and appeared and contested, comma, the service, the track report indicates that although the item was delivered to the sender, comma, in a previous endorsement of the self-same track report, it is indicated that the item returned as insufficient address. First up, it is obvious that delivery to the sender does not indicate effective service on the respondent. First up, as such, comma, we find that despite efforts to serve at the last known address, comma, the service could not be completed. First up,
page 4 is the last service where it is written no such person exists in the address. Page 4 at the
accordingly, we direct the appellant to effect substituted service of notice of the appeal as well as the application by publication in 2 daily newspapers of moderately good circulation in the area of the last known address of the respondent, comma, one of which shall be in English and the other in, what is your language, mother tongue? Of
Bengali.
Of the other in Bengali vernacular. First up, such substituted service shall be effected within 4 weeks from date, and an affidavit of service to that effect shall be filed on the next returnable date. First up, the application shall next be listed on January 16, 2025. Wait for ওটাকে ট্রিট করে নেবো অ্যাপিলের নোটিশ বলেছে আপনি সবসময় সাজেশন দেবেন। নেক্সট all the both the respondents.
There is 2 respondents.
Both the respondents you are appearing for. Yes, what is that?
Delay and stay application. Well, I want to file the opposition.
Delay how much?
Delay 102 days.
100.
What is the reason?
My lord, the certified copy received on 1st January, my lord. Thereafter took some time to contact with the advocate. And
how can you have personal knowledge on that, Mr. Bhattacharya? What will you say in your opposition?
But
you cannot have any personal knowledge regarding when they applied for certified to copy, that will be evident. And
Only thing, Lord, your lordship, if your lordship kindly see the judgment, the
yes,
top portion,
yes,
top portion,
judgment.
yes, in the top portion, Lord. Your lordship kindly see the application, he filed on 19th July. Then, Lord,
Judgment.
judgment. Lord, the party, this is a partition suit, Lord. Partition suit.
Impugn
Your
judgment.
lordship kindly see the memo of it, so that your lordship.
Yes, we are
In the
seeing
top portion, Lord,
title suit 44 of 2017.
applied and filed, Lord, the requisition.
Oh, that acha.
Yes.
On 19th of July.
Yes. Then, Lord, 12th, 12th, Lord, September, Lord, the requisition made. They
were notified on
deposited in 15th January. That cannot be.
That must have lapsed.
Yes, automatically lapse.
But they got the certified copy all this.
I do not know how.
That is happening in trial courts, Mr.
That,
Bhattacharya.
I see.
It should have lapsed.
Then, Lord, dear lordship.
That's the trial court's fault.
This is my.
But that
You
has
need to
lapsed.
show your
No,
lordship.
you are absolutely right, Mr. Bhattacharya. It's very evident. Should have lapsed after a few days. But since it has not lapsed, I mean, that's a, what should we say, ministerial error of the.
The trial court maybe. But not regarding.
করেনি এখানে করে ওটা কি করে দিয়েছে পেয়ে যখন গেছে you got it on 15th of January. When did you file the appeal?
File on 21st March, my lord.
21st
March.
Why this delay? You are thinking over the matter.
No, my lord.
The advocate was thinking over the drafting. Nothing in the matter, and you have to.
Thereafter, my lord, he collected from the learned advocate on 2nd February, my lord, the court below. And thereafter, my lord, on 17th February, he came to the High Court, my lord, and thereafter.
Then I have not say anything.
We are allowing the
Yes.
section 5 stay. Will hear you.
No, no. No problem.
The which can is that?
Can 2 of 2000.
Can 2 of 22.
Can 2 will not stay application.
No,
That
can
will
2 is the section 5. They have numbered
can
it.
1 is the stay application.
1 is the stay.
Yes.
That you will hear you.
That yes, Mlad, I want to. Mlad,
I will hear you, sir.
because
Can 2 of 2024 is an application for condonation of delay in preferring the appeal. Full stop. Although the certified copy of the impugned judgment and decree was filed only after 2 days from the passing of the same, comma, substantial time lapsed in obtaining such certified copy. Full stop. Ultimately, the same was obtained on January 15, 2024, comma, after which the appellant took some time to collect it from his learned advocate, learned advocate apostrophe clerk in the court below, and to instruct his learned advocate in this court. Full stop. Thereafter, some time was spent in drafting and filing the appeal. Full stop. Learned counsel appearing for the respondents opposes the prayer and submits that the application for certified copy ought to have lapsed, comma, since the date of intimation of the requisites to the appellant was September 12, 2023, whereas the requisites were put in on January 15, 2024. Full stop. Since the applications for certified copy lapses after 3 days, comma, the obtaining of the certified copy itself is bad in law, and the time consumed in between ought not to be deducted from the limitation period. Full stop. Next para. However, comma, we find that although there was some ministerial lapse in not considering the application for certified copy to have spent its force, but having granted certified copy, although the requisites were put in much after the statutory period, comma, since the fact remains that the certified copy was obtained only on January 15, 2024, comma, we cannot penalize the appellant for such lapse, comma, if any, comma, on the part of the concerned department in the court below. Full stop. Next para. Being otherwise satisfied of the reason for the delay thereafter, comma, we are inclined to allow the present application. Full stop. Accordingly, can 2 of 2024 is allowed, comma, allowed on contest, comma, thereby condoning the delay in preferring FAT 78 of 2024. Full stop. The appeal shall be treated to be in order and be registered accordingly. Full stop. We'll take up can 1 after 5 minutes. We said, but you'll just return and take up can 1. How does a stay lie? Dismissal of suit.
Suit is not necessary.
Stay is not necessary.
Not necessary, my lord.
If you want an injunction, you have to make the averments and file an. Have you asked? Yes, you have made the necessary averments. So we can mold the relief. What is your objection, Mr. Bhattacharya?
Objection is not, practically he is not title over the property. Suit, partition suit, that was dismissed by the attorney.
First appeal, all questions are involved. So we'll
Yes, all
grant,
questions of it. Lordship
grant
can,
injunction.
here
Their
the
possession is disputed.
possession, no, Lord, I am in possession.
Acha, is there any finding in the trial court judgment regarding your possession?
No, my lord, there is no positive findings, my lord.
Then how
there
can
is
you
no-
direct the injunction regarding possession? And if you grant status quo tomorrow, somebody,
No,
either of you
there-
will encroach.
My lord, your lordship can see page 6, paragraph 13.
Yes.
It stated that the appellant plaintiff states that the defendant are trying to dispossess the plaintiff from the suit property to the third party. I could not understand the language.
It's a mix-up between transfer and.
Yes.
And the previous
Practically,
paragraph, they say they are in.
I think it is transfer.
Mr. Bhattacharya, is there anything in the trial court's order to show that they are not in possession?
Not in possession. I
Let
can
us just
show
check up.
your
There is no
lordship,
such.
your lordship kindly see.
They have not been able to prove their the
All
chain
the thing
deed.
your lordship kindly see.
The Sen was saying.
Inner page 7.
7.
Inner page 7.
Yes.
The paragraph 10 bottom. Paragraph 10 bottom.
Yes.
However, upon scanning the said deed filed by the plaintiff, it is visible from its schedule that RS plot number Ato has not been instead of the sub plot number Ato. Then only your lordship kindly see next para, page 8. Just second.
It is just palpable. Read from that portion.
Yes. Alleged to have been executed, but it is the present plaintiff appears to have acquired no title or interest in the suit plot by virtue of the gift dated Ato, alleged to have been executed by her husband.
No, what about the
This is
position? RS plot
page-
records somebody else's name.
My lord, there is
in my name.
is recording in the RS plot number.
In my name.
This is
His
the-
name.
In yes.
RS record is in,
RS record is in his name.
in mine. There is two deed, my lord. Originally, suit property belongs to one, the father of the defendants, my lord, and the defendant
No,
number.
no, you are arguing that the RS plot number. Oh, actually, in the sale deed is.
Defendant number 2 sold the property to the father of the plaintiff, my lord, and there is, my lord, misrecording of the plot number, my lord.
Consequently, page
And-
9, it is recorded middle of the after the first paragraph, second paragraph. Consequently, when the title of the plaintiff in the suit plot to the extent of a share is not proved, question of a joint possession with the defendants in the suit plot does not arise. So it's held in the negative.
My lord, no.
What were issue numbers 5 and 6? Let us see. Issue number 5 was
But your
whether you have
lordship,
share,
page 6,
Ejmali position.
page 6, bottom portion.
No, let us go one by one.
Yes.
Issue number 6 is whether you have got interest in Ejmali position. And page 6 bottom you are saying.
Yes.
On
Your
the
lordship kindly see.
Your position is not shown.
On the contrary,
I am in
is the
possession, my lord.
defendant number 1.
It is
who
record in
claims
LR
to have
record in
filed
my
the
name, my lord.
certified copy of ROR,
Page 6 bottom.
page 6 bottom. Your lordship
Page
kindly
6
see.
of the judgment.
Yes.
In a page 6, yes. Bottom.
Yes.
Where is that? On the contrary.
On the contrary, the
I
plaintiff middle portion, your lordship can say, but finds nothing in respect of the ownership.
No,
and
start from the
possession of
sentence.
this
What is the
property
sentence? What
is
does the
in name
sentence start from? What does the sentence start from?
Your lordship can say, middle portion in furtherance thereof. Middle portion.
This is point number 9.
Point
Paragraph number 9.
Yes. Paragraph point number.
In furtherance thereof, yes. You can any of the documents and or possession of the suit property in the name of Gokuleshwar is your predecessor.
Gokuleshwar is their predecessor, my lord. Gokuleshwar died leaving behind wife and 2 sons, my lord. Chiranjit and
You say Gokuleshwar gifted to you.
no, my lord. Chiranjit Mondal gifted me, my Chittaranjan Mondal gifted me, my lord. But Chittaranjan Mondal did not appear in the court below, my lord.
Anyway, we are not concerned with you. হ্যাঁ ওই জায়গাটা বলছে দুজনেরই পজিশন হতে পারে, দুজনেই ভুল করে। ওটা পড়ে কি, ওটা পড়ে বলছে গোকুলেশ্বর পজিশনে ছিল না,
Defendant number 2.
কিন্তু গোকুলেশ্বর শুধু তো ও ক্লেম করছে। On the contrary, it is defendant number 1. Page 8, internal page 6 says, on the contrary, it is a defendant number 1 who seems to have filed certified copy, although the same is partially illegible. However, plot number appears from the said document, your document, to be RS 4658, measuring 14 decimals of land.
Yes.
So that is the suit property.
That is the suit property, my lord. Suit property is 1.45 decimal, my lord, which I have
So that
purchased, my
14
husband
decimals
purchased.
is his name.
My lord,
It is his name.
Yes.
Recorded in the possession is recorded in his name.
Yes. Is my name.
So therefore, no, we are refusing possession, injunction regarding possession. Status quo regarding nature, character, and transfer. Only that. And we'll record, Mr. Bhattacharya, that you are not admitting any of the above.
Yes, yes.
Because we are not inviting affidavits.
Your lordship.
Can 1 of 2024 is captioned as 1 for stay, which of however, comma, we choose to mold the reliefs since there is no question of any stay of a dismissal of a suit, and as there are sufficient averments in the application to consider grant of injunction. Puts up next para, the appellant pleads possession in respect of the suit property. Puts up however, comma, prima facie, we are of the opinion, comma, from a perusal of the relevant paragraphs of the impugned judgment and degree, comma, that the plaintiff failed to prove her possession in respect of the suit property. Puts up as such, comma, we are not inclined to grant an injunction in that regard. Puts up, be that as it may, comma, since the appeal arises out of the dismissal of a suit for declaration of title and partition.
No party. Yes. Yes.
And partition,
Sorry.
comma, we are of the opinion that the property should be maintained in statu quo. Status in statu quo during pendency of the appeal. Full stop, next para. Accordingly, can 1 of 2024 is allowed on contest, comma, thereby granting, directing both parties to maintain status quo with regard to nature and character of the suit property, as well as in respect of transfer, alienation, or creating any third party interest in the suit property, comma, till disposal of the appeal. Full stop, since we have not invited affidavits, comma, it is deemed that none of the allegations made in the application are admitted by the respondent. Full stop, next para, respondents. Next para, the appellant shall prepare and file the appellant shall, in view of the appearance of both respondents to their learned advocates, comma, service of notice of appeal on the respondents is dispensed with. Full stop. The records be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. Full stop. The appellant shall also put in other requisites, comma, if necessary, comma, within a week. Full stop. Next para, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival on the of the trial court records on the learned advocate on record for the appellant. Full stop, liberty to the parties to mention the appeal for inclusion in the list for hearing, as and when the same is made ready for hearing.
Can want to dispose of that.
On the last occasion, my lord, the respondent filed their affidavit in opposition, my lord. Today I am filing my affidavit in reply, my lord. This is the affidavit in reply. This is my affidavit of service, my lord. Copy served.
Yes. অপোজিশনটা কোথায় আছে? অপোজিশন আগের দিন ছিল?
I don't last occasion.
অপোজিশনে ফাইল
Last occasion.
আপনাকে দুটো কপি চলে যাবে অপোজিশন?
Second guys copy.
হ্যাঁ, fix.
Both the copies are there.
হ্যাঁ. Yes, what is the matter? What is the appeal against?
My lord, kindly fix the matter for hearing after 1 week after vacation.
Why? No question of that.
Because my lord,
No, stay application, no question of that.
No, my lord, it's all, we already grant stay, my lord.
We have granted stay.
My-
So you also want after vacation?
Charges have been given.
You are suffering stay, you are asking for
No, my lord,
adjournment.
my senior is in hospitalized. Hospitalized. That
You are there. Stay application, the appeal is against what? They would want an adjournment. They would love an adjournment. What is the impugned degree?
Actually, Mr. Digari is appearing, my lord, in this matter also. I am also paying for an adjournment.
Eviction.
Regarding eviction.
Both learned counsel for both the parties seek an adjournment till after the upcoming Christmas vacation. Push up the affidavit of service and affidavit in reply filed to be kept on record. Push up. Let the matter be listed in the monthly list of January 2025.
Your Lordship, I appear on behalf of the appellant, Your Lordship. On the last occasion, there were two queries by Your Lordships. First, whether it was room 9A or 9.
Forgot the thing. And
Oh.
What is the
Your
matter?
Lordship, this is, so I am suffering an eviction decree.
Are we hearing can 3 or what?
Can 1. Can 1.
Can 1.
Let's stay applicable.
Stay application. 1, 2, 3, so many applications. So these.
Who has been disposed of? Who has been disposed of by Your Lordship's order?
Which has been disposed of?
Your Lordship, the delay application, Your Lordship.
Delay was 1. Delay was 1.
So this is 2, Your Lordship. My stay is 2.
Stay. Now you are hearing 2 then. What is 3? He does not have any caption even.
It is not filed by me, Your Lordship. It was.
Oh.
I got a change in the matter after it was filed.
No. It says rule granting stay of execution of the judgment. So 2 and 3 are same probably.
There are two applications for stay.
Can 2 is appropriate order, but you have paid for stay there. No, appropriate order is early hearing probably.
Can 3, Milord, which has been served upon us, Milord, it says rule granting stay of execution of the judgment dated 29th April 2024.
And can 2 says set aside the impugned judgment degree.
And
rule granting stay also.
Yes. I have the can 2, Your Lordship. I
1,
don't have
Milord,
can.
which
So let us allow the prayer A of can 2.
Section 5, Milord, is can 1. That is already allowed.
Can 2 prayer 1 we are inclined to allow. At the ad interim stage. Mr. Bhattacharya, please come to prayer A of can 2.
Page 11.
We are allowing that ad interim. Have you checked up?
I'm trying to assist you, please.
Page 11, imputes ad interim. Eviction degree.
Have you checked up? Read it out once. Once read it out.
Set aside the impugned judgment and degree, Milord, in application, Milord.
So you're agreeing to that being granted at
Milord, I am the respondent, Milord. I agree to that. B, Milord, I'll oppose.
What is the? It's against what? Eviction. Stay.
Yes, on the last occasion, Your Lordship was pleased to hear the matter for some time. And
Yes, room 9 and 10. What were
room 9 and 9A, there was a confusion. Your Lordship, my submission because I was a tenant there and I am still residing there. There is only one room where I am residing, which is 215 square feet. In the agreement which I have signed, the agreement has note in by pen whereby the landlord has only made an endorsement room 9A. I don't know of which room 9 he is speaking about. It is upon them to show because I can show from the 2 suits which my condition is same property. 2 suits are being filed for eviction. That is with regard to 9A. It's a 215 square feet room, only one door, entry and exit. And I have a copy of that agreement.
As per the agreement, agreement says 9A.
Yes.
You say you are enjoying 9A.
Yes.
And the suit property is
9A.
9A.
Yes.
So where does 9 come from? Who is speaking out?
Lordship, my learned friend picked up the topic that there is the difference. The other suit is with regard to room number 9.
Achha.
This suit is.
So we are hearing now one suit,
9A.
one appeal that is regarding 9A.
9.
There is no doubt on that.
No.
So let us proceed.
We are
on that.
item on that.
Achha. So this is a decree under Premises Tenancy Act or trespass?
9A is suit.
Flat number 9. In the decree, it's written flat number 9. Justice Shen is saying that, my brother.
Flat number 9. This is 9. Kindly.
But just now you agreed that it is 9A.
No. Kindly comes to Milord, page 15 of the plaint. page 15 of the application. The plaint is there. Milord, kindly see, Milord, page 16, para 7 and 8. Kindly see that the said Rocky Jadhav had surrendered his tenancy being flat number 9, including the said one room in favor of the said Shivendra Kumar Pramanik since disease, and the defendant was using flat number 9A as a monthly tenant. That after becoming trustee, the plaintiff has visited the flat premises number 36 1A Shorkar Lane, PS Girish Park, such and such, when it was noticed that
One Rocky Jadhav surrendered 9. How we don't understand the transition between 9 and 9A in para 7.
those two were, Milord, rooms, Milord, adjacent to each other. Milord, he has forcefully entered.
He has entered 9A, you are saying?
No, kindly see 9A, he is a recorded tenant.
All right.
Then, well, kindly see, that's what, Milord, I'm placing paragraph 8, that after becoming the trustee, the plaintiff had visited premises number 36 1A Shorkar Lane.
Yes. Trespassed into 9.
Trespass.
That has been granted.
Yes.
Oh, the other suit is for regarding, he's a tenant regarding 9?
Where we have got a decree, this honorable court.
That is under 97 Act.
97 Act. Now, Milord,
and this honorable court set aside that decree and then remanded back to the trial court.
Even after remand, we have again not got a decree for eviction. Now, Milord, kindly take.
That has not been challenged subsequently.
I do not know.
You are 90 days is not yet over.
When the city civil code limitation is 30 days. Milord, kindly comes to a written statement at page 24. Because, Milord, I'm on
So they want to stay.
I'm on the prima facie case first.
Very
Milord, kindly comes to page 24. Milord, kindly comes to page, para 11 at page 25.
You have levied execution.
Kindly comes to page 25, para 11. Kindly see, with reference to the statements made in paragraph 128 are matters of record. They admit they are trespassers. They are matters of record. 7 and
They say it will be dealt with in.
kindly see, yes.
Where is the appropriate time and place?
12 to 18 is, kindly see, Milord, where there is a single, Milord, averment regarding that.
So the place has come, but the time has not come probably.
Well, this is admission, Milord. After this, whether
You're fighting a lost case. Because you cannot improve whatever was done in the trial court.
Kindly see the subsequent paragraphs of the written statement. No averment, only denial.
What is your case? Nothing.
Your Lordship, in this, I'll very.
What is your independent right you are claiming?
Lordship, my
26.
The relief I am seeking here is
tenant. Any single document?
With regard to your Lordship.
You plead that you are a tenant in paragraph 17 of your written statement. Page 26.
Well, then I have to ask for that, your Lordship.
No, you cannot ask for that.
Lordship,
Before the suit court, if you could not present it, you are gone.
Lordship, the prayer I am.
Directed them to file supplementary affidavit.
No, that I have filed. No, that I have filed. But your Lordship, the prayer I am asking.
Yes, what prayer?
The relief is, my claim is that with regard to one property, there cannot be two suits. They have filed one suit for eviction. That has been again decreed. This suit was filed subsequently, claiming for the identical prayer.
That point has been taken in the written statement.
But that
No, this has nothing to do with the other suit. Other suit is these are adjacent rooms, right? One is 9, another is 9A. 9A, you are a tenant, admittedly. They have got a degree. Lastly, position as of today is they have got a degree. Even if they did not get a degree. 9A, your tenancy is admitted. 9, your tenancy is not admitted. They say you have encroached upon 9. You say that you are a tenant, but you have failed to prove one document. Was any rent receipt produced in the other suit showing that 9A is the property? Otherwise, there is a scope of confusion.
Because we admit him as a tenant in the other suit. Yes.
Other suit, but we want to see any rent receipt or anything which was produced in the other suit to see whether 9A is the premises.
Your Lordship,
if you find one room, then Mr. Bhattacharya, he has a primary.
May I substantiate page 21 of my application? Kindly see the documents relied on by the plaintiff. There, the agreement he is relying on is 1st September 2005.
Page 21.
Yes, Your Lordship, of this application, page 21, internal page 7 of the plaint. The documents relied by the plaintiff to make out a case in the plaint.
Yes.
3. Tenancy agreement 1st September 2005. I have that copy, Your Lordship. That says 9A.
Where is that copy?
Yeah, Lordship, I have it.
Rent bill also is there.
They relied.
Why didn't you annex it in the supplementary affidavit?
Lordship, this was.
Annex whatever you have to produce the documents. Yes, what does that say?
That says, Your Lordship, I have. Lordship, that says room 2015 square feet and room 9A. Kindly see.
So that is your tenancy. Therefore, you don't have any right in 9.
No, he is telling that this suit is with regard to 9. He himself is telling
You have to
this suit is-
understand the basics of the case. You have not studied your case properly. We told you what his case is. You are not understanding. That is your difficulty, sir. You have to understand at least during hearing if you did not prepare yourself previously. Their case is they have instituted 2 suits for 2 rooms, adjacent rooms. One is 9A, another is 9. Regarding 9A, you are granted a tenancy by way of an agreement which is substantiated by you by handing over that agreement. So 9A, they gave you a tenancy. They obtained a decree, remanded in appeal, again obtained a decree. Now they have a decree against you regarding 9A, regarding in respect of which you are a tenant, admittedly. Regarding 9, they say, which is an adjacent room, during your tenancy in 9A, you encroached upon 9. 9 is a different ball game altogether. It's a different room. So regarding 9, you are a trespasser. Therefore, common suit is not maintainable. They rightly filed 2 suits, one under 97 Act, the other for eviction of trespasser. This is that eviction decree against your trespassership regarding this 9. You have said that you are a tenant. You don't produce a single document. The only document which has been produced is the agreement, which shows your tenancy is in respect of 9A. So if you have not produced a single document to substantiate your case of tenancy regarding 9, then you are gone. You don't have any prima facie case.
Your Lordship, my submission, there is nothing called room 9, Your Lordship.
If there is nothing called room 9, will not grant any stay. They'll execute nothing. They have got an execution regarding room 9, right? They have got a decree regarding room 9. They'll execute that room 9. If you say there is no room 9, they'll get zilch, they'll get 0. They'll not get nothing by that execution. Let them execute nothing. You can't have any case then. If you deny the existence of room 9, but that is contrary to a written statement case. In written statement, you have not said that there is no room 9. Their specific allegation is that you have trespassed into room 9. There, while denying that, you have said it is a matter of record and will be dealt with accordingly at the appropriate time and place. We fail to understand which is the time and place which can be referred to in a written statement to make the very basic averments of your case.
I cannot.
So your written statement does not say anything, as rightly pointed out by my learned brother, apart from para 17, where you say you are not a trespasser, you are a tenant. In respect of the suit property in this suit is room 9. How can you deny room 9 now? Because you have not stated there is no room 9. You have stated that you are a tenant in respect of room 9. No document to produce that. Why should these frivolous appeals be kept pending even? This is the first appeal. We won't dismiss the appeal, but we will say there is no prima facie case. Nothing. You have failed to show a single document of tenancy regarding 9. Nothing. Before the trial court, before us, we gave you opportunity to use a supplementary affidavit. Supplementary affidavit gives precious nothing. What do you say in the supplementary affidavit? What have you annexed in the supplementary?
Judgment of the
Other suit. The judgment of the other suit.
9A.
That substantiate their case.
No scope for any confusion. No,
Ah.
no scope for any confusion.
That's why 2 suits were filed.
We are rejecting your step.
May this reason, Your Lordship, may I get just one day so that
No. Say very sorry. No. We have expressed our mind. No further. And we have given you an opportunity to file supplementary affidavit. What is CAN 3 for?
Your Lordship,
CAN 3 is same.
Both stay.
Same pair. CAN 3 is same. And this is CAN. What is the other one? CAN 2. CAN 2 is also for stay. CAN 2 of 2024 and CAN 3 of 2024 are taken up for hearing. Full stop. The appeal arises out of a decree granting eviction against the appellant in favor of the respondent on the ground that the appellant is a trespasser in respect of room 9 in the suit premises. Full stop. Next para. Upon hearing learned counsel for the parties and for the parties, it transpires that 2 parallel suits were filed by the self-same respondent in respect of 2 adjacent rooms, room number 9 and room number 9 capital A, in the same premises. Full stop. Next para. In respect of room 9 capital A, the plaintiff respondent admitted the tenancy of the defendant appellant and initially obtained a decree of eviction Full stop. The said eviction decree was set aside by the appellate court and the matter was sent on remand to the trial court, upon which, it is submitted by learned counsel for the respondent, a fresh decree of eviction was again obtained in the trial court. Full stop. Next para. Insofar as room number 9 is concerned, the plaint case of the respondent was that the appellant, taking advantage of his tenancy in respect of the adjacent room number 9A, encroached and trespassed into room 9. Push up next para. In the written statement, we find that there is absolutely evasive denial, pushed up in denying the relevant paragraphs of the plaint, that is paragraph numbers 1 and 8, the defendant appellant substantially states that those are matters of record and appropriate pleadings in that regard shall be made in appropriate within bracket time and place, double inverted close, full stop. Next para, there is no specific assertion as to any status of the defendant appellant apart from paragraph 17 of the written statement, where a bold, BALD, bold statement has been made that the defendant appellant is not a tenant, but not a trespasser, but a tenant. Pushed up, we find from the records that not a single iota of evidence was produced to that effect by the appellant in the court below. Pushed up, even in this court, and a copy of an agreement is sought to be relied on by learned counsel for the appellant, which substantiates the fact that the tenancy of the appellant was in respect of room number 9 capital A and not room number 9. Full stop. Since the tenancy in room number 9A is not disputed, and is the subject matter of a different suit, there is no scope of going into the same. Full stop. Insofar as room number 9 is concerned, as discussed above, neither in the pleadings nor by way of proof could the appellant produce anything to substantiate the appellant's case of tenancy with regard to room number 9. Full stop. Hence, we find that the defendant appellant has palpably failed to make out any prima facie case whatsoever for hearing the first appeal on merits. Full stop. As such, there is no scope of granting any stay of execution of the impugned decree. Accordingly, Can 2 of 2024 and Can 3 of 2024 are dismissed on contest without any order as to cost, thereby refusing stay to the appellant. Full stop. The plaintiff respondent shall be at liberty to proceed with the execution of the impugned decree. Full stop. Would you like to proceed with the appeal or should you dismiss the appeal also?
In the appeal, I need
Very. Although virtually nothing remains for the appeal to be heard out, learned counsel for the appellant seeks a final hearing of the appeal. Full stop. Next para. Since the findings in an order passed in connection with a stay application are, after all, tentative insofar as the final hearing of the appeal is concerned, we are, as such, not inclined to dismiss the appeal at this stage, since the appellant wants to proceed with the same. Full stop. Accordingly, the appellant shall, accordingly, the trial court records be brought by way of special messenger at the cost of the appellant to be deposited within a week from date. Full stop. Requisites, if any, shall also be put in within a week by the appellant. Stop. Service of notice of appeal on the respondent is dispensed with by virtue of appearance of the respondent through his learned advocate. Full stop. A skeleton record shall be maintained by the trial court for proceeding with the execution case. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for hearing upon the same being made ready for hearing. Thank you. Great. Yes.
Item number 24, Malan, I am for the appellant.
Right.
Stay. This relates to Malan, land acquisition under Act 2. And my lord, the can application number 1, that was for delay, that was allowed on 19th August 2024. And now, my lord, I am moving the can application number 2, stay, stay of the execution proceedings. My lord,
Lord, I submit, my lord, there is a section 5 application.
Section 5 he says has been allowed.
Hello,
When allowed?
19th August 2024. My lord, can see.
has been allowed.
2020? Yes. August 2020? No.
I'm sorry, my lord, 19th July.
Yes. The other division bench allowed.
Allowed.
can টুই আছে
Can want to না
মিস্টেক শুধু can টুই আছে
ডিস্ট্রিক্ট ক্যান 2 আছে সেকশন 5 টা না এলাও হলে ওটাও শুনতে হবে You are not there. No name for the respondent is recorded.
You served, nobody.
You had served, you had not appeared. They had served, you had not appeared. So already allowed. What about the stay, Mr. Bhattacharya? You have deposited the amount?
No.
Enhanced amount? Is it a prerequisite under the Act to deposit?
Yes. Yes, my lord, this should be treated as money decree. So we will deposit the entire sum before the Registrar General.
Because this is against an enhancement.
Enhancement.
So Bhattacharya, the usual order will direct them to deposit the entire amount which will bear interest in an interest bearing account.
Going in lordship,
Yes.
the judgment order
50%.
of our High Court in the similar cases.
50%. No ratio was laid down there. You can cite the judgment. Please cite the judgment.
No, there's, but
In that case, it was done.
I think
Anyway, the dean.
this was traveled to Supreme Court also. I do not know. I heard.
Supreme Court SLB was dismissed.
You don't know.
So there was no merger.
Otherwise, they would not have.
But yes, 50%. You have got the original amount. The enhanced amount you have not got. So you want 50% of that enhanced amount to be. The amount originally assessed, that has been disbursed to you.
Collectors
Awarded amount has been.
Yes,
Obviously.
collectors award they received. But not the enhanced amount. The enhanced amount we would be depositing before the Registrar General, and my lord, let them come up with the application for withdrawal. So
No,
my lord,
that
I
is
can-
not required. We
my
can.
lord, then, my lord, kindly, I need to show the judgment.
Let us see the
Passed by
judgment
the
cited by Mr. Bhattacharya. Mr. Bhattacharya, have you got an extra copy for him? Because this is unreported, they have to get a copy. Here it was 40%, absolutely discretionary. These are cultivable lands. These were cultivable lands.
One is-
Cultivators.
One is Shali, another classification is Khal. So there are two types
So they
of.
these are agriculturists.
So this is in respect
My lord,
of.
in respect of Shali, yes, but in respect of Khal, that cannot be treated as agricultural land.
They are Khal, you are the Kumir. So they are entitled to compensation.
Land of the same moja, same jail number. As such, man, they
40%. Now,
also-
what is the ratio, Mr. Bhattacharya? You are citing 40% withdrawal. There are judgments which say 50% withdrawal.
And paragraph 50, paragraph 14, you will also can see
14 of the application.
of the stay petition.
Yes. Yes, para 14.
Yes, বইটা মূল মামলা করি স্যার যদি করতেই চাইছে তাহলে করি
These are averments which will be decided in the appeal. Mr.
The
They are
learned
very-
LA judge, my lord, has gone haywire. My lord, why I am saying this? My lord, the LA judge has relied on Act 2013. This is an acquisition under Act 2. My lord, this acquisition had taken place in the year 1976.
Act-
Well, let me place my
Mr.
application.
Bhattacharya, if they win the appeal,
Act 2 cannot exist because it has to be converted to Act 1.
Mr.
Otherwise,
Bhattacharya,
there is no
if they
question
if
of
they
conversion.
if they win the appeal, there is always a possibility of it going either way. If they win the appeal, then how will you compensate? I mean, if you permit you to withdraw, You are not an institution. You are individuals. You'll spend the money. How, if we direct you then to recompense, how can you do that? And if you're cultivators or landowners, I mean, if you direct you to furnish bank guarantee, that would be equivalent to not taking the amount. For bank guarantee, you have to deposit some amount in the bank.
Similar circumstances, order has been passed by the division bench of our High Court. Your Lordship.
Let us see the relevant portion of that judgment.
My lord, kindly come to the judgment, my lord.
Please come to page 4.
But,
Zadar, you take your seat. Let Mr. Bhattacharya complete, because we have heard you. Because you have to basically reply to this 40% withdrawal thing.
and for
Otherwise, we will direct you to deposit the entire amount. So
we are ready.
We have heard you. We have heard you on that. Let Mr. Bhattacharya argue his case. Then he will give reply to that.
Lord,
Regarding withdrawal, we are focusing on withdrawal.
he-
Yes.
in the similar circumstances in respect of adjacent land, the earlier court passed order, earlier tribunal also passed order. The quantum of compensation should be 40,000 per decibel. That judgment was appealed against, and the division bench passed order that 40% paid out of the deposit. Now,
Here, no compensation was paid, because the finding of the division bench is, please come to internal page 3 of the judgment you have cited.
yeah. No. আমার কাছে নেই এটা।
You don't have a copy. You give your copy, Mr. Dhar.
Your Lordship, can see the order. The said proceeding, second page.
Yes.
Said proceeding was which was registered as case number 44 of 2004, was disposed of by the learned judge on 7 June 2011 by assessing the market value of the acquired land at rupees 40,000 per kata. In addition thereto, acquiring body was directed to pay interest at the rate of 12% annum on the market value. Respondents' entitlement to get solatium at the rate of 30% was also recognized in the award. Further interest was also directed to be paid on the matter market value or as per different provisions of the Land Acquisition Act. The acquiring body was thus directed to pay awarded compensation within 90 days from the date of the award. Mr. Rai Chaudhary, learned senior counsel, appearing for the respondent, submits that as on today, sum of rupees is payable. Let the calculation sheet which has been submitted by Rai Chaudhary in the court today and the copy thereof which was given to Mr. Dotto, learned senior counsel, appearing.
Give us a second, sir. Additional deposit may be made with permit the respondent to withdraw 40% of deposit. Such permission for withdrawal is given to the respondent. He has not paid the compensation amount to এখানে তো যেটা পেয়েছে এটা ডিস্ট্রিবিউট
সেটাই এখানটা যাওয়ার জন্য ওয়েট করছি। Yes, Mr. Bhattacharya.
Accordingly, we dispose of the stay petition by granting unconditional stay of execution case. Pending, we have also started execution case in this matter also. Pending before the Court of Additional District Judge, First Court, Partition, only for a period of 8 weeks, and if in the meantime the appellant deposits the same entire awarded money amounting to rupees 51,71,000 within the learned register.
Come to the next paragraph, Mr. Bhattacharya.
In case this says deposit is made by the appellant, we permit the respondent to withdraw 40% of the such a deposit.
Then comes the reason. Next sentence. Please read on. Such permission.
Such permission for withdrawal is given to the respondent as he has not been paid the compensation amount till
Date. He had not been paid any compensation.
Compensation amount was paid only কত টাকা? About 10,000 rupees. 7,000.
7,000?
7,000 in total or 7,000 per kata?
Total quantum was paid.
Total 7,000 rupees. What was the area of the land?
14,
or 30th কত
1976.
yes when was it paid 1976 maybe assessment
Land was taken in
when was the award passed when was it paid
1997. For that I need to show 93B, section 93B of the amendment of Act 1. 93B relates back to 41A. Here 41A was issued in the year 1997. 1976 to 1997, they got the rent compensation, and on the date of 1997, that is 31st March 1997, Malad, the
what was the area
The area I'm telling you.
10 days.
neither of you can tell the area
Malad, no.
the
Malad,
person who
I
got the
have-
award
I have
cannot
marked-
tell
Malad, I
the
have
person who's
marked-
suffering the award cannot tell the area so let us find out the area
0.21 decimals.
So that is 21 decimal 0 point is used as a
Yes.
normal
21 decimals.
21 decimal
Yes. Part is Shali and part is Khal.
Kindly come to page 51.
Page 51.
Page 51.
This is page 51.
Upon acquisition of total 29.75 acre land.
Yes, that
That
is the total area.
Total area.
Total area.
In respect of his undivided 1/4 share.
In respect of this land loser, only 0.21 acres or 21 decimals.
একজন এসছে এখানে। What is the amount payable to him enhanced amount
Now 57.
Approximately, Malad, as per the LA judge's order, Malad,
56 lakh
56 lakhs. Malad, which is, Malad, I need to show, Malad, that's palpably wrong.
Mr. Bhattacharya, let it be deposited, it will bear interest. If you win the appeal, if they lose the appeal, then you'll get them. Not no disbursal at this time. We'll discuss it. Try good. Can 2 of 2024 has been filed for stay of further proceedings in the court proceedings in execution case number 01 of 2023 arising out of LA case number 167 of 2008. Full stop. In the said LA case, comma, enhanced compensation was granted to the respondent stroke land loser. Full stop. Next para, learned counsel appearing for the appellant submits that the premise on which the enhancement was made is palpably contrary to law. Full stop. It is further submitted that the appellant state is willing to deposit the enhanced amount in court, comma, subject to grant of stay. Full stop. It is further contended that the original awarded amount has been disbursed to the respondent. So next para, learned senior advocate appearing for the respondent submits that the awarded amount is a paltry sum of about ₹7,000, which is grossly insufficient. It is further submitted by placing reliance on a coordinate bench unreported judgment dated March 23, 2015, passed in FAT 77 of 2013, comma, that in the said case, comma, in similar circumstances, comma, 40% of the deposit made by the state was permitted to be withdrawn by the land loser therein.
That matter, my learned appearance kindly consider. In that matter,
Yes,
my learned appearance.
maybe.
But he.
More important than his appearance is the judge's judgment. Upon hearing learned counsel, comma, we find that in the present case, comma, however meager, comma, the original awarded amount had been disbursed in favor of the respondent land loser. Full stop. Furthermore, comma, in the cited judgment, we find that the coordinate bench recorded that in case the deposit was made by the appellant, comma, the respondent therein was permitted to withdraw 40% of such deposit. Full stop. However, it was also categorically observed that such permission for withdrawal was given to the respondent as he had not been paid the compensation amount till that date, though possession of his land was taken over by the government in 1977. Full stop. Next para. Since arguable issues have been raised in the present appeal, we are of the opinion that the same should be heard on merit. Full stop. Next para. Thus, a prima facie case for grant of stay has been made out by the appellant state. Full stop. The question as to whether the amount directed to be deposited as condition for such stay is to be permitted to be withdrawn by the respondent, however, is circumscribed by the observation of the cited judgment of the coordinated court to the effect that in that case, no awarded compensation had been paid at all, contrary to the present case, where the awarded amount has been actually paid to the respondent. Full stop. Next para. Since it would be difficult for the respondent to withdraw the amount by securing the same by way of adequate bank guarantee, as the same would tantamount to nullifying the purpose of the withdrawal, we are not inclined to grant any permission to withdraw at this stage. Full stop. However, needless to say, the stay should be adjuncted with a direction on the appellant to deposit the entire award enhanced amount which has been impugned herein. Full stop. Next para. Accordingly, Can 2 of 2024 is allowed on contest, thereby granting stay of all further proceedings in execution case number 01 of 2023 arising out of LA case number 167 of 2008 till disposal of the appeal. Full stop. Such stay orders shall operate unconditionally for a period of 4 weeks within 4 working weeks, within shall operate unconditionally till January 15, 2025, within which the appellant state shall deposit the entire amount, enhanced amount, which has been impugned in the present appeal with the Registrar General of this court. Full stop. In the event such deposit is made, the stay order shall operate till disposal of the appeal. Full stop. In default of deposit of such amount within the period as stipulated above, the stay order shall stand automatically vacated and the respondent shall be entitled to proceed immediately with the execution case. Full stop. Next para. As and when such deposit is made, the Registrar General shall invest the said amount in a short-term interest-bearing account deposit with any nationalized bank. Full stop. Such deposit shall be subject to the outcome of the appeal. Full stop. The appellant shall prepare, in view of appearance of the respondent through learned advocates, service of notice of the appeal is dispensed with. Full stop. The appeal be otherwise treated ready as regards service. Full stop. The trial court records be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. So the liberty is given to the parties to mention the appeal for hearing, for enlistment for the purpose of hearing, as and when the same is made ready for hearing. প্রথম সেন্টেন্স একদম এফিডেভিট অফ সার্ভিস ফাইল টু বি কেপ্ট একদম
One submission.
Yes, Mr. Bhattacharya.
One submission, the appeal has been preferred by the state. Under section 54, appeal cannot prefer by the
By the state?
By the land acquisition officer, he has to file appeal.
This has been state generally, not through land acquisition officer.
Through land acquisition officer. State cannot be represented by the land acquisition officer. It is under the rules.
At a line at maintainability.
Secretary, they are the persons to represent.
It is made clear that the question of
appeal should be dismissed.
It is made clear that the issue of maintainability of the appeal as raised by learned senior advocate for the respondent is kept open for being decided at the final hearing of the appeal.
Could have been dismissed here and now, all right.
You take the point after the application is disposed. That is the difficulty, Mr. Bhattacharya. That should have been the first point you have taken.
I was afraid of SS. I have not taken the point.
Your fear is their advantage. Next.
I'm for the rest. Matrimonial appeal by the wife, husband getting a decree.
What? Repeat?
Matrimonial appeal by the wife, husband got a decree.
Oh, achha, achha. I thought matrimonial suit, your suit, he got a degree. Thank God. Divorce has been refused.
No, granted.
Divorce, his divorce suitor. So very well, now what is the application for stay of operation? Not stay of operation, or will injunct them from marrying?
But only one thing, Lord, I have a point of maintainability. If your Lordship takes up the judgment in the memorandum of appeal, point number 44, Lord, at page 14 of the judgment, Lord, your Lordship, Lord, may I just remind your Lordship, Lord, the dimension of cruelty now, Lord, after Shamor goes, this Honorable Supreme Court has made it clear that if the Lord relationship has gone to such an extent, the parties are living together, not living separately for such a long time, it has become deadwood, then it amounts to cruelty. There is an admission, last 4 line of that paragraph of both the learned advocates. If that admission remains on board, relying on this admission,
there are other contrary judgments, Mr. Mukherjee, which says after Shamar Ghosh, I can't recollect the citation. I am very poor in memory, but there are judgments which have been cited before us, which say that yes, irretrievable breakdown between the parties can tantamount to cruelty. We have also said that in cases, but it has to be seen whether that cruelty can be attributed to one of the parties.
Correct.
If it's both ways, Mr. Mukherjee, in a sense, it justifies each other. If you are cruel to me in defense, I cannot be cruel as such, but whether it's unilateral cruelty, uninstigated cruelty, that has to be seen.
That's why, if your Lordship wants,
that is arguable, very arguable. Irretrievable breakdown is not a ground.
Admission of the learned advocate, the court recorded specifically that
Admission
yes,
of the advocate,
page 44
doesn't help.
Not it's
advocate was not leading the matrimonial life.
Both the parties have canvassed before this court that the matrimonial bond between the parties has ruptured beyond repair and it has become a deadwood.
Even then, that's not a good ground.
For desertion.
That's not a good ground.
Suit for desertion, decree on the ground of cruelty. Suit simply stated on the ground of desertion.
So then,
I shall be this is not under the desertion.
Arguable. Don't remarry.
Well, I can show from the plain.
The present appeal has been preferred against. Have you remarried?
Both.
That's
right. That is not the arguable case. That's it. Not only one thing. The
framed on the ground of
wife is
is
on
desertion. Suit simplicity on the ground of desertion.
Suit file ko print desertion.
The wife is working as a air hostess in Emirates.
Alimony application is also there.
No, not alimony. What I suggest, since the parties are in separation for quite a long time. It's from 2008 onwards. They are living separately. And
no issue. No issue.
One girl, she is at the hostel in Bangalore.
Age,
it's now it's about 14 to 15 years. So if we can venture, if I am suggesting something, if subject to,
if you allow, we can grant injunction and direct mediation.
For that, since
both of
I
you
believe only with regard to the money that is now required to be adjudged. Both of us is working. It's not that.
I will retire next year. I will retire next year.
From Emirates, she will retire. What that we can short out.
No, that can be.
I will not file any application for maintenance as of now.
No, not that. Mr. Lahiri, you take instruction whether it could be. We'll grant injunction right now, but whether it can be sent to mediation with that.
The trial court granted 30,000. I am paying towards my daughter.
The present appeal arises out of a divorce decree obtained by the respondent husband on the ground of cruelty. Full stop. We find from the arguments of parties that several arguable issues are involved, and as such, the appeal should be heard on merits. Full stop. In view of the nature of the suit, we are of the opinion that if a stay of operation of the decree is granted, it would tantamount to staying a judgment in rem comma, which we are not inclined to do. Full stop. However, comma, we choose to mold the relief made in the prayer portion of the application, and in order to save the appeal from being rendered infructuous before it is heard out on merits, comma, are inclined to restrain the husband from remarrying in the meantime. Full stop. Accordingly, can 1 of 2024 is allowed on contest, thereby restraining the respondent husband from contracting any second marriage in the during pendency of the appeal. Full stop. Next para. In view of the appearance of the respondent to learned advocates, comma, service of notice of the appeal on the respondent is dispensed with, and the appeal is treated as otherwise ready for hearing, otherwise ready as regards service. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant to be deposited along with other requisites, if any, within a week from date. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 8 weeks from the date of service of notice of arrival of the trial court records. Trial court record date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Next para. Liberty to the parties to mention the appeal for hearing after the same is made ready for hearing. 8 weeks you are giving. If you complete within 4 weeks, you are at liberty to mention. Do it.
And we'll talk about the second.
We'll just should we direct mediation, because you don't have instruction right now.
But we will talk.
It is made clear that since the respondent contends that the marriage has broken down irretrievably, comma, we leave it open to the parties to resort to mediation in the meantime, in order to explore the options, comma, either to stay together or part ways. Full stop.
My lord, in this matter, I am for the appellant.
Yes, Mr. Mahathur.
My lord, this is for application for injunction.
Yes.
My lord, suit is for partition. It is second suit. The first suit for partition in respect of the same property amongst the same parties were dismissed because, my lord, they did not pray for any cancellation of the deed. They did not pray for cancellation of the two deeds. Therefore, my lord, the earlier suit was dismissed, and my lord, arising out of that, I filed an appeal because I was defendant there, but because, my lord, it was held that the deeds have not been properly explained. Challenging that observation, I have preferred an appeal. That appeal is pending before your lordship's court.
Finding against finding, Mr. Mahathur, no appeal lies. So your appeal will get dismissed. Don't worry about that. Don't try to expedite that appeal.
No, I am not trying that, my lord. They have filed a subsequent. They have filed the second suit for partition. My lord, it is barred
a continuing cause of action, but they now want a declaration.
Cancellation of the deed. Cancellation of the deed. Upon cancellation of two deeds, which have been, my lord, dismissed in this earlier suit.
That is not time barred, Mr. Mahathur, according to you. The cancellation
cancellation part is, my lord, time barred, and another thing is, my lord, order to rule 2 is also it is a bar. Earlier suit, he did not pray for, my lord, cancellation of the two deeds. Therefore, his prayer suit was dismissed. Now, my lord, his second suit is not maintainable under order to rule 2, and my lord, that is also time barred. My lord, this is the points, my lord, required to be adjudicated in this appeal.
Now, what has been done? The preliminary degree has been passed.
Preliminary degree has been passed.
So it has been declared that the deeds are bad.
Deeds are bad. Null and void. It is binding.
Then we'll stay that portion of the decree, and the rest of the partition suit will proceed. No final decree.
Well, the plaintiffs have no other say. Only by two deeds, everything has been covered.
Oh. Then you have sought for injunction. You have not sought for
yes,
stay.
I have prayed for injunction.
Grant injunction. Definitely grant injunction. The present appeal has been preferred against the preliminary decree of partition. Learned counsel appearing for the appellants argues that this is the second suit for partition. A previous suit for partition was dismissed, inter alia on the ground that the plaintiffs stroke present respondents had not prayed for cancellation of two deeds,
My lord,
by virtue of which the plaintiffs allegedly derive title to the property. Full stop. Next para, it is submitted that apart from being time barred, the prayer for cancellation of the deeds is also barred by the principle incorporated in Order 2, Rule 2 of the Code of Civil Procedure. Full stop. Next para, such contentions are controverted by learned counsel for the respondents. Full stop. However, we find that sufficient prima facie case has been made out by the appellants to hear the appeal on merits. Full stop. Next para. Accordingly, can 1 of 2024 is allowed on contest, thereby restraining the only plaintiff respondent.
Plaintiff respondents.
No, there
Plaintiff
are,
respondent.
I am on 1, 2 minute, 1 and 2.
Restraining the plaintiffs respondent numbers 1 and 2 from changing the nature and character of the suit property in any manner and stroke or from transferring, alienating and or encumbering any portion of the suit property in favor of any third party till disposal of the appeal. Full stop. Next para. The service of notice of the appeal on the respondent numbers 1 and 2 is dispensed with in view of appearance of the said respondents through their learned advocate. Push up. Next para. However, the appellants shall put in requisites for service of notice on the defendant numbers 1 and 7 being respondent numbers 3 and 4 herein. Full stop. Next para. The trial court records shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. Full stop. The trial court shall be entitled to retain a skeleton copy for proceeding further with the final degree proceedings. Full stop. Next para. The appellant shall also prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival on the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing.
My lord, injunction in respect of the nature and character, and my lord, the transfer.
Yes.
But so far the possession is concerned, my lord, let there be an order of injunction.
Possession, Mr. Mahato, we are not sure who is in possession. So we'll not grant that. You have not prayed for possession. Possession, have you prayed?
Yes, I prayed, man. The first prayer is, my lord, possession.
Possession, Mr. Mahato, it's risky. I mean, we are not refusing it.
Earlier suit was dismissed. My lord, kindly consider that. Earlier suit for partition was dismissed.
But we don't know who is in possession. That remains, that position remains. Prima facie case, you have got a strong prima facie case. But possession, we are not sure. And status quo, we are not a believer in status quo without
they have prayed for, my lord, not that they are in possession of in respect of the entire property. They have prayed for, my lord, their share. Therefore, according to them, it is joint property. They have prayed for, my lord.
Yes, very well. যেখানটা dispose of বললাম তারপরে বললাম যে সার্ভিস অফ যেখানে ক্যান ওয়ান ইজ অ্যালাউড বলে সেন্টেন্সটা শেষ করলাম ওখানে অ্যাড করে দিন দ্য পার্টিজ শ্যাল অলসো মেনটেন status quo as regards their respective physical possessions with regard to the suit property.
Grateful to us.
Thank you.
I'm grateful to us.
Next.
And for that, there is a section 5, there is a delay of 975 days. The notice of this application not yet been sent.
The appellant shall serve copies of Can 1 of 2024 as well as Can 2 of 2024 on the plaintiff respondent only. No, you are asking. No. This is a suit for partition. Then all the respondent. On the respondent number 1 as well as the pro forma respondent number 2, indicating that the matters that the application shall be listed for hearing on January 9, 2025, when an affidavit of service to that effect shall be filed by the appellant. Both the applications, 1 and 2. Yes. Are you related to Mr. Supreme Noskar? Look alike, yes. Item number 27 and let it be called on 28 এখন 29 28 কি হলো আচ্ছা 29 টা take in, yes. 29 similar. What is the difference? Why 2?
Here is the Maya Mondol is the applicant and
Respondent is different.
In 27
29 file দিন
she is the pro forma defendant.
Arising out of the self same judgment.
Yes, sir.
29 এ হচ্ছে আর কি ছিল pro forma respondent ছিল সো এখানে plaintiff
সেম অর্ডার সেম অর্ডার যা আগেরটা হলো সঙ্গে একটা লাইন অ্যাড হয়ে যাবে the present applications shall be listed along with can 1 of 2024 and can 2 of 2024 filed in connection with FAT 290 of 2024, which is the other appeal. All 4 will appear to 28 will take up after the recess. After the recess. Yes.
Appellant before your lordship was a defendant in a suit for partition, a suit for declaration with an alternative prayer of partition and permanent injunction.
Declaration of what? Regarding some deed?
No.
Title? Yes.
But it's admittedly, your lordship, it's a joint property, 13 decimals of Bastu land.
You are challenging a preliminary decree.
Not the adding trim order being passed, my lord, the order of status quo.
Appeal has been admitted.
No, my lord, there is a delay of 45
Delay of
days.
45 days.
However, I have obtained instruction. I do not object the.
No, but do you have determination? Is it from the civil court?
Lord,
Not from city?
Valuation is
What is the district?
district, your lordship, Hooghly.
No, then we don't have determination to take up the order 41 or connected applications. You have to go before Justice Tandon's jurisdiction. Let the matter go out of the list due to lack of determination with liberty to the parties to mention for enlistment before the appropriate bench having determination. You have to go to Justice Tandon's. Yes, please.
Because it is that matter, my lord, where an appeal is arising out of a matrimonial suit, my lord.
Section 5, they want to use an affidavit. They say that they have remarried. Do they say that? Have they given any copy of the opposition to you?
No, my lord.
They have to file opposition.
Not yet.
What is the delay?
It's a delay of 55 days.
What is the reason?
Lord, she was contacting the lawyers for that reason. Also, my lord, there was a revision preferred in the interagnum. And if my lord sees,
Why division?
that was a mistake on the part of my advocate on record. my lord.
That mistake
For
is
want of
unpardonable.
jurisdiction, it was dismissed. And my lord, the order-
Division against the final decree. It's against a decree for divorce.
Yes, my lord. The divorce decree was granted on 24th of January 2024. And my lord, the revision was preferred with a 2 days delay on 26th of April 2024.
So total delay, including everything, is 55.
55 days.
After the revision was filed, it was dismissed by the.
Dismissed, naturally,
the
it was dismissed by my lord Justice Bishnojit Basu.
Have you annexed that
Yes,
order?
yes, my lord, it
So
is
that
annexed on the stay application, my lord, can 2 of 2024, page 78. My lord will find the. But however, my lordship made a partial observation on the merits, my lord, that
আমি দেখে নিচ্ছি।
for want of jurisdiction, it was dismissed.
ও ওটা বলছে অ্যাডমিশন হয়ে গেছে। Total judgment is not there. How do you file this second judge's copy?
There might be a clerical mistake.
What clerical mistake? The law ordering portion is not there in the second judge's copy. How can we even take up the appeal?
Even in this copy also, up to 3.
Both the copies up to 3 pages.
Or nullity জন্য আটকে
There must be a clerical mistake, my lord. I do my apology on behalf of my learned advocate on
Did not
record.
intend to carry on a marital relationship. She had no objection if a degree of divorce is passed. Oh, decree cannot be passed on admission.
My lord.
Section 5 টা allow করে দিয়ে কালকেই অ্যাপিলটা হিয়ারিং এ রেখে দিচ্ছি। ও আপনি থাকবেন না, এনিওয়ে আমি রেখে দিচ্ছি কাল।
But I have denied and disputed all the allegations as well in the written statement.
So there is no admission as well.
But there is an admission. If my lord sees the written statement for one,
Let us see that.
so that your lordship. But I am not objecting to the divorce, but only my lord.
No, you cannot do that. It will be collusive. Then 13B has to be filed.
Yes, yes, absolutely. There was a mistake on the part of the learned advocate there as well.
Yes. Which paragraph of your written statement? Admission?
Yes, paragraph my lord 29 my lord.
This is on the ground of cruelty only.
Lord, kindly gives me a moment, Lord, I'll just show. Lord, the written statement is at page 30.
You have found the written statement. Page 42 is paragraph 29.
Paragraph. Lord,
You have denied. You have said it is false to state that there is no hope of reunion.
paragraph 38.
30?
Paragraph 38.
Page 46, paragraph 38, internal page 15 of the written statement. Lord, may I read out to your lordship?
Unpleasant, yes, you have seen. It does not want to carry out.
In
But you have
favor
to
of-
file a 13B then.
Yes, my lord. Lord, either let me contest in the suit or, my lord, I'll go for a 13B.
No, we'll set it aside and send it back. I mean, they have to be present for that.
My lord. My lord, he was present, my lord, my learned other side, my lord.
We're allowing the section 5. We're asking you to give you a notice. We'll keep the appeal for hearing tomorrow. We'll keep the
Well,
matter
I'll
as
serve
for
the
orders
notice.
tomorrow. Yes.
Lord, for orders.
For orders, we'll dismiss the appeal, allow the appeal. We'll just record that. First, let us allow. By an order dated December 3, 2024, comma, it was recorded that the learned advocate for the respondent sought to use an affidavit in opposition to the application for condonation of delay. Till date, comma, however, comma, no such opposition has been filed, comma, nor any copy has been served on you. Nor any copy has been served of any proposed opposition to the learned advocate for the appellant. Even today, comma, at the time of call, comma, none appears for the respondent. Next para. We find from the averments made in the application for condonation of delay that the appellant had initially, comma, by bona fide error, comma, preferred a revisional application which consumed some time and thereafter took time to draft and have the appeal filed. Next para, being satisfied of sufficiency of the reasons for the delay, comma, we are inclined to condone such delay. Accordingly, can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring FAT number 309 of 2024, which is accordingly deemed to be in order and registered. Next para. Can 2 of 2024 is taken up for hearing. We find that the very brief conspectus of the appeal is that the trial court granted a decree for divorce on admission, which is bad on 2 counts, niche Roman 1. There was no admission on the allegations of cruelty on the part of the appellant wife, Roman 2. No decree for divorce can be granted on admission as such, comma, unless an appropriate application for divorce by mutual consent under section 13 capital B of the Hindu, this is a Hindu marriage, of the Hindu Marriage Act is filed by the parties and the necessary timelines stipulated therein are complied with. Hence, comma, it appears that the appeal itself can be disposed of on such short point as indicated above. Indicated above, comma, on the papers which are already on record. Next para. Accordingly, we dispense with service of further notice of appeal on the respondent and other formalities, as well as observe that the trial court records need not be called for. The appeal is otherwise treated to be ready for hearing on the memorandum of appeal as well as the annexures to the connected applications. Let the matter be listed. Let the appeal be listed for passing final orders under the heading for orders tomorrow. A notice to that effect shall be served by the learned advocate on record for the appellant on the learned advocate on record for the respondent. Please give a notice immediately, file a receipt tomorrow.
By today, my lord, I'll serve.
Yes. If they don't appear, we'll pass a decree. কখনো হয় না আপনি কখনো দেবেন বিশ্বাসযোগ্য
Item number 31, my lord.
Yes.
For the respondent in this matter. But,
Right.
There are, my lord, can number 3, it is for, my lord, modification of, my lord, an order passed by mistake. Application.
Modification of different bench.
Modification of an order passed by different.
What sort of modification?
My lord, there was an order for, my lord, taking out the child.
This is the misappeal against custody.
Guardian. Section 25.
You're the mother.
I am the mother. Order matter was disposed of, directing me to hand over the child.
His application. His proceeding.
His proceeding.
The case was filed by him.
Case was filed by him.
So custody was granted to him. Full-fledged.
Custody was granted to him without any evidence.
All right.
Now, my
According
lord,
to
I
you.
preferred an appeal.
Yes.
No, admittedly, there was no evidence.
Acha. Very well.
Now, my lord, I prefer this appeal. My lord Justice, the division bench presided over by my lord Justice Tandon passed an order that he will take out the child every, my lord, Saturday, every Saturday and following Sunday he will return back. Now, my lord, 30th of April, my lord, I have annexed in Can C. This is the order.
21st of March order?
Yes, yes. 21st of March was first order.
Yes.
Thereafter, that was modified on 30th of April.
So the child was to be taken how frequently? By the first order?
Saturday?
Every Saturday?
Every Saturday and the following Sunday he will return.
Acha. Very well.
Now, my lord,
30th of April order we don't find in the records. Anyway, let us see the application. Can 3?
Can C, my lord.
What a record is থাকা উচিত. Which page?
Last. Last and last but not least.
Yes. Yes.
My lord, my predicament is that my lord, the child is facing, my lord, tremendous pressure. by
Child is a girl or a boy?
Girl of 13 years, presently my lord, studying in class 7. My lord, page 14 of my application is a letter. Page 16 of my
So let us
application.
see the order first. Let us see the order. What was in what order first? So for summer vacation, that same arrangement was continued. Originally, the first order was Saturday he will take, Sunday he will return, Sunday evening. The father may take the child from custody before afternoon of each Saturday and shall return the same arrangement was continued. What is the modification? During summer vacation, that is the difference.
During summer vacation, but subsequently, my lord, kindly comes to my lord, page.
But that order was the previous order also.
Previous order also. Page 16, my lord.
Both parties shall ensure study is not hampered. Page 16.
My application.
Priyanshi is the daughter? Yes.
Same handwriting to the life of you.
To the officer in charge. She lodged a diary.
Minor.
Anyway, what is the content of this?
The content is that, my lord, she is being pressurized when she is taken out by her father. Now, my lord, the father pressurizes him that he will lodge several criminal cases against the mother. And, my lord, not only that, my lord, there is, my lord, as per this, my lord, page 16, my lord, his curriculum classes, there are lots of curriculum classes and his regular studies also. This is the predicament of the child. Now, my lord, if he comes to my residence and take visitation, my lord, I don't have any problem. I will not stand in the way. This is the, my lord, only modification.
What is your stand?
The first thing is that, my lord, this order was never complied. First thing is that Lordship will kindly records my.
You are not permitted to take the child.
Nothing, my lord. Abusive languages were used.
But previously, when the first order was passed, you were permitted.
I only went for 1 day, my lord. After that, my daughter, my lord, was living with me for 1 day, my lord. There's no problem.
Why was a modification required? The summer vacation same and
because
why was it required? Because during summer
they
vacation
want
it
to
was
stop. They want to stop because, my lord, the direction was given from Saturday to Sunday.
Achha,
They want to stop that. For that reason, they have filed a modification application.
Oh, that was disposed of by retaining the same arrangement.
Retaining the same one. Now, my only problem, Lordship will kindly see, is there is an order of this honorable court 3 times passed. There were also orders of the learned Judge Mala who has passed sitting in section 25 order of this. He has also, Mala, in his chamber, the daughter was bought, Mala. That is also recorded in another order, my lord. My only, Mala, prayer before your Lordship is that, my lord, whatever the problem, my lord, am I not entitled to, my lord, take my child for a day?
Who else are there in your house?
My mother and I live there, my lord. And she is happily, he was residing with me. But complaints, my lordship knows, 15 and 16.
Custody order was granted by the trial court. Was that complied with at any stage? Implemented?
Nothing. Never.
After that, they filed this appeal and this order.
2019. Till 2019, we are living together. After that, the wife left with the daughter. So,
2019, what was the age of the child?
Today is 13 or 14 years. So, if I take 6 years back, so 9 years. So,
5 years back. 10.
So, she was already, my lord, I had a very good.
From 0 to 10, she was with you.
Yes, yes.
The wife was also
Yes,
with you.
yes. 2019, they
2019, my lord.
They parted.
2019, they
There is no divorce suit.
divorce. I mean, well, I don't have any instance where the divorce has been filed. So my
Why
today,
can't it be reconciled?
well, I
Come
have
and live with the husband if there is no divorce suit. We are not compelling you, but why don't you come back?
regard to divorce suit, my lord, I don't have any instruction of that.
Don't file tomorrow after having being advised.
well, only,
Not that. Our intention is the contrary.
My lord, 125.
There is no divorce suit. There is still chance of reconciliation.
125 proceeding is there, my lord.
13-year-old girl, why pull a tug of war with her? I mean,
and my lord, 14 and 15, my lord, the lordship sees same handwriting. Well, I'll just show before all the same handwriting.
14 and 15
Yes, 14,
are by the mother.
yes, 14 is by mother and 15 and 16 is by the daughter. Same handwriting.
Yes, yes. Yes.
My lord, the
Should you
signature
direct
of
the child to give her handwriting? The same thing will dictate her, she'll write.
No, my lord, this is the version, my lord, so far as, my lord, the child has written. Otherwise, she could not have, my lord, signed
Child
the
has
document.
written the version for the mother also.
No, the signature, my lord. The signature is different.
The written may be by some other person, but signature by her.
Signature.
Mother became the scribe.
Without attesting witnesses.
Well, I'm the
No,
last
no
person.
modification.
My lord,
Stop. বাবার এগেইনস্টে সেখানে এই অ্যালিগেশন তো সেখানে আদারওয়াইজ কোনো অ্যালিগেশন বাবা তো নিজের মা পাশে নিজে চান খাই
my lord, problem for the child, my lord. In the last order also, my lord, it was written. It was observed.
You keep yourself a bit aloof from this. I mean the mother. I mean, if you intrude too much, this problem will persist. The very purpose of this visitation right is to, because the trial court granted custody. If we affirm that, then the child goes forever with him till she's a major. We are still considering this visitation. You cannot take that away.
My lord,
I mean,
he
the child
he can
and the
assume
mother.
visited my residence, my lord. There is no, my lord, issue, my lord.
Why? You come to her residence, his residence, and you stay outside when no, for one day you cannot. No, we don't find any reason to deviate. This is not sufficient. This appears to be manufactured. One same handwriting, no explanation as to whose handwriting.
No, my lord.
What have you written about the, let us see the pleading in your application regarding that diary?
Which,
Yes, yes. And child and you made the same complaint. Let us see page 14.
No,
Let us see.
even different date, my lord. 12th of May is the mother.
Child does not give a date.
Well,
Child's complaint does not carry a date.
82, my lord, the next page, my lord, the GD.
GD number, no date is given. By the child, no date is given.
No, my lord, the page
GD might
17,
have
my
been
lord, is the postal receipt by which, my lord, that was said.
Yes, obviously.
21st of May.
Then it was done at your home. If the GD was sent by post, then not the police officer. It is not the police officer who writes. Somebody, the same person, writes in your home, and you send it by post. Ridiculous. Definitely not acceptable. বুঝতে পারি লিখে তারপর লিখে দিয়ে সই করে হ্যাঁ অন কনসেন্ট অ্যাডভোকেটের কনসেন্ট সেই জায়গাটা একটু প্রবলেম আছে
Now, at page 13 is the GD number 1408 dated 18th of May 2024. Subsequently, it was said to send on.
And you did not oppose the prayer. No, they said this is a subsequent. Consent দিয়েছিল
Yes, at that time, my lord, I did not oppose. At that time, I did not oppose.
We have written at the time of hearing before the Honorable Court, the appellant consented to the proposal for one day stay of the child with her father.
এটা সাবসিকুয়েন্টলি হচ্ছে বলছে কনসেন্ট দিয়েছিল তারপর দেখছি এই প্রবলেম হচ্ছে কিন্তু দিস ইজ নট ক্রেডিবল সরি নো
Yes, 13, my lord, is the GD bearing the date and number, my lord. No, 12th is the mother. 12th of May.
All the
Thereafter, my lord,
GDs were
18th of May.
all the GDs were registered by post.
No, my lord, page 13 is the GD, my lord, annexing the police station stamp.
Well, the date is not matching with the slip. The date is 17th, Mala, it's 21st May, and GD is Mala on
It was
14th.
posted.
18th
It was
May.
addressed to post.
21st May, where do you get 21st May?
Mala, that at 17,
17
page
is
17.
21st May. That was sent by post.
Yes.
Now, my lord, page 13 is on 18th of May 2024.
And Mala, GD, if Mala, my learned pen Mala shows the page 13, then my 18th May is the date.
18th
So
May
Mala,
is the
it cannot be Mala prior. Prior কি করে GD হয়ে গেল? তুমি complete
12th May, what happened? Page 12.
12th May, my lord, page 15.
What is that?
By the mother.
What is that complaint?
Mother, my lord, page 15 is the complaint.
No, okay, page 14.
Page 14 is the complaint. No, there are two
14 is the
complaints.
complaint.
Acha, page 14 and 15, two complaints, two dates. 12th of May.
12th of May.
Let us see those complaints. 14 May, নিজের কথা same allegation. Same allegation. Sorry, this is doctor. Yes. Can 3 of 2024 has been filed for modification of an order dated April 30, 2024, passed by a coordinate bench, whereby, comma, on consent of learned counsel for the appellant wife, comma, an arrangement was made to the effect that the respondent father may take the minor child, comma, regarding the custody of whom the present matter arises, comma, from the custody of the mother before the afternoon on each Saturday, and shall return the child to the mother before the afternoon on following Sunday. Full stop. Both parties were directed to ensure that the study and other extracurricular activities of the child are not hampered in any manner, and shall respect the wish of the child in the event she intends to go back to the mother even on Saturday. Full stop. Next para. The present application alleges that subsequent to such consent being given, comma, it was noticed that the child was having difficulties in the visitation. Full stop. Next para. From the nature of the complaint purportedly made by the minor, comma, which was sent to the police by registered post, comma, it transpires that the plinth of the issue between the plinth of the issue is that her extracurricular classes are being affected, and that the respondent father threatens that he would initiate criminal proceedings against the mother stroke appellant. So further, comma, the child has purportedly alleged in the complaint that the respondent father, comma, while taking the child from the mother's home, comma, abuses the mother stroke appellant and the maternal grandparents of the child, and shouts abusive language in front of the neighbors. Full stop. Next para. Learned counsel appearing for the respondent points out that two previous GD entries lodged by the appellant mother tally in respect of handwriting with that sent by registered post allegedly by the minor daughter. Full stop. Accordingly, comma, a presumption can be drawn, comma, it is argued, comma, that the same person was the author of all the complaints. Full stop. It is argued that in the garb of such complaints, comma, the visitation rights granted to the respondent father are being hampered by the appellate mother deliberately. Full stop. It is submitted that in reality, comma, the issues sought to be raised in the complaints are false and fictitious. Full stop. Upon hearing learned counsel, comma, we find that the last arrangement made by the court on April 30, 2024 was on consent of the parties. Full stop. Next para. The only change in circumstance sought to be alleged is that the father uses abusive language and threatens the initiation of further litigation against the mother, and that the child's extracurricular classes are being affected. Full stop. Next para. However, comma, the allegations made in the present modification application are not credible for several reasons. Full stop. Next para. First, comma, as rightly pointed out by learned counsel for the respondent father, comma, the handwriting in the complaints lodged by the mother with the police station exactly tally with that of the purported complaint of the child sent to the police station by registered post. Full stop. The very fact that the complaint was not lodged in the police station affects the credibility of the child actually having made such complaints. Full stop. Moreover, comma, since it was sent from the home of the appellant mother, comma, it is evident that the purported complaints were authored by the same person. Full stop. Next para. The allegations made in the two complaints lodged by the mother and that lodged purportedly by the minor child are exactly the same. Full stop. Next para. Furthermore, comma, although the child has alleged purportedly in her complaint that the extracurricular classes of the child would be hampered, comma, no iota or whisper of such aspersion was cast before the court when the earlier modification order dated April 30, 2024 was passed. Full stop. Even earlier thereto, comma, on March 21, 2024, comma, an order had been passed making similar arrangement, comma, at which stage also no plea was raised by the appellant mother as to the extracurricular classes of the child being apprehended to be hampered. Full stop. Since the child has been living with the mother as of the present, comma, it is evident that the mother would be in the know of the timings of the extracurricular activities of the child, and if there was any scope of those being hampered, comma, the mother would have evidently raised the issue on either March 21, 2024 or April 30, 2024, comma, when the arrangements were made, comma, which she failed to do. Full stop. Thus, comma, the frivolous allegations raised in the purported complaints cannot be accepted by this court to be a sufficient ground to modify the order dated April 30, 2024. Next para. We also have to keep in mind that the present appeal has been preferred against an order whereby custody has been granted totally to the respondent father. At this stage, comma, without the said order being set aside finally in the appeal, comma, the father has an underlying right of custody to the child. Full stop. Lesser rights have been granted by interim arrangements by the court merely due to the pendency of the appeal, comma, curtailing such unfettered right of custody by reducing the same for the time being to visitation only over the weekends. Full stop. Even if the said privilege is taken away from the father, comma, it would directly and adversely affect the welfare of the child, comma, which is the paramount consideration in custody matters, comma, since in such event, comma, the adolescent child would be entirely deprived of the company of his father and her father and her paternal family, comma, which cannot be congenial to her balanced development. Full stop. Next para. In such view of the above, comma, can 3 of 2024 is dismissed on contest, comma, thereby retaining the order dated April 30, 2024 passed by the coordinate bench and directing the appellant mother to strictly comply with the said order from the coming weekend.
Grateful, madam. Grateful.
What are the other two applications? Can 1 and 2 have been disposed of?
No. Can 1 is for stay. Can 2 is for my lord order 41 rule 27. since no evidence was.
Acha, order 14 rule 27 can 2. Let us just put that with the appeal. What do you want to bring in?
My lord, no evidence according to section 13 of the Guardians and Wards Act. No evidence of.
So the entire lacuna you are trying to fill up.
But if the evidence is completed, my lord, then my lord, all the things, my lord.
You want evidence to be taken?
Evidence to be taken before the court.
What evidence? Order 14 rule 27, you have to elaborate that this is the evidence I want to give. Have to be specific.
No witness was examined before the learned court below.
Order 14 rule 27 is not that. If you win the appeal, if you get a remand order, if you win the appeal and if you get a remand order, that can be a good argument in the appeal that it was granted because no evidence was adduced. Probably that was one of the considerations. If you can make that argument during the hearing of the appeal that if that was the premise of the trial court, then the trial court should have granted opportunity to adduce evidence. So this is not an order 41 rule 27. Order 41 rule 27, a specific document or evidence you want to produce as additional evidence, which the court will consider whether this would be germane, not generally asking the trial court to frame issues and will dismiss the order for 2027 application.
Application.
All right, you can do that. We'll indicate that we took this view and you not placed after that. Can 2 of 2024 is now taken up for hearing. First up, the same is couched as an application under Order 41 Rule 27 of the Code of Civil Procedure 1908. First up, however, the court formed a prima facie opinion that the general prayers of direction on the trial court to frame issues and and grant opportunity to the parties to adduce evidence does not come within the ambit of Order 41 Rule 27, but in such applications, specific evidence is required to be prayed to be adduced. First up, next para, upon such expression of the opinion of the court, learned counsel for the appellant stroke petitioner seeks to withdraw the application. First up, accordingly, can 2 of 2024 is dismissed as withdrawn. First up, stay application, if you stay the application, what do you say to stay? Subject to the visitation rights?
Well, visitation right, I should be
this will continue.
Well, I should be very candid, I have also talked with my client, my client wants at least
visitation.
Yes,
we have already
is allowing visitation.
We'll dispose of the stay application. We'll say that there will be stay of operation of the impugned order, subject to the visitation rights granted by this court, or as it may be modified subsequently during pendency of the appeal, because that scope should. We'll dispose of the can also, and then you can direct the appeal to be prepared.
Appeal can be
good ground. Can 1 of 2024 is an application for stay of operation of the impugned order whereby custody of the minor daughter of the parties has been given outright to the respondent father. Who's the next para? We find some. The appeal was never admitted.
Appeal was.
Appeal has been admitted. Must be admitted. Otherwise, how could
21st April 2024 order?
Yes, yes.
Well, we find from the nature of the appeal that in the event the impugned order is not stayed, subject to visitation rights to the respondent father, the very purpose of the appeal would be frustrated and it may be rendered infructuous. Pushed up. Accordingly, can 1 of 2024 is disposed of on contest, thereby granting stay of operation of the decree of the order impugned in the appeal bearing FMET 34 of 2024, subject, however, to the visitation rights which have already been granted by this court, and also subject to further modifications, if any, granted to such visitation rights by this court. First up, the appellant shall put in in view of appearance of the respondent through learned advocates, service of notice on the respondent is dispensed with. First up, the appellant shall the trial court records be called for by special messenger at the cost of the appellant to be deposited within a week from date. First up, all other formalities are dispensed with. Stop. The appellant shall prepare and file informal paper books without comparing with the records within 4 weeks because only the application and no evidence. Within 4 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, who have liberty to the parties to mention the main appeal for enlistment for the purpose of hearing as and when the same is made ready for hearing.
Only one indulgence, my lord. Your lordship has given an order in respect to the order given by this honorable
One
court
second.
visitation.
Arecta line at the advance copies of the paperwork shall be served on the learned advocate for the respondent by the learned advocate for the appellant.
Only lordship will kindly clarify that 30th April 2024 order may be complied with because my lord, there are 3-4 orders. My lord. For that reason, I am asking and nothing else.
Subject, can 1 of 2024 is disposed of by granting stay of operation of such and such, subject to the visitation rights granted বলেছি the visitation rights granted to the respondent father বলেছি কি বলি can 1 থেকে দেখ can 1 is disposed of
on context there were granting stay of operation of the order bearing FMAP.
The order impugned in the appeal bearing FMAT
Subject, however, to the visitation rights, which have already been granted by this court. And
by this court vide order dated April 30, 2024. তারপর continue করো সেন্টেন্সটা and subject to further.
My lord, the appearance of the respondent. My lords. My lords, am I audible?
Yes, you are audible. You are for the appellant.
My lords,
You are for the respondent.
I was appearing on the respondent, my lords.
There was a direction filed.
I am appearing for the appellant.
Yes, yes.
There was a directions to file section affidavit in opposition to the section 5 application.
Given copies.
My lord, today morning I have received the papers which would show it might that the point is in this appeal is whether the notice summons were properly served or not.
No, we cannot indefinitely delay because this is an order 9 rule 13 against what degree? What sort of a
Matrimonial suit, decree for divorce in expulsion, my lord. It was
divorce has been granted.
divorce has been granted.
We have granted any stay of the injunction, but you cannot contract marriage.
Just a day's time or 2 days time, my lord. Today morning, and it would show that the summons were properly served.
But now you have knowledge of the appeal. We restrain you from contracting remarriage. You cannot in the
On the other hand, they have filed an order 9 rule 13 before the trial court also. That is also pending. Simultaneously, both cannot run together. The appeal and the order 9 rule 13.
What is the stage of the order 9 rule 13?
That for appearance on the next date, may I hand on the last occasion also I had handed over the.
No, they can file both together. If the appeal is decided before that,
Yes, that
then that goes. There is no bar in law to file both together.
on 22nd.
Pardon, Mr. Banerjee? Your voice is disrupted. Can't hear you. Sorry. Anyway, we will extend the time for filing opposition. On the prayer of the respondent, the time for filing opposition to the Section 5 application is extended till December 18, 2024. Full of reply, if any, shall be filed by December 23, 2024, when the application shall be listed for hearing, along with the other connected application. Both applications next Monday. Opposition and reply in the meantime. Next. Yes.
There is a delay of 530 days. Order was passed on 30th March 2023. But in the absence of the respondent wife, ex parte order.
Have you served a copy on the other side? Did you direct you? Will direct you to serve copy of why FMAT? FMAT why? Registered as FMAT. How can it be FMAT? Let us see. You have captioned it as memorandum of appeal against original order. That's why. That's the wrong caption. Let us see the defect. Delay. You have preferred section 5. Impugned degree you have not.
What is the degree, Doctor? Order and decree both have been done.
You have annexed the original decree. Where is the decree? Decree has not been annexed. Only your judgment has been annexed. The order has been annexed. Decree is drawn up separately. You have got a certified copy of the decree. File it in court. Will take it on record. Will say that this defect is cured. One defect can be cured. Right? Where is the certified copy of the decree?
Original copy is with your lordship.
No, this is original order. The order only. Yes, obtain it. You unless you cure the defects, we cannot take up the application. Several defects in the appeal have been pointed out by the additional stamp reporter. First up, one of such defects, being delay, has been cured in the sense that an application for condonation of delay has been filed by the appellant. Stop. Next para. Moreover, the appellant has not classified the appeal properly as an appeal from appellate from original decree. Full stop. Next para. Leave is granted to the learned. You are the advocate on record. Leave is granted to the learned advocate on record to carry out the necessary amendment to the memorandum of the appeal by incorporating double inverted moddhe original decree double inverted clause in the caption of the same instead of double inverted moddhe original order. Full stop. Next para. Such amendment shall be carried out during the course of the day. So just quote through original order, original degree with the leave of court signature. Okay. Moreover, it is found that the certified copy of the impugned decree has not been filed with the memorandum. Push up next para. Accordingly, the appellant is directed to file the certified copy of the impugned decree within. How soon can you do it? After that. Within January 10, 2025. Full stop. Upon such decree being filed in the department, a fresh report shall be furnished by the additional stamp reporter. Full stop. Next para. Meanwhile, upon the correction to the preamble of the memorandum, to the caption of the memorandum, the appeal shall be reclassified by the department as a regular first appeal, giving FAT number instead of FMET number thereto. Full stop. Let the file be sent down to the department for such purpose. You carry out the amendment to the memorandum immediately. Take out certified copy, file it within our time, within the time given by us. File goes down to the department. এই যে শুনুন, ফাইল ডিপার্টমেন্টে চলে যাবে। যদিও আমি ডেট দিয়েছি। Please correct in both the judges.
Yes.
Item number 34. Yes.
34,
Mr. Chakrabarty,
I
you
am-
are for the appellant.
Yes, man, I am for the plaintiff appellant in this matter. But this against my preliminary decree has not been granted. Suit dismissed for partition. On the ground that there was a previous suit, there was a contention of res judicata, and my schedule is vague. That is the only ground.
What about that? What is the answer to?
That in respect to the schedule, I have made an amendment application. That was rejected. I prefer a revisional application. That is pending. I have also taken a leave under 105 of the Code of Civil Procedure.
One. Secondly, what about the other aspect?
But res judicata, lordship, that point of time, it was not complied. It's a second suit.
That point of time, CPC had not come in. What?
That it was not done.
Not done means? Res judicata.
Yes, man. In
What was
respect
not
to
done?
only that, the schedule was bad. In the previous suit.
No, res judicata.
Partition suit, lordship, I'll only
cause of
taking the
action.
recurring cause. That is the only point.
But what was the previous?
Previous,
if your title was decided against you,
no, nothing has.
Then there's
I'll
no
show it,
continuity.
at the time of my injunction. There is also a delay application also for 1 day.
Delay is also there.
Only 1 day, 1 day delay, probably.
Have both copies.
I will come back, But this can be sorted out, if my amendment application is out, I can make the schedule correct, and the suit can proceed. Only on that point,
No caveat. No caveat.
No caveat.
The appellants shall serve copies of Can 1 of 2024 and Can 2 of 2024 on the respondents, indicating that the applications shall be listed for hearing in the monthly list of January 2025. First of the appellant shall file an affidavit of service to that effect on the next returnable date. In the meantime, try to get your revision heard.
Well, that I'll try, madam.
Because you have to not press one.
Yes.
Either you continue with that or
I'll try my luck.
because we cannot take both.
Yes.
105.
Yes. Then I have to withdraw that.
Mention the matter. Mention the matter.
That 2024 matter.
No. Just mention it will come under to be mentioned heading. You say that we'll withdraw that with liberty to take this point in the appeal. Take that 5-minute matter. Who is taking a revision?
Justice Chaudhary, Basu Chaudhary, madam. Justice Raja Basu Chaudhary.
Justice Raja Basu mention this.
Yeah, he'll always.
Yes. Mention that he will withdraw. Every court will put it as to image. Yes. Next. 35.
And for the appellant, that the order impugned is an order passed under an application under Order 7 Rule 11.
Tell us first whether Order 7 Rule 11 has been allowed.
No, allowed. Order 7 Rule 11, the plaint was returned. It was held that the suit is maintainable, but it was plaint
Has
was
it been
returned.
admitted? This is the city civil court.
Yes.
City civil court. Good.
So,
Yeah.
my lord, the fundamental point that I also argued in the court below was that they had raised many points in the Order 7 Rule 11. All those have been decided in my favor. 7XA 1 point, which was that commercial suit. They argued the dispute between parties is a commercial dispute. So, city civil court could not have jurisdiction, and they did not indicate which court had jurisdiction. Be that as it may, I argued the point that, my lord, it is not a commercial dispute. Two reasons. One, there is a prior suit filed by them against me arising out of the same transaction. So if that
Which was a regular suit, regular court.
Before the same court, city civil court.
Achha.
So I followed him.
So what happened to that suit?
Still pending.
Pending.
I followed him. Data security, so I followed him there, and I.
Both of you parked in the wrong place. One gets a ticket and the other.
That was my first ground, and the second one was that. There is no agreement between the parties. Now, in order to frame this dispute as a commercial dispute, there should have been an agreement.
What was the suit for?
Suit for, my lord, basically it's a suit for recovery of money, my lord, on account of goods sold and delivered.
All right.
Now, my lord, there is no formal agreement. Admittedly, there is no formal agreement. The court records in the impugned order that there is
transaction is above the specified value.
No dispute.
Otherwise, everything.
There is no dispute. So, court record that there is an implied contract. It's recorded in the order. Now, my lord, court was hearing Order 7 Rule 11. It could not have been gone beyond the plaint. If the contract is not pleaded in the plaint, then the court by implication cannot imagine a contract and let's say that because there is an implied contract, it becomes a commercial suit and therefore you go to a high court.
Implied contract in the sense that there is an agreement that he would return the money.
There was no.
It was a loan.
No, I had delivered goods.
Oh,
he was
for
supposed
that.
to pay me, but there was no written contract. So I had raised bills.
So what are you enforcing?
I raised bills. So he made part payment.
Given it gratis.
He made part payment in terms of those bills.
On the strength of what are you claiming?
You
have given him some goods, he paid some amount.
Yes.
If you don't have any agreement, even implied between yourselves, you are not enforcing anything.
No, I am enforcing the
He's entitled not to return
bills which remain unpaid. The part payment
you worked in terms of some contract, must be.
That contract are the terms mentioned in the understanding was the terms mentioned in the bills, invoices.
Achha.
The terms that I will make payment within this date.
If the total transaction is above the specified value, what case do you have?
That is the reason why I did not want to argue that point very harshly. The main point that I want to actually argue is that while returning the plaint, the usual procedures that had to be followed, these Order 7 Rule 10A, none of these procedures have been followed.
To dispose of the appeal application, what procedure?
I am prejudiced because if I now have to come to High Court, my suit will be barred by limitation because I am beyond time. No date was mentioned on which the order was passed. The plaint also now does not say on which date it was presented. It was not notified to me. The court concluded the hearing and thereafter passed the order. Suddenly only on the point of return of claim.
So 10A.
10A. So 10A procedure has not been followed, admitted. I am saying that had it been followed and had I been intimated about the date or the intention of the court, I could have not come before this court, made my plaint ready and for filing before this court under the commercial division.
Suppose what do you say if you dispose of everything lock, stock, barrel and direct 10A to be complied? That will save unnecessary limitation.
Only one aspect, my lord, because my lord, limitation issue, if he's falling back on it, my lord, he should also indicate he had approached the NCLT where he had withdrawn the proceedings without liberty. So
Without?
without taking any liberty to
So
find
that is another point which can be taken. in
same
this
cause
one.
of action.
But NCLT
That
is
is
not
the
a
point you can take.
recovery
That was
proceeding.
not one of the grounds of the order.
It was treated in my order 7 rule 11.
But that's not a recovery proceeding at all. NCLT,
You don't have any cross appeal. I mean,
No, I don't have a cause.
so we'll
Anyway, your
we'll
lordship
dispose of
did
the
it.
fact that if Lordship extends my tenure
No, that
to approach that, this
that
court,
you can.
that also I'll be satisfied that way as well.
that
We'll
can't
be satisfied, but we'll be.
Yes, so Lordship will send us back. We'll go before the court. Will
We'll direct the. We'll set aside this order, not on merits. We'll say that only for the purpose of complying with the 10A procedure by fixing a date and all.
Yes.
limited remand to that extent.
Only that.
I'll get
I
the time to come before. That's the only way I'm prejudiced, my lord. That's the only reason I prefer this appeal. For
Otherwise,
honestly,
also, my lord, if your lordship
honestly, that is the purpose.
order 7 rule 10B.
Yes, at CPC. Do you have a CPC?
Yes, yes. Correct.
Oh, you have. Sorry. Modify. Asset না করে modify করে, ঠিক। Order 7.
If we take it as an application of the plaintiff under 10B, where an appeal be against an
No,
order
this is you are placing order for
order 7 rule
10,
10B.
10A. I'm placing 10A. 10B is not my case. I have not filed.
10A. Yes, right.
He's
10A.
placing 10E.
Oh, you are placing 10B.
Yes.
Yes.
The court, my lord.
We can also do that.
Yes.
Very good.
So it need not go back.
We'll do that then.
Because 10A, my lord, with the deepest of respect, perhaps, my lord, a civil court
Has to go back. Has to go back.
Yes.
In 10B.
Very good.
For the purpose of fixing a date before the appropriate
Fair
court,
enough.
that
Only for
fixation-
that. Only for that.
So Lordship is not giving me that window to approach me because other 10A,
No, under 10B also we have to give that window to you.
yes, that window I'm only concerned.
But you have to desire that by way of an application.
But by formally I can not file an application here before your Lordship.
By
but
way
that
of an
will not-
application, by an application is
Yes.
mentioned.
In-
File an application, come back.
before your Lordship.
Yes, yes. 2 or 3 days after.
Or my lord,
Or
if
what?
verbally that is permissible, then I can.
Not permissible. If it was, we cannot stretch this. If the plaintiff by an application,
I will.
by an application means tangible something.
No, yes, sir.
Or virtual something. No.
My lord, the only thing is that I know the Lordship is aware of that. My lord, the appeal is a continuation of the suit. So my lord, my suit will be contemplated to be pending till.
If
the
you
date.
fix a date for presentation of a plaint, everything gets. I mean, you're not barred by it.
Yes.
Will not say subject to limitation.
No, obviously.
This will not
enlarge the time for limitation.
not enlarge the time. But if you grant that liberty, Mr. Ghosh, it will be difficult for you. But
No,
this is
it
subject
is-
to
It
limitation.
is subject to the limitation.
No, my lord, I am
That
saying.
is why I am falling
but I
back.
am saying.
It is
limit-
not because of any
if I
other-
if I my lord was within limitation on the day when the impugned order was passed, then my lord, that day, on the next day my limitation would obviously be like I'll get 1 day to file the plaint. Here, my lord, I could not file it because the court did not intimate me any date. But on that day I was within limitation. That is my argument, and that has also been held in the impugned order itself. That the question of limitation is not appreciated. They asked this point.
That's a
It was
question of
not-
mixed question of law and fact.
Right.
according
But
to
Mr.
the-
Ghosh, section 14 is in any event applicable.
Yes, that leave has to be taken before the court, which is where they're accepting the plea.
No, that's subject to.
But we'll put something in our order that
That
it will be open to them to
and also open for me to challenge. the-
yes to oppose that, to plead.
14
section-
is the receiving court's discretion, my lord, subject to correction.
Not necessarily. 14, yes, it is, but we can make observations which will
The division-
ensure that because you filed a similar suit before another court.
That's
What is
on
your
account of
explanation?
damages. It's a claim on tort.
Arising out of the same transaction, involving the same.
It's not a
same goods,
claim.
same money.
It's not a claim arising
And
out
the,
of a
and the
transaction.
prayer is the cancellation of my invoices.
Yes.
The same invoices are now being implied as a
Take
contract.
out a similar application in their suit. It is interesting. It is a very interesting point. For the damages, I mean, tort, but
Claim
whether it's
arising out of the
arising
damages
out of the same context.
Yes. The action in tort will be maintainable before the civil court. But claim arising out of, my lord, invoices for sale of goods, it's commercial in nature, my lord. In terms of the Commercial Codes Act,
In view of several questions of law and fact being involved, we admit the appeal and the appeal shall be heard on the grounds taken in the memorandum. Full stop, next para. On consent of parties, the appeal and the application are taken up together for hearing. Full stop. The short ambit of the appeal is that the learned trial judge, by the impugned order, disposed of an application under Order 7, Rule 11 of the Code of Civil Procedure filed by the defendant respondent by treating the same to be one under Order 7, Rule 10 of the Code. Full stop. The learned trial judge returned the plaint of the appellant, plaintiff stroke appellant, on the ground that the suit should have been presented before the appropriate commercial court stroke commercial division of this court and not before the regular civil court having jurisdiction. Full stop. Next para, learned counsel for the appellant argues that there was no agreement as such between the parties to attract the provisions of the Commercial Courts Act 2015. Full stop. Next para. However, upon hearing learned counsel for the parties, we find that the claim of the plaintiff stroke appellant in the suit is premised on obligations arising between the parties from a jural relationship on the premise that the appellant supplied goods to the respondent for which allegedly the respondent did not make full payment. Full stop. Next para. The learned trial judge found that although there is no written agreement, there is an implied agreement which the plaintiff appellant seeks to enforce. Full stop. We find that the said view of the learned trial judge was one of the possible views to be taken on the facts of the case and do not intend to interfere with the same sitting in appeal, merely to substitute our own views on the same set of facts. Full stop. Also, the value of the claim is above the specified value in terms of the Commercial Courts Act 2015, which all the more entails that the matter should have been presented before the commercial division of this court.
Yes,
Then
yes.
commercial
Nominally
division
should
of
be high, because that court did not have a
commercial division of this court as per the pecuniary jurisdiction. Push up. Next para. At this juncture, it transpires from the arguments of both sides that this court may invoke the jurisdiction under Order 7, Rule 10, capital B of the Code of Civil Procedure in order to obviate unnecessary delay in sending the matter back to the court below for framing a timeline in terms of Rule 10, capital A of Order 7. Full stop. Next para. As such, we invoke the provisions of Rule 10, capital B of Order 7 of the Code of Civil Procedure. Full stop. Accordingly, FMAT
392 of 2024.
All right. FMAT 392 of 2024 is disposed of by modifying the impugned order to the extent that the application.
Yes, sir.
That subject to filing a formal application by December 19, 2020, December 18, file it by day after tomorrow.
December 18. This is about
Day after tomorrow. Day after
tomorrow.
Client
Yes, yes, but I'll
by December 18, 2024, under Order 7, Rule 10B within bracket 1 of the code, the plaintiff stroke appellant is directed to file the plaint before the appropriate court, that is the commercial division of this court in the original site, subject to the provisions of the Limitation Act 1963 on what should be not this side of the vacation. You have to present it.
On 19th, if your lordship, so
That will be too close for them.
If I file the application before your lordships on 18th.
Yes, we'll pass an order. We'll keep it for. No, we'll pass the entire order. We'll have to file the application and we'll say that we adopt that by December 24, 2024.
Very well, but 20. I would not be in town, but my junior will do it.
it's fine.
No, you settle it online. By December, that will be the same plane.
Yes, yes.
Only a few changes. December 24, 2024.
Last day.
Push up. Thereafter, the parties shall appear before the court, before the said court where the plaintiff is presented on, we'll keep it on January 6th, on January 6, 2025. Full stop. In such view of the matter, comma, the court where the plaintiff is presented shall not be required to serve the defendant with the summons for appearance in the suit, comma, unless that court, for reasons to be recorded, otherwise directs. We are just copying the language of. Push up next para. Needless to say, comma, in terms of Order 7, Rule 10, capital B, within bracket 2 of the court, comma, the above directions shall be without any prejudice to the rights of the parties to question the jurisdiction of the court in which the plaintiff is filed to try the suit. Push up next para. It is further observed that in view of the stand taken by the plaintiff appellant that a similar suit was filed previously by the defendant respondent with regard to the same transaction, comma, which is controverted by learned counsel for the respondent by saying that the same was for damages and as such is not governed by the Commercial Courts Act 2015, comma, we feel that there was existence of a bona fide doubt on the part of the plaintiff appellant in presenting the suit in a regular court as done by the respondent in their suit, in its suit, comma, instead of filing it before the commercial division of this court. Full stop. As such, comma, it will be open to the plaintiff appellant to argue the benefits of Section 14 of the Limitation Act 1963 before the commercial division of this court in connection with the suit.
I'm grateful. I'm grateful.
So, should we keep it again for order? We'll
That order
forget
needs-
in any.
That order needs to be.
Very good. The matter shall be listed on December 19, 2024 under the heading to be mentioned for accepting the application filed by the plaintiff appellant in terms of the direction given above. We'll just accept that and give a copy to them. We have not recorded.
Only one. The observations are not binding on the body on the single judge. If your lordship so pleases.
Single judge, this is
effectively allowed.
Mr. Ghosh, same court. I mean, High Court. We are both High Courts, a single judge and us.
Division.
So, even then, High Court, we act as High Court. We are exercising powers of High Court. Single judge, we are not a hierarchy, as in Bengal Agrasa. So, therefore, this is by way of an indication to the single judge. They are entitled to argue the benefit of Section 14.
That is
So, they are entitled to argue. The court is entitled to reject. Yes. Court will always.
Almost a blessing.
No. It's an indication to there is a nudge to the learned sin. It's our way of communicating because we speak through our judgments.
Absolutely.
So we have spoken through our judgments. To our colleagues.
I'll get some protection to the extent that
protection they've got.
these are
Yes.
observations but may not be bound.
No, they are entitled to argue the benefit. We cannot say that the court will grant. We cannot say that.
No.
Grateful.
Please bring a server copy of this order on the next date because I'll invariably, Justice Sen will not be there with his memory and I'll invariably forget. Just remind that this is 10B, Order 7 10B, that application to be accepted.
Great.
Thank you. Yes. You're for the appellant? Right.
The case is out of a partition suit. The injunction is granted expert injunction in the circumstances when the my lord will find.
No, but this is required to be admitted under Order 41.
Yes,
we don't have determination regarding apart from city civil code. Admission hearing has to be done.
No, not city civil code. This is from the Midnapur.
Yes, city civil code we have determination. But other districts, Order 41 after 2020, after the year 2020 is to be heard by a division bench, different division bench. After it is admitted, immediately we assume jurisdiction. So get it admitted there, come back here. Let the matters go out of the list due to lack of determination with liberty to the learned counsel for the parties to mention for enlistment before the appropriate bench having determined. এটা একটা অদ্ভুত problem. হ্যাঁ, ওরা হচ্ছে দৌড়াদৌড়ি করতে মক্কেলেরও পয়সা পাচ্ছে, বাবুদের অসুবিধা। Yes, please, Mr. Chowdhury.
Lord, in this appeal, Lord, there are number of defects, Lord. And those
So cure the defects and come
yes,
back.
Lord, the defects were cured one by one, Lord. Before that, it was dismissed for default, and it was, of course, a change. Lord. It was restored, and Section 5 was there. That was allowed, Lord.
So now that
Now,
Section
Lord,
5 has been allowed.
yes, Lord. And thereafter, Lord, we find that there was deficiency.
Revised report says judgment and degree of the trial court has not yet been furnished.
Yes, Lord.
That is the only defect. That is the defect which
yes, Lord.
persists.
I am with the judgment and degree, Lord.
Trial
Original.
court original certified copy you have.
Yes. And we have paid the deficit
Mr.
on the
Chowdhury,
last one.
ask your clerk to come.
Yes.
We'll take that on record. Ask your clerk to come, and from the side, he will just stitch it to the memorandum. Have you got extra copies of that? No, later on, that can be done later on. Let us hear the matter first. Ask him just to stitch it with the help our officers to have it stitched with the main file. Have you got the second judge's copy also?
Yes.
Thank you. Trial court judgment and very good. Yes, absolutely. It is a judgment of affirmance.
Yes, Lord.
Let us just record this. Learned senior counsel appealing for the appellants hands over original certified copies of the judgment and decree of the trial court. Full stop. Those are kept on record and we treated to be a part of the record. Full stop. Accordingly, the only persisting defect in the matter is deemed to stand cured. Full stop. The appeal is now, the second appeal is now taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Yes. Affirmance.
Affirmance, Lord. I am for the defendant number.
Right.
One defendant number 2 and 1 and 2, Lord.
All right. What is the matter about?
Number 1 and 2 is the appellant before your lordship, Lord. Now, the suit was filed by the plaintiff, claiming himself to be the owner of the property, measuring 13 decimals, which is in respect of a plot of land, Lord, which is plot number 235, Lord. The adjacent plot belongs to the defendant, Lord. The entire defendant, including the pro forma defendants, Lord, that is 236. Now, originally,
suit property is plot number 235.
235. Out of 235, Lord, there are two schedules. They have prayed for declaration of title in respect of a scheduled property, which is 13 decimals. And they have prayed for recovery of possession in respect of 1.5 decimals of land, which they allege that have been taken possession illegally.
That is Schedule B.
That is Schedule B. Lord.
That is a part of Schedule A.
They claim to be a part of Schedule A.
All right.
In the year 2002, Lord.
2002.
The suit has been filed in the year 2003.
All right.
Now, their title, the claim of the plaintiff is that title in the title is through records of right.
No title deed.
No title. Through records of right, and the records of right, they claim that it was originally recorded in the name of their grandfather, pursuant to which it was subsequently recorded in the name of their father, and thereafter in the name of the plaintiff.
Sometimes so old, I mean, if they claim by inheritance by 3 generations, sometimes, Chaudhary, we can rely on circumstantial evidence because, yes, records of right do not confer title, that's well settled. But prima facie presumption is created because if it's a 3-generation recording of names of the same family, they claim inheritance, the grandfather's title deed Might not be. How far can we trace it back?
No, I'm not on that, my lord. Now, here
One of the plausible views at least.
Yes, now the question is that, my lord,
And concurrent finding also.
concurrent finding is there, my lord. Now, the defendant files a written statement. The defendant says, my lord, that
Defendant is you two, 1 and 2
1
filed
and 2. All the defendants have filed their written statement.
separate.
Separate.
1 and 2 filed together.
1 and filed together.
And you took a stand?
3 files a separate written statement, and 4 to 8 files a separate written statement supporting the case of the defendant number 1 and 2.
All right.
Now, their case is not that this property originally belonged to Lord, one company, my lord.
What company?
I'm giving, Lord. That is in the
What is your defense case basically, Mr. Sudhir?
Lord, my case is not that we are in possession of 3 decimals of land in 235 since the time of our grandfather. Out of 13 decimals, 3 decimals we are in possession since the time of our grandfather. We have constructed our house, and that will be revealed from the local investigation that has been conducted, and also the report of the BLRO that has been a part of the record block, that is the exhibit, and also the report of the police which was conducted pursuant to the direction of the learned magistrate.
Local commission was held?
Yes, no.
At your behest?
At the behest of the plaintiff.
To see whether there is any encroachment?
Yes, no.
What was the finding?
The finding is that there is an encroachment of one and a half decimals, and there is an old building, Lord, in which the defendants are residing.
Old building within that 1.5?
Within that 1.5, which 1.5 and in which the defendants are residing.
Those have been directed to be demolished and hand over to the
yes, we have been directed to hand over that 1.5 to the plaintiff.
What is your substantial question of law?
Now, substantial question of law, Lord, that we have taken up a point that in our written statement specifically we have stated that we are in possession of 1.3 decimals of land out of this 13 decimals since our ancestral time.
You have taken that point, but that point was belied by the commissioner's report. You have a building there, but that is an enclosed building. I mean, you say that if you claim through the grandfather, and they also claim through the grandfather, it's grandfather versus grandfather basically. Both of you don't have title deeds. So equal value should be lent to both.
Yes, ma'am.
I mean, evidentiary value or presumptive value of the records of right. So you should have the same advantage. If their title is declared and you are declared a trespasser, you say that is a bad finding.
That is a bad finding, and not it is a case of adverse possession. We will also be asking for adverse possession.
Then you are gone. You have asked for adverse possession in your written statement. Adverse possession is patently contradictory to title. So you have claimed adverse possession in your written statement.
Not only that, but we have also said that we are in possession.
Adverse possession has to include possession. No, possession means adverse possession has to have possession also.
Yes, not.
So you have not claimed independent title. You have claimed adverse possession.
Yes.
Therefore, you admit the title of the other side. Adverse possession presupposes that you...
We are admitting the title of the original owner.
Unless you admit the title of the person against whom you are claiming adverse possession, you cannot have a claim of adverse possession.
Yes.
So you have a claim. So continuous hostile possession, adverse possession, have you ever seen a suit decreed or defense allowed?
But that point has not been considered at all. No issue raised.
In the written statement, where have you taken adverse possession?
Paragraph 9, Lord. If your lordship kindly takes up paragraph 9 of the stay application, Lord, at page, Lord.
Internal page number 9 of the judgment of the learned trial court. It
Yes.
said that the principal defendants were in possession of 3 decimal of land hereditary. And
Let us
plaintiff
see.
never any connection with the
Yes, where? Which application? Stay. Where is your written statement?
Page 26, running page 26 of the stay application, Lord. Lord, stay application.
Which paragraph?
Paragraph 9, Lord.
That does not contain paragraph 9. That contains paragraph 19.
19, Lord. May I place it, Lord?
Yes, yes.
অধীনগণের নিবেদন করেন যে this is the specific, otherwise there are previous paragraphs are denial, Lord. অধীনগণের নিবেদন করেন যে নালিশি সিমলা মৌজার 235 দাগের মোট 13 ডেসিমেলস এর মধ্যে 3 ডেসিমেল বাস্তু জমি অধীনগণের।
This is not adverse person. Where do you claim adverse person?
ঠাকুরদাদার আমল হইতে বসত বাড়ি রহিয়াছে এবং তাহার পুরুষানুক্রমে অধীনগণের বংশ পরক্রমে বসবাস করিয়া আসিতেছে এবং এই 3 ডেসিমেলের সহিত বাদী বা তাহার পিতামহের কোনো দিন সম্বন্ধ বা সত্য দখল নাই ও ছিল না।
So practically you have claimed your independent right.
Independent title.
Not adverse poison.
And that is not from 2002.
You have claimed, but did you substantiate?
Not kindly.
They have shown the chain arrest record extracts. They have shown that it was recorded in their name from CS records or what?
From RS records.
From RS records.
Well,
You are showing your recording. You have shown from CS RS records also.
it is not in.
You have not exhibited any records of rights.
No, only the possession that we are in possession.
Current possession.
Current
but
possession.
if you don't show, at least they have shown till CS. They were in possession before you.
The old buildings we are residing there, not that is.
Age
that
of the
will be a
buildings.
record.
Age of the buildings. You did not ask for any special appointment of expert to assess the age of the building by any
My lord,
engineer
can you
commission.
see the exhibits, Lord? I have the exhibits.
Age
One
of
is
the building we
exhibits.
cannot ascertain. What exhibit? Old may mean anything. 10 years is also 200 years is also
Lord, can you see
1000
the
is also.
exhibit once? I'm just handing over, Lord. Okay, all right. Fine.
What is the exhibit? Tell us first. In second appeal, we are not compelled to look into that.
No. And
What is the exhibit? Tell us.
the exhibit is one is not the report of the
old building. You are insisting on old. We are proceeding. We are accepting that it is an old building.
the local investigation commissioner's field report, Lord.
We are accepting that it is an old building, but old does not mean anything. It may mean anything. Rather, it may mean anything. Old may be 2 years, 10 years. 2 years
My
is
lord,
not
can
old.
you see the language, Lord?
Yes.
And this report is of 2003.
What is the language? Question of law to pachina to substantial.
Actual finding of fact. Which is affirm করেছে।
আর ও তো প্রিভিয়াস রেকর্ড প্রায় দেন ওরা সিএস মতো দেখিয়েছে এটলিস্ট ওরা থেকে পয়সা এটা তাহলে পরে ঢুকেছে কেন এদের কারেন্ট পজিশন রয়েছে মানে তো ইমপ্রুভমেন্ট হচ্ছে সেটাতে সাবস্টেন্সিয়েট হচ্ছে
No, field report.
No question of law, let alone substantial question of.
It decided that none of such documents either supported the plea of the defendant nor supported in vacating the case of the plaintiff. This was
একটা কপি দাও একটা কপি দিন
documents executed by the plaintiff. We have found that
field report কপি দিন এই তো
সব দেখি সব কত কিছু দিয়েছে দেখেছেন
বেসিক্যালি রেকর্ড অফ রাইটের উপরই করেছে
একটা প্রিজাম্পশন নিতে পারে না ইনহেরিটেন্স ক্লেম করছে দাদুর ডকুমেন্ট আমার দাদুর ডিটেইলস আমি পাবো
উপরে আর কোনো ডকুমেন্ট মানে
বোথ সাইড না দিলে তো তাহলে পেন্টিনেট বার্ডেন অফ পেন্টিনেট
Kindly, if your lordship kindly comes to page 4 of the.
You argued ferociously in the court below. It's recorded in the trial court judgment in the end of the ferocious argument of the learned counsel. We hope you don't repeat that.
I need not.
The ferocity could be one of the grounds of dismissal also.
Maybe, my lord.
Yes, please, what
My
do
lord,
you?
if your lordship kindly come to page 4, my lord, of the field report, my lord, that is a part of the investigation.
What is it?
Second paragraph, my lord. This is the report of 2003. Suit was filed in 2003, my lord. And they say that we have dispossessed them in the year 2002. At the eastern side, there is a very old north-facing mud-walled, straw-thatched Dochala residential house where the defendants live with their families. The very old north
Mud walled straw, very old may mean 1 year old after the previous monsoon. Mud wall, when it dries up, it looks old. Mud wall, very old, does not mean anything. After the next monsoon, previous monsoon.
But the language that the learned commissioner has.
Mud wall, straw thatch, very old. How old can it be?
Dwelling house. And
till the grandfather.
And prior to that, there is supporting document is also there.
You don't have anything, but let us see whether the plaintiff also could prove anything. Because the burden of proof is, both of you can't prove anything, then the burden is on the plaintiff. He has to succeed on his case. Let us see if something has been considered. Burden has been, yes, discharge is, yes. Let us come to page 23 of the trial court. Please there. At least উচ্চে বেটার টাইটেল হলে তো ইনক্রোচমেন্টটা পাবে কিন্তু ডিক্লারেশনটা পাবে না ডিক্লারেশন অফ টাইটেল চেয়েছি
ডিসকাসটা করেছি
ও বাবা এসব আছে ডকুমেন্ট জমিদারি সেটেল করেছে তাই এত বোকা হবে no
finding is there.
yes suit property originally belonged to zamindari company. It was settled by the zamindari company in the name of their grandfather who was a settled riot in such land.
নাম প্রকাশ দিয়ে repository.
Yes, entire genealogical table is there. The lineage is.
So there is a concurrent factual file.
Yes.
So far as the title of the plaintiff is concerned.
That has been pleaded, not.
No, nothing. No, nothing. Nothing in your case.
That has been pleaded, Mlad, only.
No. Come to page 25 of the trial court.
Learned trial court put much emphasis upon the exhibit 1 to 3 and exhibit 6. Sir. Read out that portion.
No, concurrent finding. We are dismissing. No substitution.
What the learned court did not consider is, Mlad, that is the only case I can make out, Mlad, that we are in possession of 3 decimals of land, Mlad.
Local inspection says otherwise.
Not local inspection also says that we are in possession. If your lordship kindly looks at the schedule also, Mlad.
You say the local inspection report says that it's over 1.5 decimal land.
Kindly see the plaint, Mlad. Kindly see the plaint in the stay application itself.
What does the plaint say?
They have given a sketch themselves.
Yes, so what?
Kindly see the sketch. It
No,
will
why
draw
should it
inference. If your lordship kindly looks at it, it will draw inference, Mlad.
What inference?
Kindly see. At page 20, Mlad. the map got of seal.
Yes. Yes.
This is the house, my lord.
Maybe. Mud walled thatched house.
Yes, my lord. 236 is the adjacent one, my lord. Some portion is in 236, some portion in 235.
Yes, that is your encroachment.
That is the encroachment, my lord.
Yes,
So
that has been
this
corroborated
is
by
the
the
portion.
commissioner's report. It has been corroborated by the commissioner's report.
So this we are saying that we have built since the time of our ancestor.
You have said that, but
And my lord, if your lordship kindly also looks at one more, that was the exhibit, my lord, exhibit C. Kindly looks at exhibit C, then your lordship.
What was
kindly
exhibit
take
C?
the decision. Exhibit C is the report of the BLLR, my lord.
BLLR report, what will the BLLR report say, sir? BLLR, that is at best hearsay. He can only have an inspection and give a report.
He has inspected, my lord.
He can only
It's
show
not
the
a
current
hearsay,
state of
my lord.
affairs. BLLR report is nothing. BLLR, what does it prove?
He has gone with the Amin and he has measured the property, and thereafter the report has been submitted.
What does it say, the report?
Very similar.
What does it say? You say first what it says. Why are you relying on? You have relied on several documents which you find entirely irrelevant.
সরজমিনে উপস্থিত ছিলেন প্রথম পক্ষ এবং দ্বিতীয় পক্ষ প্রতিবেশী ও স্থানীয় অধিবাসীগণ। সরজমিনে উক্ত মৌজার 235 ও 236 দাগে সীমানা চিহ্নিত করা হইল। সরজমিনে তদন্তে উপস্থিত ব্যক্তিগণের বক্তব্য অনুযায়ী উক্ত 235 দাগে দ্বিতীয় পক্ষ ও শ্রীমান শঙ্কর মহন্ত, শ্রীমান সমীর মহন্ত 3 ডেসিমেল বাস্তু জমির উপর দীর্ঘদিন যাবৎ ঠাকুরদার আমল হইতে বাড়ি।
BLLR now goes and says ঠাকুরদার আমল হইতে. Brilliant BLLR. He's not a BLLR, he is an astrologer actually. BLLR goes to the plot and says ঠাকুরদার আমল থেকে. You were paid more or the BLLR was paid more?
Not
BLLR বলছে ঠাকুরদার আমল থেকে.
So far as the appeal court judgment is concerned, paragraph number 19 and paragraph number 21, more specifically page 8 and page 10 of the internal page of the appellate court judgment, I find that we find that learned trial court has not only believed the factual finding as believed by the learned trial court with regard to the title. At the same time, the appellate court, first appellate court has come to a finding that you are unsuccessful in proving in submitting a single document showing your position in respect of the 3 decimal line.
Sorry, Mr. Chaudhary.
These are all factual finding and concurrent factual findings.
The present second appeal has been preferred against a concurrent findings against a judgment of affirmance, whereby both the courts, that is the trial court and the first appellate court, have returned concurrent findings as to the plaintiff respondents having title and regarding the defendants stroke appellants having encroached upon the suit property comprised of plot number 235. Full stop. Next para. Learned senior counsel for the appellant argues that the courts below failed to take into consideration the specific finding in the commissioner's report to the effect that there was the existence of a very old mud-walled straw-thatched dochala within double inverted residential house where the defendants live with their families, on the suit plot. Full stop. It is contended that the evidence on record should have been appreciated in proper perspective to hold that the defendants also are in possession of the property since their grandfather. Full stop. Next para. Learned counsel argues that the one BLLRO report was exhibited by the defendants stroke appellants, which records that the defendants were in possession of the property since the time of their grandfather. Full stop. Next para. We find, comma, however, comma, that the trial court categorically considered the entire evidence on record and came to the conclusion that exhibits 1 to 3 and exhibit 6 clearly show that the suit property originally belonged to the Midnapur Zamindari Company, which settled the property in the name of one Ramprakash Tiwari, comma, the grandfather of the plaintiff, who was a settled Rayat, R-A-I-Y-A-T, in such land. Full stop. The entire genealogical lineage thereafter from Ramprakash Tiwari through Nilmohan Tiwari, comma, the father of the plaintiff, comma, to the plaintiff, has also been narrated in the trial court judgment. Full stop. Moreover, comma, the learned trial judge held that lastly the land passed on to Gopal Tiwari, the instant plaintiff, and that exhibit 6, comma, the certified copy of the finally published LR records of rights clearly reflect the name of the plaintiff as the sole possessor of the entire 13 decimals of land in the suit plot. Full stop. Next para. On the premise of the same, comma, the learned trial judge came to the conclusion that title follows possession and the plaintiffs have title and possession in respect of the suit property. Full stop. Next para. The learned trial judge further observed that DW1 clearly admitted in his cross-examination that he had no landed or homestead property in the suit plot number 235. Who sub DW2 made a single statement about the position of the defendants in the suit land, and DW3 admitted his inability to say anything about the instant dispute. Push up. Next para. As such, comma, the learned trial judge painstakingly went through, adverted to all the evidence on record and came to the conclusion that as opposed to the plaintiffs who have proved their case by cogent evidence, comma, both oral and documentary, comma, the defendants utterly failed to prove their title in respect of the encroached portion in plot number 235. Push up. Next para. The mention in the commissioner's report of the existence of a, within double inverted, very old mud walled straw thatched structure does not prove automatically that the defendants were in occupation of the property for 3 generations. Full stop. A mud walled straw thatched structure, comma, by its very nature a temporary structure, comma, can at best be as old as the previous monsoons, comma, unless properly maintained. Full stop. The expression within double inverted very old has to be taken in proper context. Full stop. The said expression, comma, if applied to a concrete building, concrete dilapidated building, would definitely lend some permanence to the age of the said building, whereas application of the same phrase to a mud walled and straw thatched structure does not necessarily mean permanence through 3 generations. Full stop. Next para. Hence, comma, without ascertainment of the age of the structure, comma, it cannot be said that the defendants established in any manner their case of possession, possessory title through 3 generations. Full stop. Next para. In fact, comma, the reliance on the BLLRO report is also misplaced. Full stop. The BLLRO, comma, on spot inspection, comma, cannot conceivably ascertain as to how long the persons in occupation of a particular land have been in such possession. Full stop. Such a visual inspection can only reveal the current state of affairs, and the BLLRO is not an astrologer that he would ascertain the length of period for which the possessors have been occupying the land. Which have as such, comma, even minimum reliance cannot be placed on such report. Full stop. Next para. The learned appellate judge has gone through the entire findings of the trial judge and have returned concurrent findings of fact. Full stop. Hence, comma, we do not find any reason to interfere. Full stop. Let alone we do not also find any question of law involved in the appeal, comma, let alone any substantial question of law. Full stop. Accordingly, SAT 534 of 2015, is it SA numbered now?
SAT.
SAT 534 of 2015 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Consequently, comma, can 1 of 2023 is can 1 of 2023 also stands dismissed, no orders to cost. Yes, we have to keep this on record, Mr. This the copy of the commissioner's report handed over in court to be kept on record. What are the প্রথম বলে? Defect is cured বলে দিচ্ছি। Can list আছে? হ্যাঁ, can list আছে। Can list নেই?
37.
What is the number of the can? There is no application. তুমি ওটা কেটে দাও, can one of the বলে দাও connected applications if any stand accordingly dismissed as well. না ওটা করলে কি হবে, কম্পিউটার উপর রেকর্ড ওঠে না, ওটা পেন্ডিং দেখিয়ে যাবে।
It is
Give the number please, just take the number. Can 6960 of 2016 not been renumbered? আচ্ছা ওটা তো ওটা লিখে রাখো তারপরে, তাহলে ওই কানেক্টেড অ্যাপ্লিকেশন থাকলে ওই ক্যান্টে। থ্যাংক ইউ। নেক্সট।
The other application has disposed of on the last one.
Then we are not recording in order. Yes. Similar? Your smile says it's similar.
I beg to appeal for the appellant. The appellant number 1 died in the meantime. There are 5 steps.
So you're saved for the time being. No, if you have a point, even if you have a single point, definitely we'll admit. But anyway, so why didn't you take steps? You are gladly saying he has died. And
No. Steps already can is filed.
That is not appearing. Can is there? Yes, can is there. We'll not go into technical. It will allow. Is it filed in time?
It is within time.
Can আছে।
Can twice filed. One first the appellant number 2 died.
এক কপি রয়েছে তো দেখছি।
Appellant number 2 died long before. In
What is the can number, sir?
Can
There is a substitution application.
Can 1 of 2023.
twice substitution application. This is can 2. Can 1 is in respect to appellant number 2, and can presently in respect to appellant number 1.
No, can 1 is in respect of appellate. Can 1 of 2023 is in respect of appellate number 1.
That is the old. Then the whole number is there in respect of.
No. The previous the other application has been allowed.
No. That is in respect of appellant number 2.
দুটো অ্যাপ্লিকেশন খুলে দিন, একটা পেয়েছি আর একটা সেকেন্ড জাজ কপি আছে কিনা
এটা তো কোনো অ্যাপ্লিক্যান্টই দেখতে পাচ্ছি না।
এটা একটাতে বার করুন আগে, তারপর দেখুন, তারপর সেকেন্ড জাজ কপিটা খুলতে।
একটা দিনও
একটা ক্যান রয়েছে দেখতে পাচ্ছি, ক্যান 1 ওই যে একটাই রয়েছে।
So what is the can number?
That was filed in
Number, sir, number.
that is old numbers. That is not with me presently. That is old number.
Say that number.
Just now I cannot. No, এটা তো
High Court of Judicature. You are arguing in the High Court of Judicature at Calcutta.
এটা এখনকার।
Such a good name.
That is old number is there. Since that is of 2020.
Let us dismiss the appeal for non-prosecution because you are unable to furnish your numbers.
Then my entire BP is with lying with Mr. Tanmay Mukherjee. That's why
What can be done?
Only the presently filed can is with me.
Mr. Tanmay Mukherjee is not releasing the brief.
No. He is in engaged in court number that is that.
He may be engaged in whatever court. He is a free person.
No.
He's also
BP
engaged in this.
BP is with me.
He's also briefed in this matter.
No, he has been briefed.
You're granting a short passover. If he does not come in 20 minutes, we are passing over.
No, then make it not today only.
20 minutes. He has to come and address the court.
20 minutes.
No, sorry, 1 minute. Sorry, this was the last chance to you. First, it was adjourned on your prayer.
In respect of.
No, wait. On 25th of September, none appeared. Then on 11th of December, on your prayer, it was adjourned. On 12th of December 2024, we recorded an order. This is the second consecutive occasion when adjournment is sought. Accordingly, let the matter stand adjourned for the day as a last chance to the appellants to appear and argue the matter. Made clear that in the event the appellants remain absent on the next returnable date when the matter is called on for hearing or pray for an adjournment, ex parte orders may be passed in the absence of the appellants.
Well, then I'm calling him.
We'll dismiss for deferred.
No, I'm calling him.
Let it be in the name of a dead person. You come and prove that it was in the name of a dead person. We'll dismiss for default. And we'll direct that this order be communicated to the trial court immediately.
Yes, that is there.
That is there. What is there? You don't know the number of this substitution application. You were briefed in the matter.
That is with him. Let him come, Lord. Or make it not put him for better shape. Otherwise,
no, we can't because of our own order. This is the last chance given to you.
Yes, I'm big pardon. I'm very much sorry. Make it not too long.
No question of not today. No question of not today. We have permitted you enough. 3 occasions, you are killing time in this manner, and people are saying that matters are pending in the court because courts are inefficient, advocates are inefficient. You are giving a bad name to the bar and the bench.
Then at 4 p.m.
Other advocates are so ready in the matters.
I don't know in what stage of argument they are.
You have to return the fees of the client then if you are not ready.
Okay, make it at 4 p.m. I shall.
4 p.m. very well. Pass over till 4. ঠিক sharp 4 এ রাখবেন না থাকলে যাওয়াটা পাস হবে yes call on the next matter yes Mr. Banerjee
an appeal against order refusing to pass interim order. I'm enjoying an interim order from this honorable court. Now, during pendency of this appeal, the suit has been disposed of. Partly allowed, the prayer for injunction has been granted, mandatory injunction, but the other prayer has not been
disposed of as infraction.
Which has merged into this order.
Learned counsel appealing for the appellant submits that the suit from which the present appeal arises has itself been disposed of in the meantime. Full stop. Since the present order has been, since the present appeal has been preferred in connection with refusal of injunction.
Refusal of injunction.
Since the present appeal has been preferred against the refusal of an injunction in the said suit bearing title suit number 755 of 2017, pending before the 755 of 2017 of the Second Court of Learned Civil Judge Senior Division at Barashat, District North 24 Parganas, which has itself been disposed of by an ex parte judgment and decree dated May 21, 2024, the present appeal has been rendered infructuous. Accordingly, FMA 1678 of 2018 is dismissed as infructuous. Any connected application must be there, or that was disposed of.
Can 3006 must be can 1.
That was kept pending.
Kept pending.
Can 1.
Now can 1.
Acha. Accordingly, can
2018.
Can 2. This is 39. Sorry. Accordingly, can 1 of 2018 within bracket can 3006. Can 1 of 2018 within bracket old number can 3006 of 2018 also stands disposed of. Interim order, if any, stands vacated. Not gone into the merits. No question of recording. Yes. Yes, Mr. Kushal was there.
Thanks, short pass over.
Very well, Mr. Gupta, short pass over. Whenever he comes, yes. Yes, pass over. Okay, again, sir. Yes.
Who is appealing?
অনেক আগে একটা চান্স দিই আমি দেখে নিই একবার জাস্ট লিমিটে বসে নিই তো এখানে তো যা পাচ্ছে তুলে দিচ্ছে। ডিফেক্টটা কি সেটা দেখি, ডিফেক্ট রয়েছে সর্বগুণ সমন্বিত। একটা ডিফেক্ট রিমুভ। সরি, কোড ফি রয়েছে দেখি 20 টাকা। না, বাকি ডিফেক্ট তো সব রিমুভ
করেছিলাম।
কিওর করে দিয়েছে সব, টাকাটা শুনে দিয়েছে রিমুভ। হ্যাঁ, আরো 41 নেওয়া যেতে পারে,
এই জজের নাম নেই সেটাও ঢুকিয়ে দিয়েছে।
সেটাও ঢুকিয়ে দিয়েছে। ইফএমই এত বছর আগেকার পড়ে আছে, এটা 100% ইনফ্রাস্ট্রাকচার হয়ে গেছে। আইডেন্টিটি হবে। হ্যাঁ
হ্যাঁ,
হবে,
এরপর identity
কচি ভূত হয়ে গেছে। তুই দুটো দিন চান্স দিতে পারি। None appears at the time of call, full stop. As a last chance to the appellant to argue the matter, the same is adjourned for the day. এগুলো এমনি ইনফ্রাস্ট্রাকচার হয়ে গেছে, এগুলো না এলে ডিসমিস ফর রিপোর্ট করবে, যদি ফিরে আসে রেস্টোর করে দিয়ে শুনে দেবো। হ্যাঁ, ইঞ্জিনিয়ার সুট ডিসপোজ হয়ে গেছে আগেরটা যেরকম হলো অয়েনমেন্টের। পুরো ঝাড়াই বাছাই কাজ জানেন তো, এই ডিটারমিনেশন জাস্ট ঝাঁট ফাট ঝাঁটা নিয়ে আসে বসবে পরে।
সিঙ্গেল ম্যাচে সেম হয় ফিমেল ম্যাপিং
একই একই।
করতে পারি আমাকে দেখিয়ে নিই
হ্যাঁ বলছি, আর ঝাঁটা ঝাড়ন নিয়ে বসলে সব ঝাড়বো বসে বসে। ডিফেক্ট রিমুভ করেছে, এটাও তো এফএমএল ইনজাংশনই হবে। Adjourn for the day, last chance. ও বাবা, আপনার প্রিয়। হ্যাঁ, কি অবস্থা হচ্ছে, খারাপ হলে খারাপ লাগার কিছু নেই। সেম ইনজাংশন, ইনজাংশন সেম অর্ডার। ডিপার্টমেন্ট থেকে এসে পুরো খেয়াল করেন। সেম ইনজাংশন। অফ টাইম বলছে না, ডিলে কন্ট্রোল হয়ে গেছে, সব ডিফেক্ট রিমুভ করি। ডিফেক্ট রিমুভ করেছে অ্যাপেল করছে। হ্যাঁ, ডিফেক্ট রিমুভ বলে দিয়েছি, ডিলে কন্ট্রোল লিখে দিয়েছি ওই স্ট্যাম্প রিপোর্টে রেখে। হ্যাঁ সেম সেম, বলে ধরে ধরে পাঠিয়েছি। জঞ্জাল বাড়াচ্ছে হাইকোর্টে। কন্ডন হয়ে গেছে। সেম, এটা তো গেছি কেন, স্টে অর্ডার তো তুই তো দেবে না স্টে দেয়। তন্ময় সেম অর্ডারটা কনভে করে দিই, আর এটা লাস্ট চান্স দিচ্ছি তো সব। United রিমান্ডের বিরুদ্ধে রিমান্ড অর্ডারের বিরুদ্ধে প্রথম গ্রাউন্ডটা হচ্ছে ইমপিউন অর্ডার অফ রিমান্ড রিমান্ড যেহেতু মিস অ্যাপিল করেছে ফার্স্ট অ্যাপিলের নেচারের কিন্তু এনিওয়ে সেম অর্ডার তুমি শুভ্রকে বলে দিও কি অর্ডারটা তন্মা একটা কারেক্ট করিয়ে নিয়ে সেই ফরম্যাটে শুভ্র ফেলে দেবে অর্ডারটা নিয়ে নি ষোলো 11/2021 লাস্ট এসছে না সাবস্টিটিউশন এখানে রয়েছে অর্ডার কন্ট্রোল লাইন ছিল কন্ট্রোল লাইন ডিসমিস করেছে হ্যাঁ না করেনি এত বছর ধরে যদি ফেলে রাখে 5 বছর ফেলে রেখেছে মানে তার কোনো কথা ডেড কেস সেম
status quo till disposal of this same already হবে না
সেম এর পরের অর্ডার গুলো আপনি দিলেন সেম বললেন ইয়েস
For the appellant, my lord.
Very good. Good to see a learned advocate for the appellant after a long time. Yes. What is the appeal against?
Appeal against the against the temporary injunction.
First, tell us whether this is a city civil code matter.
Yes, it is a civil court matter.
So,
Caused by the judgment by the planet 12 law.
so we are taking up the order 41 now.
And
What
I have only one point that the impugned order, the order has been passed to stop the business and trade.
Come a bit closer to the microphone. Stop the business, running business.
Stop my running business.
Let us see the impugned order. What is the suit for?
Suit was there for under section 6 of the
Specifically?
specifically
Section 6.
section 6.
Injunction from running business has been. Let us see the order.
Yes.
In these cases, have you annexed the
Order number 50. Lordship.
You have annexed the plaint in the stay application?
Yes, yes.
We'll come to that. Let us see the order first. Yes. Not stop a business. You did not have a business there. It says that you're from restrained also from changing a and from commencing any trade or business of this sort.
Lordship, and that is my fundamental right.
The fundamental right is circumscribed by law.
But Lordship, the order has been passed. The order has been passed against the defendant number 10.
Huh.
He is the subsequent tenant in the property, but he is not the owner.
Defendant number 2 also. This court passed an order, the second paragraph of the order, passed an order against 2. And if 10 is a tenant under 2,
yes,
you also inducted a tenant within 6
Yes,
months
what
from
happened
dispersing.
No, no, no.
You're
no.
very prompt litigant.
No. What happened, my lord? Sheikh Nizamuddin was the previous tenant, was the original tenant. He died in 1970. Thereafter, their grandsons who are living right now, they have surrendered the tenancy. I have annexed the surrender letter also in my CAN application.
Then
now these two plaintiffs, they are claiming to be the grandson of original Sheikh Nizamuddin. They are claiming that we have inherited the tenancy.
So who was
In the meantime,
who surrendered then? You say grandsons surrendered.
His grandsons are surrendered, but they are not in the list of these two.
These people also claim to be grandsons.
Yes.
Maybe, but they
But
don't.
they are not known to the original.
Not required to prove title. If illegally disposed, that is, they have to show disposition, and they have come.
No,
with
I have seen the. Kindly Lordship, kindly come to page 13 of the CAN application. there is a surrender of tenancy.
Followed by delivery of possession.
Yes, followed by delivery of possession, and they took all the articles
How
from that
section
short road.
6 will come into play?
I am not the plaintiff in this one. I am the defendant number 7, 8, 9.
No,
and
this
10
is
and
surrender
11.
of tenancy, page 13.
Yes.
That is what a document you are reading. Where is the plaint?
Plaint is on page number 23.
23. You are relying on this surrender document.
I am relying upon this surrender document.
They say that you have illegally dispossessed. They were in possession, you have illegally dispossessed.
Yes. And they have filed a suit for recovery of possession.
That is under section 6, you are right.
And the plaint is Mohammed Alam and Mohammed Khalid.
You are the landlord practically.
I am the
owner
landlord, and originally defendant number 10 and 11, they are the subsequent tenant. I am representing all these 5.
So who obtained the injunction?
Obtained the
Plaintiff, sorry.
plaintiffs obtained the
Against
injunction.
against whom? You are defendant number?
I am defendant number 7, 8, 9, and 10 and 11. But the order was passed in respect of the defendant number 10 only. I am giving taxes to the Kolkata Corporation Municipal.
He filed a vacating application. Court says in the second last paragraph of the first page of the order that hearing both sides considered view that the order passed by this court cannot be altered. There was an ad interim order.
There was an identity order.
You had not challenged that.
No, I have not challenged that.
You
I
waited
have
for 2 months.
challenged the trial court.
Final order you have challenged. You waited for 2 months for that.
I have filed my
It is
detailed
only an
objection.
extension order. You have not challenged the parent order.
No. I have challenged the order also. Kindly see. Objection is in running page 124.
All right.
So if we produce the last 2 orders, how you are agreed?
The business has been stopped by my client.
No, creating any third party interest and nature and
Yes.
character.
If there is any order of status quo, I would not have any problem. But the order was that to stop my business and
Or
that is
commencing
my,
any business.
commencing any business.
You
This
cannot
part, I
commence
have
it.
only this part of.
You should have pointed out that you have not commenced. You have already commenced business.
Yes, I
No,
have.
how could you commence the business? In fact, because that order was prevailing from 17th of June 2022.
No, actually, the business is not running out.
When did you start the business? Where is the proof of that? Nothing is shown by you.
No, Lordship. Lordship, kindly keep page 18. It is Annex 3, P3. I am giving text to the Kolkata Municipal Corporation. Page number 18, 19, and 20. I have annexed the documents.
When was the suit filed?
Suit was filed on 2022.
This is contemporaneous. After the suit was filed, you obtained this license.
No, I have previous.
Where is the document to show that you were running from previously? You dispossess somebody and commence the business there.
15 March was the surrender of tenancy.
15 March was the surrender of tenancy.
The suit was filed on 22nd February 2023.
23.
And when you started your business?
Thereafter, I have obtained the.
Part with possession nature character change for business. You will record that in your order. Have you filed?
On the particular date when the business was started, I have to take instruction.
No, even if you don't prove that, we are prima facie satisfied that you are running a business would not hamper his interest in the suit.
Yes, Lordship. That is my view.
Have you got any stay also?
Yes, I have a stay application.
The appeal will be heard on the limited question as to whether the learned trial judge was justified in restraining the defendant's appellants, by the impugned order, from commencing any business over the suit property till disposal of the suit, comma, keeping in view the nature of the suit which has been filed under section 6 of the Specific Relief Act, full stop. However, comma, we are of the prima facie opinion that the other portion of the injunction restraining the defendants from creating any third party interest over the property and or changing the nature and character of the suit property was in consonance with law. Full stop. Next para. Accordingly, the appeal shall be heard on the above limited aspect of the matter. Full stop. Now, stay application. If you stay, the grant stay, that means injunction order. I mean, then it will be allowing the appeal.
Business portion time you can stay.
Business portion very the business profile. Can 1 of 2023 is now taken up for hearing? Full stop. There shall be stay of operation of the impugned order dated April 20, 2023 to the limited extent that the same restrains the appellants from commencing any business over the suit property till the disposal of the suit. Full stop. Such injunction, such stay shall operate till disposal of the present application. Full stop. It is, comma, however, comma, made clear that the other part of the impugned order, whereby the appellants have been restrained from creating any third party interest over the suit property or to change the nature and character of the suit property, is not being stayed or interfered with at this juncture. Full stop. The appellant shall serve a copy of the appellants shall serve copies of the present application on the plaintiff stroke respondent numbers 1 and 2, indicating that the application shall be listed for hearing on January 8, 2025, when the appellant shall file an affidavit of service. Well argued. Yes. Password. Charte. We have a substitution application, the number of which your learned advocate does not know because the file is with you. That was the specific submission twice or thrice. Because the application is with you, he does not know the number, and you're engaged in some other court, probably with that application in your under your armpits. And
what I have.
Why do you retain applications without giving the numbers even to your juniors?
No, Milord. What Milord, the brief has been handed over that where Milord I find Milord only one can 1 of 2022. I must be candid, Milord.
Can 1 of 2022?
2023. Can 1 of 2023?
We also find that only in our record.
Yes, in respect of
One.
death of appellant number 1.
Yes.
But I find, Milord, by the order dated 4th of February 2020, this honorable court records that appellant number 2 has also died. Milord, that can application. Milord,
we'll record the abatement simpliciter.
But Mr. Jana's clerk today has not come, Milord. I must be candid before your lordship. He is having the Milord that brief entirety. The copy which has handed over to me.
Second. So why did Mr. Jana say that it's with you?
Milord, it's
you don't look like the clerk of Mr. Jana. You look different. No, the appeal has abated then. Who has died? Appellant number? Which order records?
Milord, 4th of February 2020.
And Mr. Mukherjee, by the order dated the 12th of December, we had recorded second consecutive occasion, adjournment sought, last chance. If you don't appear or seek an adjournment, ex parte orders.
What I thought, Milord, today morning, I informed Mr. Jana how this matter is appearing as order 41 because it can't be placed before the order 41 court unless, Milord, these substitution are being allowed.
No, this has been placed probably for recording the abatement. You had submitted, Mr. Jana had submitted that the appellant number 2 had expired.
And probably, Milord, I do not know, Mr. Jana is also not, Milord, sure whether the application is already filed or not because Mr. Jana's clerk today has not come due to his illness. Give me, Milord, one opportunity. I shall apprise before your lordship. Otherwise, I am ready with the merits of the matter also.
What merits? If appellant number 2 has expired, that was recorded in 2020. We are in 2024.
We cannot, Milord. Both the appellant number 1 and 2, both died in respect of 1. Milord, the application is with your lordship's brief. I do not know, Milord, what is in respect of appellant number 2. Give me last opportunity, Milord.
When?
Milord,
but we have given a last chance. Give a synonym of last chance with a superlative because last chance has been exhausted today.
Sit on Thursday, Milord. I shall apprise before.
Give us a superlative of last chance. Last test or last star. Last star is better because last test can come after that. Then
Lord, it's my mistake. I have not seen your lordship's last order. Otherwise, my lord, I should have, my lord, come prepared. But I really, I was under the
What
impression.
prepared? How could you prepare yourself? Mr. Jana does not give the application to you.
That's why, my lord, I thought that this application is pending. It's wrongly appearing before your lordship's court. That is my impression. But I should have, my lord, prepared with the matter, my lord.
Learned counsel for the appellant submits that this is not a change brief even. Mr. Jana was there. So in 2020, you submitted, Mr. Jana, that appellant number 2 has died. What happened thereafter?
That's why it just out. That's why.
So it has been tested out. When was it tested out? Learned counsel appearing for the appellant submits that the brief was missing in the office of the learned advocate on record and has been recently traced out. First of it appears that there is that both the appellants have died. First of can 1 of 2023 is for the substitution of the heirs of appellant number 1. First of however, comma, no application for substitution of the heirs of appellant number 2 can be traced out. First of next para, in order to enable the appellants to furnish the particulars of all connected applications, comma, the matter is adjourned till December 19, 2024, when it will be listed under the same heading.
It's my mistake, Lord.
December 19, at least furnish the particulars so that we can bring the application. Thank you. After password, so question 9 not today. Okay, no question of running. We granted time for you. We saw you. We told Mr. Gupta that Mr. Ghoshal was there in the morning. That's why we passed it over. But move the matter. You're feeling
but this happened.
very.
Any date that suits your lordship, I'm otherwise I won't have it.
In view of the inconvenience of counsel for the appellant, let the matter stand over for the day.
Nowadays I cannot run so much like that.
No question of running, Mr. Ghoshal. Why should you run? We gave you time to come. I mean, we would not have called unless you came.
I must show honor your lordship.
You have done that. Yes.
Number 51.
Yes. Oh, that nothing in that matter matter.
My lord, your lordship's observations was heard my client, but I was so now to say in the house, in my house, then why you have filed this case? When the judges are saying
no, tell him judge does not understand. I have filed properly understanding the law, but the judges don't understand. What can we do? Whatever we used to say.
I said that was a primary.
You have so much experience in saying these things. Judge doesn't understand the law.
As she heard, I said that is
no, that you can because there's no camera in your house when you advise your. But we have a camera. That's our disadvantage. You say whatever against the judge outside.
The privilege communication.
No, she is in the court.
But
she heard.
Yes, what is the matter?
What happened, my lord?
Is she in court today?
Huh? She is in court today.
Very well. Let us.
My lord,
so we'll have to give a bit more hearing to you.
My lord, appellant here, my lord, Bodhanath Saha. Bodhanath Saha and his wife, 2 persons, they were inducted in 1998 by virtue of a, my lord, deed, agreement of tenancy agreement.
Please tell us what is the suit for eviction suit?
Yes.
Both courts decreed against you under 97 Act.
Yes.
All right. Yes.
Now,
what was the ground on which this decreed?
Decreed, my lord, the plaint case was that they we made a default in paying the rent, and we are misusing the subject premises, and my lord, they need reasonable requirement is necessary.
Default MOP and reasonable requirement.
Default misuse of the subject premises, my lord, 2 rooms, residential rooms.
Misuse means?
Misuse, my lord,
nuisance or
no,
or addition alteration.
Addition alteration, not. We are keeping laborers. We are doing business.
Used for some other purpose than for which it was granted.
So, my lord, their initial, my lord, was 3. Nuisance and disturbance and putting, my lord, outside.
Nuisance was also there.
Yes, everything was there.
Default? No, then it becomes 4. default, nuisance,
putting other persons.
other
for
use,
and reasonable requirement.
reasonable request. So 4. It was decreed on which ground?
Reasonable requirement.
Only.
Yes.
So we forget the others.
Kindly, my lord.
Reasonable requirement, what is your substantial question of?
My lord, they do not, my lord, the plaintiff, my lord, who filed the case after few months, when he died. Now, see, his case was that he has got no accommodation, and his daughter is an educated person. She would start business, so he requires the building premises. Now, the gentleman who filed the case, one Raichodhri, he died. But he's a Raichodhri, he's a rich man. He has got other accommodation.
All Raichodhris are rich.
No, but in the instant.
You are lucky, Mr. SP Raichodhri is no longer there. Mr. Bhattacharya, what would happen? He would appoint himself amicus curiae.
Anyhow,
it would be embellished when it went to Mr. Raichodhri.
Now,
and Mr. Mustafa would be in some.
Now, I am presently I am aged about 75-6 years, and my wife is also almost similar age.
But that is not a consideration.
Now, my lord, kindly look at page 6 of the order of the Honorable Trial Court. The issues from the rival contentions.
Give us a second.
Yes.
After yes.
From the rival contentions?
From the rival contentions of the respective parties, following issues have been framed for consideration and determination.
Issue 4 is only German, 4 and 5.
Plaintiff reasonably required is the eviction
default of this. It was also decreed on the ground of default.
Yes. Now, kindly, my lord, see.
Sir, just a minute. Accordingly, the plaintiffs are entitled to get the degree. Page number 54 of eviction from the suit property on the above ground and also on the ground of being defaulted in payment of rent.
Yeah. So default is not correct. We paid, my lord, up to date rent.
You said it was decreed only on the ground of reasonable requirement?
No, that is, my lord, that's why I'm placing. Kindly look at page 31.
No. First, let us get the contours of the case. It was decreed on the ground of default as well as reasonable requirement.
Default, my lord, the default is not correct because as per court's order.
Correct ground, forget about that. Learned trial court decreed the suit on the ground of default and reasonable requirement.
That is wrong because we paid up.
Obviously wrong according to you because you are there.
Now kindly see.
No, it is wrong that the trial court decreed the suit on the ground of default also. Is this statement wrong? True or false? Tell us true or false. The suit was decreed on the ground of reasonable requirement and default. True or false? The statement is true or false?
That is correct. That is a statement. That is on record. Yes.
So we'll put it like objective type now.
Yes.
OMR sheets.
Now, page 31.
Yes.
Whether the guilty of change of mode of user of the suit property without the consent of the plaintiff, with the guilty of causing nuisance.
So why are you showing this? Has it been It
is
in the appellate court judgment?
Nuisance.
No, it is.
But this can also tantamount to a nuisance.
No, it is in our favor. These issues are in our favor.
Why are you showing that? Nuisance is in your favor. You are not required to.
Now, page 38. Page 38. Does the plaintiff reasonably require the suit premises for their own use and accommodation? And does the plaintiff has any suitable alternative accommodation? This is against, my lord, these issues.
What is your substantial question, Mr. Ghulam?
My lord, substantial question, my lord. The gentleman who filed the
7-3, your defense was struck out.
Struck out.
So decreed on the ground of default as well as reasonable.
Now
you have to satisfy us on both grounds to get an
default, my lord, there was no default as per court's order. That is also there.
7-3 that was affirmed by the appellate court.
That affirmed, that is wrong. We paid up to date.
That's a factual argument you are making. We cannot reopen the concurrent finding. So if you fail on the ground of default, then no need of admission of the appeal. Even if they get decree on one ground, that will sustain.
Kindly see the reasonable requirement.
Yes.
Page 38.
38, yes.
I take the opportunity to discuss both the issues together as they are intrinsically related to each other. According to the plaintiff case, the plaintiff reasonably requests the suit premises for his own use and occupation, for the use and occupation of his family members, as present accommodation available to the plaintiff insufficient to meet their need. The plaintiff has specified that he has no alternative accommodation available in the city of Kolkata. My lord, there are, this is a three-storied building, three, my lord, floors. In each floor, there are 4 rooms. In the first floor, we are given, as per my lord tenancy agreement, we are given 2 rooms only.
Three-storied building.
2
stories building.
2-storied building.
So 2 each floor means there are total 4 rooms.
No. In ground floor 4, in first floor 4.
4 or 2?
4.
4 on each floor.
4 on each floor. 4 on each floor. Ground floor 4.
Ground first and second.
Second.
There are 3 floors.
3 floors.
4 into 3, 12. Total 12 rooms.
In first floor, we were, my lord, inducted as tenant in respect of only 2 rooms.
Very well, yes.
So, my lord, the story of reasonable requirement was, my lord, with Malafide just to evict us. It has been, para 39 page, my lord. It has been further clarified the plaintiff that he needs 1 bedroom for himself, his wife, 1 bedroom for his daughter, 1 dining room.
Plaintiff is residing in a rented house.
That is their assertion, but this is not correct. That we have repeatedly, my lord, said. Drawing room, kitchen, 1 Thakurghar and bath and privy. But we are only, my lord, in 2 rooms. Total 12 rooms.
Plaintiff died during pendency, wife and daughter now.
Plaintiff died, my lord, on 20. He died on, my lord, June 13, 2022. Now, it is the specific version of the plaintiff that the plaintiff does not have any occupation in the suit premises and he is presently residing in a rented house and such place, Patipukur, under the landlord Partho Sarkar Chaudhary. And as such, he is dire need of his own accommodation in the suit property as he has no other suitable ordinary accommodation in the city of Kolkata and he is finding difficult to stay accommodation. He himself being a cancer patient and senior citizen, and his wife being homemaker and
Just a minute.
Survey.
Payment cannot dictate as to how they will.
যদি দুজন হয় শুধু ভার নেই আর ধরুন অলরেডি বাড়িতে করতে অন্য রুমগুলো টেনেন্টের তো নয় অন্য রুম অত 12টা রুম নিয়ে দুইজন মিলে কি করবে তাহলে পার্সিয়াল এভিকশন দরকার এটা তো স্যাটিসফাই হয়ে যাচ্ছে বাকি কি কোয়ান্টিটি ডিফারেন্স
has been clarified. No. It is a specific version of the plaintiff that such and such. Then, however, it is necessary to mention here that in this context, that during the pendency of the instant suit, the plaintiff or them died and he has been substituted by his legal heirs, his wife and daughter. The learned advocate for the plaintiff categorically submitted before this plaintiff, being the landlord, has absolute prerogative to decide which property he wants to and for what purpose he wants to same, provided he has bona fide need for the same. Kindly see, bona fide need. See, he has no bona fide need because other.
Carry on.
The defendant in his written statement has challenged the plea of reasonable requirement as made by the plaintiff by specifically stating that the requirement of the plaintiff is malicious and not bona fide, as the plaintiff has inducted several tenants in the suit premises and he has the habit of taking salami premium for them. As per agreement, my lord, he took 80,000 from me also at the time of induction. The defendant has further denied the fact that the plaintiff is residing at a rented accommodation at premises number such and such, wherein he is facing extreme inconvenience by stating that the plaintiff is having sufficient accommodation therein and the same is his own property. The defendant has also denied and disputed the need of the plaintiff as enumerated in the plaint by saying that the need of the plaintiff is exorbitant and fanciful. The learned advocate for the defendant boastfully argued that no commission work has been held over the suit premises at the instance of the plaintiff, so availability of rooms therein. In the next line, argument, the learned advocate for defendant stated that the plaintiff has not disclosed about his present occupation in the suit premises for which he is guilty of suppression of material fact and he is not entitled to get any relief under present suit. It was also argued that the plaintiff has not also conducted local inspection over the premises at
quantification of
238 Bipin Bihari Ganguly and Patipukur, which is not the rented accommodation. The plaintiff but is own property, and accordingly no decree on the ground of reasonable decree can be passed in favor of the plaintiff. And then at the very outset, it is important to note that in this context, the plaintiff has specifically mentioned that apart from the suit premises, he has no other suitable alternative accommodation elsewhere in the city of Kolkata, as the property where he is staying at present, 230 Pinberry Ganguly Street, rented accommodation. On the other hand, it is the specific claim of the defendant. Plaintiff has sufficient alternative accommodation, 230 Pinberry Ganguly Patipukur, which is his own property and not rented accommodation, and also the suit premises. However, with due respect to the submission made by the learned advocate for the defendant regarding the availability of sufficient accommodation in the suit, I find the such submission absolutely beyond the pleadings of the defendant, as it is nowhere stated in the written statement the plaintiff has any possession in the suit building. Needless to mention that the authorities relies upon the learned advocate defendant in this regard as referred above, are unanimous on the point that in order to establish the ground of reasonable requirement by the landlord, the court must satisfy itself such requirement is bona fide, and the landlord has made all disclosures about the availability of other accommodation under his occupation to prove the accommodation of the landlord is insufficient to meet his need. As such, if a landlord guilty of the suppression of material facts regarding his accommodation, he is not entitled to get any relief from the court under this ground. Now, with this, let us come to the pleadings of the plaintiff in this regard and the relevant evidence recorded to that effect to ascertain whether the plaintiff is actually guilty of suppression of material facts as claimed from the side of the defendant, as the plaintiff held local inspection over the present accommodation at Bipin Bihari at the suit premises in order to bring the actual picture of those premises to show the availability of the rooms therein. In the present case, the plaintiff has categorically narrated his need as well as the need of the family members who reside in a tenanted accommodation at 238 Bipin Bihari Ganguly, in spite of having his own property. The suit premises, as the suit building, which comprises of numerous rooms, is under the occupation of several tenants, including the present defendant. Though the defendant has stated in written statement that the present accommodation of plaintiff at such and such is own property and not rented accommodation, but the plaintiff, here there are certain against me, has more than sufficient, but the defendant, while deposing before this court, DW1, candidly admitted during his cross-examination that it is fact that the plaintiff reside in Patipukur Lake Town in a rented accommodation. It is also come from a cross-examination of the plaintiff, while disposed PW1 on March 17, 2021. The present, he pays rupees 5,000 per month and pays rent to the Partho Chaudhary, such and such. Therefore, the above statements made by DW1 during cross-examination clearly destroys the version of the
উল্টে দিল গরমে দিল, কিন্তু বোঝার অন্য কিছু ইন্ডিপেন্ডেন্ট এভিডেন্স প্রুফ করবে। কত রুম আছে জানেন? দেখেন
it is settled. Plaintiff landlord has to fulfill two ingredients. Requirement must be reasonable and bona fide. No other suitable accommodation is available to the plaintiff landlord. While adjudicating, this I am giving trace because there are 12 rooms. In the first floor, I was given only 2 rooms. I paid regular rent. And till the disposal of the suit, I deposited the entire amount. Reasonable and bona fide. No other suitable accommodation is available to the plaintiff landlord. While adjudicating upon the bona fide need for reasonable requirement, it would be pertinent to mention that the word requirement coupled with word reasonable mean that it is something more than the desire, which may not be compelling or absolute or dire necessity. It is honest but not fanciful or reasonable. At the same time, it is equally true that the word requirement is not to be rigidly interpreted so as to make it impossible for the landlord to obtain a decree of eviction under this clause. The relevant provision insist on reasonable requirement and genuine requirement or bona fide requirements. Now the time has come to scan the evidence on record to see as to how far the plaintiff has been able to establish his case of reasonable requirement to the satisfaction of this court in order to entitle himself to get a decree of eviction, as it is the bounden duty of the plaintiff.
We'll admit the appeal. Ask. Reasonable requirement করছে। আর first appellate court দিয়েছে ওটা reverse করেছে। The present appeal arises against the present second appeal arises against a judgment of affirmance. Full stop. Next para. An eviction suit was filed under against the appellant under the West Bengal Premises Tenancy Act 1997. Full stop. The trial court decreed the suit against the defendant stroke appellant on the grounds of reasonable requirement as well as default in payment of rent. Full stop. However, the appellate court, the first appellate court reversed the findings on the ground of default in payment of rent, semicolon. However, in the same breath, the ground of reasonable requirement was sustained and the eviction decree was affirmed on such ground alone. Full stop. Next para. However, on a careful perusal, we are of the opinion that the present second appeal ought to be heard on the following substantial questions of law, niche Roman 1, whether the learned appellate court as well as the learned trial judge were justified in granting a decree for eviction on the ground of reasonable requirement without quantifying the exact number of rooms required by the surviving plaintiffs stroke respondents. Roman 2, whether, in the absence of any evidence being adduced on the part of the plaintiff landlord regarding the measurement, nature and extent of user of the present rooms at the suit building, the courts below committed a substantial error of law in granting an eviction decree on the ground of reasonable requirement. 3, whether the এই দুটি থাক ঠিক না ব্যাস next para. The what is the stay application? What is the number?
Can one, because my lord, execution, they have filed an execution case.
Can 1 of 22, there is no caveat.
No.
Can 1 of 2024 is now taken up for hearing. Full stop. In view of the second appeal being admitted previously, we are of the opinion that a strong prima facie case for hearing the appeal on merits has been made out. Full stop. Accordingly, there shall be a stay of all further proceedings in execution. It's mentioned as title execution case before the small case.
Ejectment execution 126 of 2010.
All further, there shall be stay of all further proceedings in ejectment execution case, EEC capital. Ejectment execution case number 593 of 2023 pending before the third bench, Presidency Small Causes Court at Calcutta till disposal of the application. Full stop. The appellant stroke petitioner shall serve copies of the application on the plaintiff's respondent indicating that the application shall be listed for hearing on January 7, 2025, when the appellant stroke petitioner shall file an affidavit of service to that effect. Full stop. Next para, it is made clear that the question of imposition of occupation charges as a condition for making the stay absolute shall be is kept open for being heard at the time of final disposal of the application.
Ejectment, they have given the ejectment execution number 126 of 2023.
But in your prayer portion,
in your application,
or it is 1 second. Which was a চিঠি দিয়েছে ওটা হোটেল বাজারের চিঠি
execution case arising out of ejectment suit number.
না স্পেসিফিক দিয়েছে প্রেয়ার করে
Prayer তো দিয়েছে. You
Yes.
have mentioned the
Their learned advocate, my lord, this is the letter they have given, execution 126. Din ekটু, my lord.
What can we do? You have to tell us. We'll decide. What is
Because
the number of
they-
the execution case also?
they-
We did the
that's what-
rest for you.
That
We'll
was-
also have to decide what is the number of the execution case.
No, my lord. All right, well, this, let it.
Let it be. And if it's a different execution case number, you will be evicted.
So kindly give this number also.
Mr. Bhattacharya, you save us.
It was filed by. I am extremely grateful, my lord.
Thank you very much, Mr.
Lord,
Yes.
before my lord,
Because this type of cases, my lord, rarely I do.
No. You did it well.
Lord,
It's not your fault that your client. Anyway. Yes, Mr. Bhattacharya, you want to say something?
Extremely grateful, my lord.
32.
Sir.
Mr. Chakraborty,
Lord, item 50,
change the expression. Yes.
58 and 59. 58, I am for the appellant. 59, I am for the respondent. But tomorrow and day after tomorrow, I have some difficulty.
Keep somebody to ask for time so that we can refuse and dismiss your appeal.
Only on Thursday. Only on Thursday.
We'll allow your appeal and dismiss. No, this is not a commitment.
On Thursday.
Can he disappear? Can his line code number?
Can is disappeared or never appeared? It was appearing in our list.
Yeah, but the file is not here. Can is appear?
It is missing.
Missing.
When someone will pray for.
Which code did you file it for? In a slip of paper, write it, give the item number and give to my officer. Otherwise, it will never come. We are not supposed to know which court it is lying in. We have to send a requisition. Only we send a requisition to the department unless the specific court number is mentioned in the mentioning slip. Write it down and give it to my officer and she'll do it. Yes.
Someone will pray for an accommodation, Lord. 50. 59. Don't
50.
forget the-
Ask somebody to ask for a